reflected in February 2025 meeting minutes are incorporated into the record for this hearing. One change that we've had since then is that the division has identified a new witness, Beth Foley, to testify. So I want to give the commissioners another opportunity to update any conflict disclosures they have for Ms. Foley's testimony or for any other reason. Seeing none, we will proceed. Parties ready for you to enter your appearances for petitioner Edge.
Good morning, Michael Cross on behalf of Petitioner Edge Environmental LLC, and I believe Brian Whitcamp, the owner of Edge Environmental, is present via Zoom. He had to be out of state for a parents' weekend for his daughter.
Thank you, Mr. Cross. Make sure your microphone's on. Hear you here and online.
It is now on. Should I do that again?
Okay, I think we all heard you.
Okay.
All right, and for the division?
Morning, Commissioners. I'm Second Assistant Attorney General David Beckstrom, joined by Emily Splittick, Senior Assistant Attorney General. We represent the Air Pollution Control Division. With us at council table is our division representative, Curtis Burns. Thank you.
Okay. The commission proceeds today under sections 24-4-105 and 25-7-511 of the Colorado Revised Statutes and the commission's procedural rules for adjudications under Roman numeral 6. We will hear the parties' presentation of argument and evidence. Based on the record, the commission will render a final decision on whether Edge has violated one or more of the asbestos control regulations identified in compliance determinations letters. The purpose for this hearing is for the parties to present evidence and arguments, and then for the commission to determine, based on the parties' presentations, whether the division has proven that Edge violated the asbestos control regulations under Regulation 8, Part B, Section 3 of the Colorado Code of Regulations. No public comment will be presented or allowed. Written public comment was allowed through February 4th, 2025, and none was received. Before we hear the parties' opening statements, we will have some preliminary business. The division filed a notice on October 9th to substitute a witness and submitted written testimony for Beth Foley. This is under Division Exhibit 33. Will the parties state on the record their stipulation as to witness Foley and Exhibit 33? All of the divisions are first.
Thank you, hearing officer. Due to the unavailability of Ms. Laura Maniac, the division has moved to enter written testimony. Division Exhibit 33 of Beth Foley, who is with us today, will be available for cross-examination. In addition, we had some additional parts of that stipulation as we understood them to admit in full the deposition transcript of Laura Maniac, which is at Joint Exhibit 40. It had previously been admitted only in part as designated, and we'd like to designate the entire deposition given her unavailability. Additionally, we would like to withdraw as part of that stipulation Division Exhibits 6 and 25, which are the written testimony of Ms. Laura Maniac, and again, substituting Ms. Foley's written testimony in that stead.
Mr. Cross.
Under the circumstances, Edge has no objection to that, so stipulates.
We will go ahead and if what has not been admitted thus far, which is the complete deposition under Joint 44, Exhibit 33.
Commissioner Gonzalez, if I may, I'd just like to alert the commission that those have been entered into the Google Drive for this proceeding, so that should all be updated with the current.
Are those part of our hearing notebooks today as well?
No, we were not able to get those into the hearing notebooks, but they're digital versions through that Google link.
That sounds great. So for the commissioners, those won't be available in front of us, but we can access them. Thank you.
So just as a clarification, the unredacted or the new version of was it 40 or 44? May not yet be available. We'll make sure that's in there just as soon as possible.
Okay.
Just to clarify, it is in the Google folder. It is, the full version is not in your hearing binders. We didn't think you wanted a full printed version and we didn't have time to do that in the hearing binders.
So there just might be a little bit of version control that we need to clear up versus what they have in front of them today.
Okay. Division submitted the Exhibit 14, the proposed early settlement agreement dated November 30th, 2022. Edge objected based on relevance in CRE 408. In February, I sustained that objection and found that it was not relevant to contain compromise negotiations and ruled that it may not be admitted to prove the validity or amount of the claim for impeachment, subject to CRE 4B if offered for a permissible purpose. As reflected in the amended exhibit list filed on October 9th, the parties stipulated to a redacted version of Division Exhibit 14. Are the parties satisfied with this redacted version?
Yes, Edge is satisfied.
As is the division. Thank you.
Then we'll go ahead and admit that redacted version of Exhibit 14. The parties have stipulated as to certain facts which were filed with the commission on January 15th, 2025 and made available in advance for the commissioner's review. Parties have stipulated to exhibits and are admitted to the exhibits that are admitted into evidence as joint exhibits 1 through 45. A number of divisions exhibits have also been entered into evidence. The parties have been encouraged to offer witness testimony in writing for commission's review in advance. That has been done. The parties have chosen to present testimony both in writing and in person. The party's order of proof will be a rough guide to serve our process today, our procedure today. The parties will each have 2 hours and 55 minutes to offer their evidence and arguments. It's up to the parties to manage this time. We want to keep to a minimum any reading of deposition transcripts to the extent that we're just going to be reading them into the record. We have that in front of us, but for the sake of argument or to make your case, that's going to be up to you on how you present that. Highlights are welcome. This is in the interest of time and given the volume of evidence, also with our time constraints today that have been submitted in advance in writing, that's appreciated. Each witness is subject to direct oral examination by the party who called the witness, then cross-examination, then if necessary, any redirect. Commissioners will be allowed to ask follow-up questions before I excuse the witness. To my fellow commissioners, please recall that this is the division's burden of proof on the charges. And should you choose to ask any questions of any witness, please focus those questions on what is necessary for you to reach a decision in this matter. As I mentioned, I've said it before, I'll say it a couple more times as we get started. We're very ambitious in our timetable today as we work through it. We will have a lunch break around noon for 30 minutes. And commissioners and parties may request breaks when needed, but I'll keep an eye on the clock and make sure that if we have a good breaking point, that everyone will be comfortable with those breaks and keep everyone try and keep everyone well attentive during this process. But if you need something, please let me know. As the parties are aware, the goal is to complete the parties' presentations by 4 p.m. today so the commission may begin its deliberations. As noted, it's up to the parties to manage their time and make adjustments accordingly. Following closing arguments, I will close the record and the commission will begin deliberations. You may ask commission counsel for an executive session if needed to consult on a legal issue. As I mentioned, ambitious timeline. I believe we have a hard stop. At least one commissioner has a hard stop today at 5 p.m. I'm curious if that still holds. Still holds. Okay, great. Then we're going to be out of here by 5 p.m. today. If necessary, we will continue into tomorrow morning. But again, the tight schedule all the way through the day and for this entire hearing. Does any party have any issue to raise before we get started? Division?
Just one update to the order approved for your awareness. We had previously considered calling Mr. Michael Rodriguez. We have released him from the subpoena and he will not be appearing today. We'll be relying on his written testimony.
Edge?
No updates.
Okay. In that case, we will get started and we will start with opening statements. Division will go first.
Good morning, commissioners. The commission has regulated asbestos handling in Colorado for 40 years. Over the last 22 of those years, the commission has repeatedly found that exposure to asbestos creates a public health hazard. It has issued that finding and statement of basis of purpose multiple times. Based on that finding and the hazards that asbestos exposure poses to the public and the environment, the commission has adopted, revised, amended Regulation 8, Part B countless times. Those rules are necessary to protect public health. Adherence to them is critical for the protection of public health, the environment, and worker safety in this state. Those rules apply statewide to everywhere asbestos is handled. EDGE violated those rules. It violated those rules in 7 different ways. It threatened public health in doing so. And at the end of the hearing, we'll ask that you hold them accountable. Sorry. Thank you. As mentioned earlier, I'm David Beckstrom. Together with Emily Splittick, we represent the Indoor Environment Program of the Air Pollution Control Division. That team is charged with the implementation and enforcement of the rules this commission has adopted to protect public health in Regulation 8, Part B. Today, you'll hear from 4 members of that team who are sitting here today. First, you'll hear from Jeff Wolf, APCD inspector who inspected the Eagle Creek apartment complex in Leadville, Colorado. Next, you'll hear from Severn McGowan, APCD inspector who inspected the Pine Creek apartment complex in Denver, Colorado. Then you'll hear from the division's expert, Curtis Burns. You'll hear from the division expert, Curtis Burns. With almost 35 years of experience in asbestos regulation, he will provide his expertise and opinion on how the rules of this commission are implemented, how the EDGE's actions violated those, and answer any questions you might have. Finally, Ms. Beth Foley, the APCD enforcement coordinator for the Indoor Environment Program, has provided written testimony, will be available for cross-examination on matters related to the enforcement process of the Indoor Environment Program and the penalty calculation considerations in this matter. All 4 of those witnesses are here today because it is critical that you hear from them. They're providing live testimony. They'll be subject to cross-examination by EDGE and EDGE's counsel, and they'll be available to answer your questions. This is incredibly important because the division carries the burden of proof in this matter. You, the commission, are the fact finders. It's our job to convince you that it is more likely than not that the allegations against EDGE in this case happened, that EDGE violated Regulation 8 Part B in 7 distinct ways at 2 different projects in very different parts of the state. The standard here is a preponderance of the evidence, as Commissioner Gonzalez mentioned earlier. It is not a burden beyond a reasonable doubt, as would be the case in a criminal case. It is preponderance of the evidence, meaning more likely than not. The division's evidence in this case will show it is far more likely than not that EDGE committed those violations. Let's start with first the violations alleged at the Eagle's Nest apartment in Leadville, Colorado. This was a transite removal project. Transite is a type of asbestos-containing cementitious siding material common in construction of a certain age. EDGE had been asked to come remove transite around balconies on certain buildings of this large, sprawling complex that was occupied at the time of EDGE's work in the summer of July 2022. Transite is a really interesting material because it contains asbestos. In its functional state, you will hear Mr. Curtis Burns, in its functional state, it is non-friable. However, when it is mishandled, it can become friable, it can release asbestos fibers, and it can pose a public health. For that reason, it is incredibly important that it is handled properly during removal, and when it isn't handled properly, the project manager shifts gears and treats it as abatement. Jeffrey Wolf will testify that in his inspection on July 28, 2022, he conducted a routine inspection of that apartment complex. When he arrived, he found 2 EDGE workers, one up on a ladder near the 3rd floor, removing transite, breaking it off the side of the wall, dropping it 20 feet to the ground where it shattered. Some of that landed on the poly drop cloth below, some of it landed on the soil. Most of it was broken into smaller pieces. There was one worker below that was picking up those pieces and bagging them. Mr. Rodriguez was one of EDGE's workers those days. He was the supervisor on site for EDGE. And per his testimony, he was the one on the ground picking up the pieces. His written testimony is in the record, and we'll highlight pieces of that today. Mr. Wolf will also testify that when he arrived and during his inspection, he never saw the airless sprayer that EDGE claimed it had on site, necessary to wet the asbestos-containing material during removal to ensure that those fibers don't become airborne, causing a further public health damage. Finally, he took photos, in addition to his personal viewings, he took photos and video. He touched the siding the edge had removed and dropped to the ground where it shattered with his hands. And based on that, he determined that the siding material removed and dropped to the ground had been rendered friable. He will testify that he has conducted over 1,000 inspections of asbestos abatement projects in the state, and that this project at Eagles Nest Apartment is one of the worst he has ever seen. Based on Mr. Wolf's observations and the evidence in the record before it, the division pursued enforcement of 3 violations of Regulation 8 Part B that we'll ask you to uphold today. First, that Edge rendered transite friable, then failed to address the removal as an asbestos abatement activity in violation of sections 3S2 and 3S4B. Second, that Edge failed to adequately wet the transite while removing it in violation of section 3S4A. And third, that Edge failed to carefully remove the transite with minimal breakage and disturbance in violation of section 3S4C. Evidence will support a finding that Edge violated these. We'll ask you to uphold them at the end of this hearing. Moving now across the state to the Pine Creek Apartments in Denver, Colorado, this time the summer of June 2021, a very different project. Here in this multifamily apartment complex, a large fire had broken out, had burned a hole in the roof and created significant damage. Part of the damage it caused that day was a major asbestos spill, meaning there was identified friable asbestos material in this building that required cleanup. Edge had been conducted or had been engaged to conduct the cleanup of that. The building, unlike Eagles Nest Apartment, was unoccupied at the time. Severin McGowan conducted an inspection on Tuesday, June 15th, 2021. 4 workers were on site at the time he arrived. All 4 of those were appropriately certified to conduct asbestos work. One of the people he found there was Mr. Alberto Mota. Mr. Mota was Edge's supervisor on site that day. Again, his written deposition transcript is in the record for you as well. Upon arriving, Mr. McGowan immediately saw something of great concern to him. He saw plastic sheeting and tape typically used as a critical barrier necessary to maintain containment to make sure those asbestos fibers don't get out into the public, into the environment, dangling out of a 3rd floor window. Upon seeing that, he received permission from Mr. Mota to further inspect the location where he found yet more issues of concern. First, despite confirming, as this commission has already done in its order on summary judgment, that containment had collapsed and negative pressure had been lost, the manometer, the device used to measure and record negative air pressure between the dirty workspace with asbestos contaminated material and the clean area with public access, where worker access is done without personal protective equipment. The manometer was not sounding an alarm as is required under 3J3. It was not programmed with the project data for the Pine Creek Apartments. And it did not have a functional printer, strip chart reader, to show when that negative air pressure had been lost, how long that piece of dangling critical barrier had been in that way, and exposing the outside environment to potential asbestos fiber release. Each aspect of that is a violation of section 3J3 that we will ask you to uphold today. Mr. McGowan also identified that the 3-foot by 3-foot pop-up clean room on location that day, the clean room necessary for workers to store clothing in, to store their clean street clothing, change into their personal protective equipment necessary to pass through containment into the dirty work area, and then on their way out, again, after showering, washing all the asbestos fibers out, take off their respirators, take off their PPE, change back into their street clothes. It was a 3-foot by 3-foot pop-up chamber that was intended to allow the storage of all of the clothes for all of the workers on site that day, allowing them at least one to change. That was inadequately sized. And you'll hear from Mr. Curtis Burns that in 2021, this commission adopted changes to Regulation 8 Part B at section 3K1A, which is the requirements for the clean room, and the definition of clean room in section 1B. This commission adopted changes because those pop-up clean rooms typically did not allow for all of the storage of clothing, equipment, and people to change. You'll also hear Mr. Burns testify that there was extensive stakeholder outreach in advance of that rulemaking, during that rulemaking, and training afterwards. Edge's use of that pop-up months after that rule became effective in 2021 is a violation of that rule, and we will ask you to uphold it. Additionally, Mr. McGowan, during his inspection, walking on parts of the floor, the third floor that had already been abated and tear down had already occurred, he identified plastic sheeting and tape in areas that he could only explain as being critical barriers left up from that containment area that are required to be torn down and disposed of as asbestos contaminated waste because they can have asbestos fibers on them. Instead, they'd been left up in place and not disposed of. That's a violation of section 3Q. We'll ask you to uphold that today as well. Finally, this commission has already found in summary judgment violation of section 3C3 as Edge did not have the project design for the work it was conducting on June 15th, 2021. We will ask that you impose appropriate penalties for that violation at the end of this hearing. As mentioned, Mr. Burns will testify. He has nearly 35 experience in asbestos abatement work in Colorado. He has helped write and implement Regulation 8 Part B over the course of his career here. He is going to provide testimony on why those rules are so important to protect public health, why the violations of Edge of those rules are so critical. You'll also hear from Ms. Beth Foley, who will provide information on the division's enforcement process and penalty calculation. The division's witnesses are all here. You'll hear their testimony. You'll read their testimony. They'll be subject to cross-examination. They'll answer your questions. Because we want to make sure that if you have lingering doubts, if you don't yet find that it is more likely than not that Edge committed these violations, when we close our evidence at the end of this hearing, we want you to be sure. Because the evidence will show that Edge violated those rules. And at the end, we will ask that you uphold the division's finding, impose the appropriate penalties, and hold Edge accountable. Thank you.
Microphone?
We need the mic.
Oh.
Back, right?
Will yours reach?
I think so.
Barely.
Is that automatic? So if I,
Yeah, I think they'll start it for you.
I think we can turn it. You want to turn it so you can see it?
no, I don't.
Oh, you got it. Okay.
Thank you. My name is Mike Cross. I represent the licensee Edge Environmental. And on behalf of Edge, I want to first say thank you. I understand you are all very busy. I can see binders all throughout this room. We gave you a lot of information. So we appreciate that you're taking the time to take a look at this case. As you can imagine, this is very important to my client. As you know, the division has issued 2 compliance determinations against Edge on 2 projects, alleging a total of 7 violations. I've been told that I have 2 hours and 55 minutes to defend those allegations. We've taken 9 depositions in this case. There's 1,200 pages of transcripts. So as you can imagine, bringing 9 witnesses in here today to testify fully is simply impossible with the time constraints that we have. So instead, I'm going to try to do my best to summarize and highlight some of that evidence for you today. And we've done some of that in our pre-hearing statements. And as I hope to demonstrate in those statements and today, Edge fully complied with Regulation 8. Edge Environmental has been in business for 15 years. Edge fully agrees with the division that asbestos is dangerous and that Regulation 8 is important. And it does everything it can to comply with every single issue or every single requirement of Regulation 8 and believes it did so in this case. We hope to show that the division's enforcement of these alleged violations is based on subjective interpretations of Regulation 8, not the actual language, as well as some arbitrary and honestly unfair enforcement policies. So I'm going to talk about the same projects, start in the same order, starting with Leadville. Apparently, Mr. Wolf is going to say that that was one of the worst projects he's ever seen. I don't doubt it. One of the things you're going to hear is what the project looked like when Edge arrived on site that day. Edge's job was to remove transite panels around the balconies so that a different contractor named Ortiz Brothers could come in, remove those balconies and replace them. But you will see that Ortiz Brothers did not wait for Edge to do this. Instead, when Edge arrived on site on July 28, 2022, they observed that Ortiz Brothers had already ripped off all the balconies and in doing so severely damaged the transite. You will see pictures of this. They have already. They destroyed the transite tiles on the wall. They scattered the pieces throughout the entire 9-building apartment complex. Edge had been there for hours of one morning, and there's transite everywhere throughout a 9-building apartment complex. It caused a major asbestos spill. And interestingly, Ortiz Brothers is not subject to this enforcement proceeding or any enforcement proceeding for causing a major asbestos spill. As Mr. Wolf said during his deposition, we have to pick and choose our battles. So the battle they have chosen is against my client, Edge, not for causing the spill, but instead for how it removed the broken fragments that the Ortiz brothers left behind. In doing so, the division has alleged 3 separate violations. The first reads as follows: Edge rendered a previously non-friable material friable. That material was transite. You probably have learned already or will today more about transite than you ever wanted to in your entire life. It is cement mixed with asbestos fibers to create a very durable building material. That is why it is used in siding and roof and piping. It is undisputably non-friable, which means, according to the regulation, that if you grab a piece of transite and you try to crush it with your hand, you cannot crumble it, pulverize it, or reduce it to powder and sprinkle it. And for this reason, when Edge was there that day, there was no containment required. But Regulation 8 does prohibit, and we agree, cutting, grinding, sanding, bead blasting, sandblasting, or otherwise damaging transite in such a way that it would render it friable. There is no dispute that Edge did not cut, grind, sand, bead blast, or sandblast the material. Instead, the division alleges that Edge rendered it friable by dropping the fragments onto a poly drop cloth. Notably, the section on which the division relies for this alleged violation doesn't prohibit dropping. List cutting, grinding, sanding, bead blasting, sandblasting doesn't prohibit dropping. You're going to hear that nowhere in Regulation 8 is dropping prohibited. Instead, the division is relying on the broad catch-all language of otherwise damage the material in such a way to render it friable. You are going to have to interpret that language. You're going to have to apply the facts of this case to that language to decide if the regulation has been violated. To aid in that interpretation, Edge engaged an expert witness, a man named Carl Cox. Mr. Cox testified in a separate deposition. He is a former president of the Colorado Environmental Professionals Association, the Association of Asbestos Abatement Contractors and Industrial Hygienists and Inspectors. He's participated in the rulemaking proceedings. He's testified before this commission during those proceedings. And he has managed thousands of transite removal projects. He's an expert in transite and transite removal. You will see that Mr. Cox provided the opinion that in order to render this durable material, transite, friable, you would need some sort of mechanized means, similar to those that are cited in the regulation: cutting, grinding, sanding, bead blasting, or sandblasting. Mr. Cox opined that dropping transite fragments onto poly from a ladder is not sufficient force to do so. He also provided the opinion that it shouldn't even break in that situation, but if it did, it would be minimal breakage. It would not render it friable. You also see this in a bulletin from the EPA that the division has relied on heavily in its briefing, and I'm sure we'll talk about today. That bulletin from the EPA cuts both ways. It says, and I quote, "There is a difference between merely breaking a transite panel and crumbling, pulverizing, and reducing it to powder." That's our entire position. There's a difference between breaking and rendering it friable. The EPA in that bulletin gives examples of what would crumble, pulverize, or otherwise reduce transite to powder, including using a wrecking ball, implosion, using heavy machinery to demolish a building. You're going to see that Mr. Burns, during his deposition, agreed that dropping transite fragments from a ladder onto poly is nowhere near the same category of force. Second allegation on the Leadville project is that Edge failed to adequately wet the surface of the siding prior to removing it. Mr. Rodriguez testified during his deposition that Edge did indeed use an airless sprayer full of amended water as required to spray the material before removing it. Mr. Wolf, who apparently is going to testify today that he didn't see an airless sprayer on site, didn't note that in his notice of inspection that he created that day. He didn't note or allege in that notice of inspection that Edge had in any way failed to spray the building with amended water. We heard about that years later for the first time. The division takes a position, according to Mr. Burns, that Regulation 8 requires that transite be continuously sprayed during the removal. You will see that that is not in fact a requirement of Regulation 8. You'll also see that Mr. Cox opined that continuous spraying of a material during removal is not an industry standard. His exact words were, "It's not a requirement, it's not a rule, it's never been a good practice." The last allegation on Leadville is that Edge failed to carefully remove the asbestos cement siding, including dropping it to the ground from an elevated height. It's a separate subsection of the applicable section in Regulation 8. Division takes a position that dropping transite onto poly is a violation of Regulation 8 in and of itself. You will see that Regulation 8 is a very specific provision that addresses how to remove asbestos-containing material from an elevated height. You'll see that that section very clearly and unequivocally prohibits the dropping of friable asbestos-containing material from an elevated height. Everyone will agree today that there is no similar prohibition in Regulation 8 anywhere prohibiting dropping non-friable asbestos-containing material from an elevated height. On this particular issue, there is going to be a factual dispute. Mr. Rodriguez, Edge's supervisor on site, testified, you will see excerpts from his testimony, that he was at ground level and he didn't see anything breaking. He said if he had seen it breaking, he would have put a stop to it. You heard that Mr. Wolf is apparently going to testify that it was shattering. Those are two completely opposite positions, both under oath. You guys will have to resolve that finding or that factual dispute. You're the finders of fact here. And as I've raised in prior briefings, you're going to have your hands somewhat tied behind your back when you do so. Apparently, the division had a policy to keep only the documents it felt necessary to prosecute a licensee and allow others to be destroyed. You will see that the division takes a position that is up to a licensee such as Edge to preserve its own evidence to defend itself. So in this particular matter on the Leadville project, the division allowed to be destroyed several photographs and the original high definition video of the work practices that day. That video alone would have answered probably every single question you're being asked to determine today regarding the Leadville project. We would probably not be here if that video had been preserved by the division. The only evidence you will have to work with is what the evidence felt would be helpful to its prosecution. You will have to decide whether it's fair and if they can meet that their burden on that evidence alone. The other project is Pine Creek. Again, Edge was working under difficult conditions on that project. A fire had ripped through an apartment complex. Edge was performing work on the third floor, the top level. Fire had ripped holes or destroyed holes or created holes in the roof through which wind and rain were entering the building. Edge was engaged to remediate the spill that was caused by the fire and to remove whatever asbestos-containing material remained. On this project, you will find that most of the facts are not in dispute. What we have here again is a concern with regard to the interpretation and enforcement of the language of Regulation 8. The first allegation on Pine Creek is that Edge failed to program and maintain negative air pressure. There's no dispute that the containment lost pressure overnight. When both Edge and the inspector arrived, as counsel indicated, they found that a containment had collapsed, most likely from weather overnight. No removal was taking place at the time. No spill resulted. The public did not have access to the area. No one was placed in harm's way. Edge quickly restored the containment and reestablished negative pressure as instructed by Mr. McGowan. You will have to decide whether that pressure loss is a violation of Regulation 8. And when you do so, you will see that Mr. Burns testified during his deposition that a pressure loss alone is not an automatic violation of Regulation 8. Both he and the inspector, Mr. McGowan, agreed. This is not uncommon. Unfortunately, it's something that happens on asbestos abatement projects, especially where, as here, the containment is exposed to elements. Second allegation on this project is that Edge failed to ensure that the clean room was adequately sized. Again, a lot of these facts are undisputed. Edge agrees. They were using a 3x3 prefabricated pop-up chamber for a clean room. It's undisputed that Edge, like most contractors, use that same clean room on thousands of construction projects, and that the division allowed that pop-up chamber as a clean room for 20 years. And as counsel noted, there was a change in that enforcement policy. On March 17th, 2021, only 3 months before this inspection, the division reversed that policy without substantively changing the language. The only thing they added was that it had to be adequately sized. You will have to decide whether a pop-up chamber that the division felt was adequately sized for 20 years now suddenly violates Regulation 8. You will have to decide whether it was fair to charge Edge with the violation so soon after the division changed its enforcement policy. The last allegation on Pine Creek is that Edge failed to ensure proper removal and disposal of all containment components. Again, there's no dispute here. There were poly barriers installed in multiple locations on the third floor. There's no dispute that it would be wrong to leave those barriers in place if they were part of a prior containment. It's considered asbestos containing material and it needs to be bagged in accordance with the regulation. There's also no dispute, Mr. McGowan will agree, that it's perfectly acceptable to use poly to cover penetrations in the roof or to cover HVAC penetrations or sewage penetrations, to mitigate odors, to mitigate wind, to mitigate rain. In this case, again, you'll have to make a factual determination. What was the purpose of the poly that Mr. McGowan observed on that day? You will hear that Mr. Motive testified it was to mitigate wind and weather penetration and to mitigate the odors coming from rotting food and sewage. You'll hear Mr. Burns and Mr. McGowan suspect that it was from a prior containment. You will hear them admit that is their speculation. They don't actually know that. And so when you're hearing that evidence and all evidence today, and you evaluate the binders of information that we've provided to you, I'm going to ask you to keep two things in mind. As counsel said, the division bears the burden of proof. Have they met that burden? Are the division's allegations based on fact or speculation? Has the division presented you sufficient evidence to meet their burden? Or has that important evidence been destroyed pursuant to their policy to destroy everything within 90 days? The second thing I'll ask you to keep in mind is the actual language of Regulation 8 as opposed to the division's interpretation. What does Regulation 8 actually say, require, and prohibit? We submit to you that if you apply the actual language of Regulation 8 to the facts and the evidence that the division has presented here today, and through the information we provided previously, you will agree with us that Edge is fully complied. At the end of the day today, we will ask you to reject the division's alleged violations. Thank you.
At this time, we are ready for the division to call its first witness.
At this time, the division would like to call Jeffrey Wolf.
Mr. Wolf, I will go ahead and swear you in for the division's questions. Do you swear that the evidence you're about to give to the commission in this matter shall be the truth?
Yes, I do.
Can you hear me? Okay, begin.
Morning, Mr. Wolf. Please introduce yourself and tell us how you are connected with this case.
My name is Jeffrey Wolf. I'm an environmental protection specialist with the Air Pollution Control Division, Colorado Department of Public Health and Environment. I was the inspector that observed Edge's work practices that day, July 28th, 2022.
Can the commissioner see the screen behind me, or am I blocking it? Everyone can see? Okay. And you said you conducted an inspection. Which inspection did you conduct?
This is the inspection that was conducted at Eagles Nest Apartment in Leadville, Colorado. Eagles Nest Apartments in Leadville, Colorado.
Do you remember the date of that inspection?
July 28th, 2022.
I understand you submitted written testimony in this case.
Yes.
Commissioners, that is at Division Exhibit 5 for your reference. Do you stand by the written testimony that you submitted in this case?
Yes.
Can you briefly summarize your background and experience?
Yes, so I've been inspector with the Indoor Environment Program for over 10 years with the Colorado Department of Public Health and Environment, an additional year and a half with the city and county of Denver doing asbestos enforcement. And then prior to any regulatory enforcement roles, I was a certified asbestos building inspector for 5 years since 2008. So over almost 20 years in the asbestos industry.
Before we dive into the details of the inspection, can you briefly tell us what kind of work Edge was doing at the site that day?
Edge had received approval notice from the division to conduct non-friable asbestos removal of transite siding across multiple buildings at Eagles Nest Apartments.
You mentioned, I understand there's a difference between friable material and non-friable material. Can you briefly walk us through the difference?
Yes, so the definition of friable materials, any material that can be crumbled, pulverized, or reduced to powder by hand pressure when dry. A non-friable material is any material that does not meet that definition.
Emily, is it on?
Having presentation issues here.
It was bound to happen.
Let's pause our time for a second.
Maybe it's too far away.
No, it's.
No, it's
ours.
it's over here. Battery, maybe?
Of course. Try it again.
Okay, I'll just have to tell you when to change it.
I will work on this.
Can you flip to the next slide? Okay, oops. No, the one before that, please. Okay, that might be a little bit hard to see, but that is section 3S4 of the regulations. Is this a section that applies to Edge's, the work that Edge was doing that day?
Yes,
Does the division have an approval process for the removal of non-friable material?
yes, any non-friable material that's being removed over the regulatory trigger levels must supply a notice to the division prior to doing that work. That notice and the work practices included therein are reviewed by division inspectors to make sure they are in compliance with this section and all other non-friable sections. And then if the work practices as stated on the application are in compliance or would be in compliance, we issue approval of the notification application.
Did Edge seek approval for its work at the Leadville Eagles Nest site?
Yes,
This is, I'm showing you joint exhibit 27. It might be a little bit hard to see at the bottom there. Is this the notice that Edge provided that day for the work that they were doing that day?
this is the notice they provided for the work.
Okay. And then I've just zoomed in on the bottom of that form to the work practices that are listed there. You may or may not be able to see that very well. If you want to turn to joint exhibit 27 in your binder, in the big binder. And would you read the work practices that were listed in that approval?
All ACM, which stands for asbestos containing material, will be removed in a non-friable manner while using 6-foot drop cloths. Transite will remain non-friable throughout abatement. As the transite is nailed to the building, we will be pulling nails or clipping the nail heads and pulling the transite in entire sheets. Each building has approximately 45 square feet of transite in areas needing abatement. ACM, asbestos containing material, will be removed using hand tools, hand scrapers, clippers, flat bars, screwdrivers, and an airless sprayer with amended water in accordance with Regulation 8. And then there's several units listed where they were.
Do you know where those work practices came from?
They were submitted by Edge.
And were they approved by the division?
There's an approval stamp for the inspector that reviewed it. So yes,
Do you expect people to follow the removal practices specified in their approved notice?
yes, it's the only way we can review a project before the work actually happens to ensure it's in compliance with the regulations. So we expect all work practices listed to be followed prior to upon our approval.
And what happens if they don't follow them?
If they don't follow the work practices, they're committing violations of the regulation.
Okay, let's turn to what you actually observed during your inspection. Can you describe to us what you observed when you first arrived on site?
Yes, so as this notification lists, there were multiple potential units where they were working. So I arrived at 1531 Mount Lincoln, drove around the perimeter to try and locate what would appear to be, exterior non-friable removal work. I saw 2 workers in white suits, which I assumed to be Tyvek PP personal protective equipment, which is used on asbestos removal projects. So I assumed that when I saw those two individuals, I was at the right spot. So I pulled into a parking lot that was very close to their work area where they were working, approximately 25, 30 feet away, had a clear line of sight to the work that was taking place that day. And first thing I noticed was there was a worker approximately 25, 30 feet up in the air. You'll see he's on the 3rd story. He was removing transite siding basically with no care or regard for what was happening to it, ripping it off the building. It's free falling 30 feet, smashing, shattering, banging on the ground. Some of it was laying on the poly drop cloth that you'll see. Others were bouncing off into the adjacent soil. And then there was a worker also coming back and forth. I couldn't see from my vehicle what he was doing, but he was in no way assisting the worker on the ladder in any way.
And how long did you observe Edge working?
Approximately 5 minutes, as I noted on my notice of inspection.
And about how far away were you initially?
25, 30 feet, clear line of sight.
Did you take any video?
I did.
How's the quality of that video?
It's poor
Why is that?
because, as I'm sure some of the commissioners can relate to, when you take a video on an iPhone and try to transfer it to any sort of Android or PC device, the quality can become severely degraded. At the time I was taking the video, I thought the quality was excellent, and it was excellent. But in the process of uploading it, somehow it got degraded, and we cannot get it to revert. We tried very hard.
Did you destroy the original version of that video?
Once it was uploaded, it was on my personal device, so yes, it was removed from my personal device.
We're gonna show the video in a moment, but before we do that, what did you actually see as you were taking the video?
Again, as I stated, there was a worker up on a ladder. He was ripping siding off with some sort of hand tool. There was no evidence of any wetting taking place. Airless sprayers are very obvious, both from sight and sound. So there was no wetting taking place, both at the point of impact, during the removal, and then after it had fallen down several stories and shattered on the ground. There again was a worker walking back and forth. Once I approached the scene, he came here, he had been picking up some of the pieces and putting those into bags, again, without any wetting. That's what I observed that day.
We're gonna go ahead and play the video. Does this video show everything that you observed that day?
No, it's a 45-second video. It was indicative of their work practices.
Did you also take pictures?
Yes,
Did you upload pictures into the division's enforcement file?
yes.
How did you determine which photos to upload?
I uploaded the ones that were relevant to Edge's work that day that I observed.
Can you briefly, I'm gonna show you, speaking of pictures, is that a picture that you took that day?
Yes.
Can you briefly describe what this picture shows?
So this, again, I was at the site for a good amount of time that day. And so I walked the entire complex and I found areas where, as Mr. Cross has stated, Edge had not started work. So this is what it looked like before Edge had not started work. So you can see there are some small broken pieces already there. We're not disputing that. What we are disputing is look at all the other undisturbed full sheets that still sit there. Edge's work was to basically clear an area around those openings to establish new balconies. And so there's many, many full sheets there. There is a little bit of breakage, yes, the division acknowledges that, but those pieces do not then need to be further broken.
Is this another picture that you took that day?
Yes,
What does this picture show?
this is a picture of Edge's work area. You can see there's 6-foot poly drop cloth. Probably didn't quite extend 6 feet. You can see heavily broken, shattered, basically destroyed pieces of asbestos cement siding on top of that polyethylene plastic drop cloth that Edge laid down. So all of that poly, or all of that material that's on top of that poly came from Edge's work that day.
How do you know that it came from Edge's work that day?
Because both, one, there's no other way for that transite to have gotten on the poly that Edge laid down on top of it. Someone had to put that there. Second, Michael Rodriguez's own testimony stated that they actually cleared the areas where they were working before. So that direct testimony to me stated that any transite material observed there, per his own admission, would have been from their work that day.
I'm gonna zoom in on this photograph. Did you walk up to see this more closely?
Yes.
Using the photograph, can you describe to me what you saw at that point?
Again, I don't see an intact piece of transite there at all. I see heavily shattered, heavily broken pieces. And upon my touching the material, many of those pieces were easily crumbled to powder by hand pressure.
Do you have special training in making friability determinations?
Yes, as I stated, I was a certified asbestos building inspector, which the regulation stipulates are the primary individuals responsible for assessing friability. And I've also been with the division 10 years assessing friability on projects throughout the state.
Did you make a friability determination of that material that you took from?
Yes,
that
as I
liner?
said, I picked up several pieces, touched them, reduced them with hand pressure, crumbled them, and they were all very dry.
Can you please compare the condition of the tiles that are on this liner with the tiles that were untouched by Edge?
Yep, so again, yes, thank you, Ms. Liddick. So again, you can see there are some broken pieces, the division's not disputing that, but those pieces do not need to be dropped 30 feet and then allowed to shatter on hard ground. The tiles that have been very heavily weathered and would very easily shatter, further reducing to sizes that are smaller than your pinky nail. That is not minimal breakage or disturbance.
You said 30 feet, did you mean 20 feet?
3 stories high, I didn't have an exact measuring tape, between 25 and 30 feet, sure.
Was Edge removing in full sheets?
No,
Was Edge clipping nails?
no,
Are you aware of any statements Mr. Rodriguez made about whether Edge was clipping nails?
I believe in his direct testimony or deposition, he states they were not removing nail heads.
Was what you saw careful removal with minimal breakage and disturbance?
No,
Is that a violation?
yes,
Which section does that violate?
3S4C,
Just to be clear, is that a separate violation from rendering the material friable?
yes,
And which section prohibits rendering material friable?
3S4B,
Were Edge's workers wetting the siding at any time?
no, not that I observed.
If they had been wetting, what would they have been using?
As stated on their application, we expected them to be using an airless sprayer with amended water.
Did they have an airless sprayer?
Not that I observed that day on site.
Can you tell us what an airless sprayer sounds like?
Yes, so in addition to not observing it, an airless sprayer for the commission, if you've never heard one, it's a very loud device. It uses an air compressor with no real silencer. You can hear if they were using it in the building next door and there was an open window, you could hear them from outside using that device. It has the audible cadence of honestly an automatic machine gun, and I can demonstrate that for the commission if they like. That's not an exaggeration. It's that loud. You would have heard it that loud. At no point did I also hear it. So no sight, nor hearing the entire time I was there on site.
Was the siding in the drop cloth, on the drop cloth in this picture wet at all?
No, and then there's no evidence of beating. If they were spraying it there on the cloth, you would have seen some sort of water droplets on that adjacent brown siding, as well as I'm sure all the commissioners are familiar with the garden and using a garden hose. When you wet soil, there is a very obvious distinguishment between wet soil and dry soil. And you can see in that photo there is none. And this was taken very soon after their work practices were stopped.
Was not wetting the material a violation?
Yes.
Of which section?
3S4A.
Were there residents living at this apartment site while Edge was working and while you did your inspection?
Yes.
Did you see any open windows at the apartment complex?
Yes, maybe in some of the photos that may have been captured, but I can't see which ones there. There was also people walking their dogs. There was a sidewalk, not even 10 feet adjacent to this work that was taking place. None of the residents, there was also a playground that was very close to the parking lot I was parked in, maybe 30 feet away from this work. And people had their kids out there playing.
Were edge workers wearing personal protective equipment that would protect themselves from asbestos exposure?
Yes,
Were any residents wearing any personal protective equipment that would protect them from asbestos exposure?
no.
How many years of experience do you have in this field?
I've been in the asbestos industry again since 2008. I've been an inspector of the division for over 10 years.
And how many inspections do you do per year approximately?
Approximately 100 to 120 inspections for a year. That is what we average.
So how many inspections would you say you've done over your whole career with the division?
Conservative estimate is over 1,000. And again, that's a conservative estimate.
Have you ever seen anything like this before?
Nothing like this project before, no.
And of all the inspections you've done, the roughly 1,000 that you've done, how significant were the violations that you observed at Leadville Eagles Nest?
This is one of the worst transite removal projects I've seen, whether it was Ortiz Brothers or Edge Environmental.
Thank you.
Emily?
Any question?
Sorry.
That was gonna be.
You testified that it dropped from a height of 25 to 30 feet. Are you certain of that?
I did not measure the height. They're using a 20-foot extension ladder. He, as you saw in the video, extends beyond the extension ladder. So my estimate is between 20 and 30 feet. That's the best estimate I can get.
Do you remember giving a deposition in this matter?
Yes,
Do you remember what you said during that deposition about the height?
I'd have to be reminded. I don't recall.
If I could approach him and refresh his recollection.
So according to,
Having now reviewed your deposition testimony, do you recall what you?
yes, I
the
stated
height?
20 feet.
Thank you. Yes, that concludes the divisions. Correct.
Cross-examination.
Yes, please. Jenny, am I able to share now? Let's see, let's try it. Thank you. Hello, Mr. Wolf. Before I took your deposition,
Yes,
okay, I'll try to be pretty brief. One of the last things you said was this was one of the worst projects you've ever seen, whether it was Ortiz or Edge, correct?
that's correct.
Okay, and you do agree that Edge was only there that morning, correct?
Their permit was stated that they had been there for 3 days, so I don't know that.
You don't know that for sure. Did you see Mr. Rodriguez's testimony that they had just started that morning?
If that's what he stated, I did not, sure.
Do you have any evidence to suggest that they did any removal prior to that?
I do not have any evidence.
Okay. When you arrived on site that day, there was asbestos containing material in the form of transite debris everywhere, correct?
That was found out later. My first observations were of Edge working.
Right, and then after that, you walked the property, correct?
Correct.
And then you saw asbestos containing material around every single one of the 9 buildings in the apartment complex, correct?
That's correct.
All right. And looking at the screen right here, which is the Division's Exhibit 10, this is just one photo you took of one location. Every balcony, every old balcony had been ripped off throughout the entire complex, correct?
I can't recall. I can't say whether or not there had been balconies removed. I don't know if it was all of them.
And I'm just scrolling through this. Well, let's start at the top. These are 9 photographs that you took, right? Or I'm sorry, these are the 9 photographs you chose to upload, correct?
I don't know the full list. I don't know if this is the full list.
Okay, I'll represent to you that these are 9 photographs that the division produced to me and that we've jointly stipulated as Division's Exhibit 10.
Those are photos that I took that day, if that's what you're asking.
First photo is of transite debris in the soil. Second is transite debris in the soil. Third is transite debris in the soil. Fourth is transite debris in the soil. The fifth is the one that you were talking about Edge's actual location. We just looked at that one. There's another transite debris in the soil, transite debris in the soil, transite debris in the soil. See that?
Yes,
So your primary concern, clearly, you took 9 photographs. Only one is of Edge's work site. The rest are of transite throughout the entire complex, correct?
I don't know if that's correct or not.
And then I'm looking at this picture. We talked about this picture during your deposition. That's a sample you took, right?
That's correct.
And that's like, it's too small, but I've cited to this in some of the briefs that we filed previously. That says friable transite in soil and area where Edge had not started on the northeast side, correct?
That's correct.
So you took a sample from somewhere else in the project of what you consider to be friable, correct?
That's correct.
And you have the ability to take samples,
Yes,
and you stored samples from this project at your house, correct?
I stored it in my possession.
With your personal materials at your home in Oak Creek, correct?
I'm a remote employee.
Objection, this sample is not in evidence and we're not relying on the sample at all.
But I have the right to demonstrate or make a point of the fact that they didn't bring any samples today.
It's been excluded. We have not, this is not an exhibit that either party is relying on, the physical example,
Okay,
the physical sample, sorry.
I'll move on. So you didn't come today with any samples of transite, correct?
That's incorrect.
You have the evidence that's been excluded that's not allowed to be used in this proceeding, correct?
I have the samples and have had samples in my possession since they were taken.
Okay. And going back to the photo, you testified earlier that Edge was supposed to remove all the transite around the opening. Is that your understanding?
They stated 45 square feet from each building. That right there is not 45 square feet. So there is still some work to be done there per their own application.
Sure, but do you see where the trusses were cut by Ortiz Brothers?
I don't know who cut the trusses.
Okay.
Because I
Any
didn't observe any other work other than Edge's work.
Do you have any evidence to suggest that Edge cut those trusses?
I have no evidence to say who cut those trusses.
And then what, other than a square footage, do you have any evidence to suggest that Edge was gonna remove all the way around and not just around the trusses?
Yes, Michael Rodriguez's own testimony and his statements to me that day on site, that they still had work to do.
They did have work to do. There's no doubt about that. But are you saying they had to go up and over the top of the opening?
There's photos I took that show it.
Are those here today?
I don't know where those photos are.
Okay, let's talk about those photos. We have 9, right? You testified that you took several more than 9, correct?
I'd have to look at my testimony.
And you only uploaded 9,
I'd
correct?
have to look at my testimony.
Well, my question is you only uploaded 9.
I don't know how many I uploaded.
Yeah, but you didn't upload all of them.
I believe I uploaded everything that I had.
You testified earlier that or testified during your deposition that there were several more that they were purged as a result of the document retention policy. Do you not remember any of that testimony?
I preserved everything that was relevant to the Edge case.
What you consider relevant?
Who else is to consider evidence, sir?
Well, you understand my client might think something's relevant that you may not think is.
Then maybe they should have preserved their own evidence.
That's the division's position, isn't it? That it's up to Edge as a licensee to preserve its own evidence.
I'm one inspector and I follow the procedures as they're communicated.
And you're paid for by the state, right?
I don't know where my compensation comes from, sir. I don't know how that's relevant to this conversation.
Well, you're a professional. Is that fair to say?
I do professional work for the state of Colorado to protect public health and environment, yes.
And you're a skilled inspector. You're skilled at documenting things, skilled at obtaining evidence. Paid for with tax dollars.
Was there a question there?
Is all of that correct?
I do work for the state of Colorado to protect public health and environment. sir.
Okay, and I think you just testified that it's up to my client Edge, the workers that day. If they want to defend themselves in a proceeding like this, then they need to preserve evidence because you guys might not upload it all and destroy it. Correct?
I don't know how to answer that question.
We have a video. We saw the video. I'm not gonna play it again, but you really can't see anything on that video. Would you agree with that?
Yes, and I explained why.
Okay, and the reason why is because you took it on your personal iPhone
That's correct.
and it was a perfect video. It was a high def video on an iPhone, I assume.
That's correct.
And that original has been destroyed.
It was uploaded for our policy procedures in the upload process. Somehow it got to the state you see it in. So it was not destroyed, it was preserved in what I thought was good condition and found out later, much long after the fact, because as we've decided, this is 3 years ago, that it was not in a good condition.
Because the division didn't issue a notice of alleged violation for something like 2 years in this case, correct?
I can't comment on our enforcement policy.
By the time you went back and looked for the original video that was on your personal phone as opposed to a state phone, or let me ask that, are you issued a state phone?
Yes.
Okay, so instead of using the state phone, you used your personal phone and you didn't preserve the original video, correct?
It was on my personal device. As any, I think, employee would understand, I uploaded that from my personal device to our shared server and then destroyed that version of it, but it had been preserved.
And that version would have
If it
told,
wasn't preserved, we wouldn't have it here today.
well, in the original version, the high definition video would have told us, it would have shown whether the pieces were shattered and when they were coming off, right?
I was that close. I can't say what it showed because this is the version we have.
It would have shown if there was an aerial sprayer on site, correct?
This is the version we have.
Objection, calling for speculation.
What was the question again,
The
please?
question was, you would agree with me that the high definition video of the work practices on that day would have shown if there was an aerial sprayer on site.
And I can't say, I don't know what it showed because I have a
Hang on,
version.
hang on,
of it.
hang on.
Sorry.
There's an objection on the table, so it requires. a vote.
Overrule that objection.
The video I took would have showed their work practices and procedures that day.
Okay. Last thing I'm gonna ask you about is the wedding. We talked about this during your deposition. You created a notice of, well, actually, before I get to wedding, you testified that you observed this for 5 minutes from your car 30 feet away with a clear line of sight, correct?
That's what my notice of inspection states.
And it's your testimony that it was shattering the entire time.
There is not a piece that did not break when they dropped it.
Okay, and there's a playground nearby, accordingly is what you said.
That's correct.
And you agree there's no minimum safe level of asbestos, correct?
That's a personal opinion, so I can't answer that question.
Okay, what's your personal opinion?
There has been no known stated safe level of asbestos exposure.
So you thought that Edge was engaged in practices that was endangering children in a playground nearby? And you sat there for 5 minutes, is that your testimony?
I had to observe their work and according to you, preserve enough evidence to take a case here today. So yes,
Okay, so you allowed that to proceed for 5 minutes, and you claim that you saw it shattering the entire time?
yes,
All right, with regard to the wedding, we talked about this during your deposition. That's not listed anywhere in your notice of inspection, correct?
I'd have to review my notice of inspection.
You've not reviewed that in preparation for today?
I was not instructed to do so.
Do you remember me talking to you about this during your deposition?
I'd have to review the deposition.
Do you agree with me that it's important to list everything that you consider to be a violation in the notice of inspection that you created the day of the inspection?
I agree that we have policies, procedures that we follow. And in this case, I wrote down what I observed that I thought was most pressing to the situation. As you described, this was a very large site. I had a lot to cover. So that notice of inspection, the process we have is we produce the notice of inspection to those on site, produce required actions in order for the site to come into compliance. And we come back and talk to the compliance and enforcement supervisor and discuss it and discuss everything that's available. And if further allegations arise from that process, then those can be alleged.
Okay, and in that notice of inspection, you didn't mention anything about amended water.
I'd have to review the notice of inspection.
Those are my questions. Thank you.
Okay, you testified that you took some pictures that day. You observed Edge working that day, correct?
That's correct.
Did you ever observe Ortiz Brothers working?
They were not there on site.
When you uploaded the photos that council walked you through, did you upload those photos for any particular reason? What was your thought process in going into uploading those photos?
I upload the photos that are most relevant for enforcement once it's determined that enforcement case is going to be enacted. As Mr. Cross stated, the timeline for our enforcement process sometimes can be significantly delayed. And so there can be lag time from when photos get uploaded. to when photos are taken to when they're uploaded. I uploaded everything I had.
Did you make any determination about what might or might not have been relevant to Edge's violations?
I uploaded everything like I said that I had. I don't know how else to answer that question.
You said you also may have taken other photos of the site that weren't uploaded.
Correct.
Why wouldn't you have uploaded some photos that you took of the site?
They were not relevant at the time to be cited in the court case. The photos that aren't relevant to Edge's work practices or procedures that day that I observed would have been potentially deleted.
I'm gonna pull up the notice of inspection that council was referring to. That's the Denver one. Actually, if you could turn to it in your binder.
That's the number. Sorry.
It's inspection, it's joint exhibit 28.
We'll work on getting that up on the screen. Got it?
Yes.
Okay. Is that the notice of inspection that you wrote out that day?
Yes.
And when did you write out everything that's on that form?
They're on site that day.
You could scroll down. There's a lot of material on that form, you'd agree?
Yes.
Did you basically nearly run out of room on that form?
Yes, as you can see, I filled as much as I could out.
Okay, and when you're writing a notice of inspection, you're trying your best to fill in what you remember and what you have observed.
Yes.
And are you doing it on site as you're there?
Yes, and in this case, it was handed to Mr. Rodriguez, hence that's why he signed the documents. That's what it attests to. So yes, it was distributed there on site that day to Mr. Rodriguez.
No further questions.
Do you have any commissioner questions?
The report indicates that the required actions was to stop all work. Did they stop all work?
Yes, they did.
I have one question. In regards to transite friability, is there a size threshold on whether transite is friable or non-friable depending on how big it is?
There is not. Mr. Burns will probably testify later, maybe help you in that regard. And so there's no size requirement. Any material of any size can be determined friable if it meets that definition of crumbled, pulverized, or reduced to powder by hand pressure when dry.
I guess alternatively, if a piece of transite is non-friable, it could be as small as, say, an inch, and could then be further rendered non-friable.
Further rendered non-friable, I'm confused, sorry.
I'm sorry.
Question.
Rendered friable.
Again, a piece of any size could meet the definition of friability, whether that's an head. Sorry, I don't know what's happening with my microphone. But a piece of any size could be considered friable if it meets the definition of friability, even if it's along an edge of that. When it breaks, the edges are much more likely to be rendered friable, as I think Mr. Burns will explain in the statement of basis and purpose section later in our presentation. So the size of the particulate is not relevant. However, the more breakage that occurs, the more likely you will be able to reduce it to powder by hand pressure.
Commissioner Riddle.
Thank you. I am trying to figure out how you determine that the material was friable. In your deposition, there's some conversation about how you touched the material, but then had it in a bag and attempted or touched it or did something with it in the bag. And I'm wondering, and then just now you were talking about how you touched it and picked it up and did something. And so my question to you is, How did you determine that it was, what was the method that you used to determine that it was filed?
Both of them were true. It was a very large site, so I picked up many pieces. I had gloves on. It was outside, and so I handled several pieces around the facility in addition to the one that I put in the bag. I further manipulated the one in the bag because once it's in the bag, it's a Ziploc bag. That way it's not releasing any fibers. So I was able to very easily manipulate it in the bag.
What did you do?
Broke it with my hand
So you-
several times
So you just broke it?
with just snapping it with my hand very easily. When it gets to particles that side, it's not challenging to break it at all.
Okay, all right, that's all.
Commissioner Slusky, your question.
If there was an airless sprayer on site, I still am not sure. It's a compressor and a hose coming out of the compressor, and there must be a tank of water.
Usually,
All of that sits on the ground.
it depends on the project. There wasn't one there, so I can't describe how they would have had it set up. But you described the apparatus. Yes, there's a compressor, hose comes out of compressor. There has to be a reservoir, whether that's a bucket of water with an amended solution. It could have been set anywhere in adjacent to their work area, and it wasn't.
So it would have been obvious, and even in that poor video, it would have been obvious. You think?
It would have been obvious in their motion. They apply it in a spray motion. Plus that worker was 3 stories up. In order to maintain OSHA 3 points of contact, you'd have seen him put the tool down, wet it as he's going, because he's required to wet it throughout, not just before. So it should have been being wet as it was coming off and again on the ground. So they really needed multiple sprayers to achieve the standard.
It looked dangerous. And even with the 3 points of contact and a bar, is that what's going on? They're taking them.
That's what I observed. They were using hand
So
tools.
would it even be possible to spray and do all that at the same time?
In my opinion, it's not possible. I don't know what's going on with my sorry, commissioners.
We're getting you a
Can we
Zoom
hold on a
microphone, yeah, make sure we get this in the record.
As close as I can be.
I don't think that's the issue.
Yeah, that seems to be better. So yeah, it would have been, it's not a job that is easily done with one person because of the standard that needs to be met.
So it would. Your mic on. So what would be better safety wise would have been to have someone holding the ladder first of all, or having 2 people doing this job. It's a 2-person job.
I can, with the current, if you're asking with the setup that they had there, I don't see how it could have been done with one person. There's other ways they could have used other engineering controls that I think Mr. Burns is going to touch on, that they could have set it up so that one person could have been able to handle it much safer. And I don't want to say it's a 2-person job because it's not required anywhere in the regulation, but the work practices and the standard of 3S4 needs to be met, and they were not meeting that standard.
Thomas?
Mr. Wolf, was all or most of the transite siding that was broken that you observed on that day consistent with Edge's purported work schedule?
No,
And would the dropped and shattered transite have been a violation if the poly fully contained the transite?
sorry, Commissioner Thomas, can you ask the question again? I'm a little confused.
Well, in one of the pictures we observed, transite was on and off of the poly. If it was all on the poly and still broken like that, would that have been a violation?
Yes, and again, I just have my, yes, that would have been a violation of several of the sections that we described.
Okay, thank you.
Any other commissioner questions?
Just a question about the photos. The one that we saw with the poly and the transite on top of that, was that directly under the area where they were working?
Yes.
Commissioner Reader, I forgot about you back there. You have a question?
Yes, thank you. Going back to photo 5, where you could see the broken panels that were still intact. My question is around the 45 square feet of removal on each building and the number of balconies. I'm trying to understand how many panels that is around each balcony? Is it just the 2 or 3 sort of below the boarded up window, or is it many of those? There are clearly things away from where the balcony was removed that are still intact, but I'm trying to understand, are they just trying to remove those 2 or 3 directly below there where you could see the arms of the balcony coming out, or are there other panels they would be removing in addition to those? 45 square feet, if there are 15 balconies, it's not very much per balcony.
That's a great question, Commissioner. And so again, that estimate of 45 is based on what they put on their application. My observations are that the balconies that were there were smaller. There were at least 7 to 8 tiles per opening times 3 openings in a vertical run that needed to be removed, because there's photos that show it later. The decks that were then put in place were larger than the decks that were there. So there was significant tile removal that Edge still had to do, in addition to what was just broken under those small openings.
Can we pull up photo 5?
For the convenience of the commission, that's Division Exhibit 10, I believe.
I don't know if that microphone works. Division Exhibit 10, page.
Is that accessible for someone?
Yes, we can put it up.
Page 7.
I guess I was hoping we put it on the screen. You just had it on the screen from the presentation slides. That's all I'm asking for. Perfect. So my question is really, you can see the 3 places, I guess, where there was a balcony. Were they required to remove simply that 1 panel or 2 panels, however many it is underneath, that are damaged? Or were there other panels above that or below that they were also required to remove as part of their scope of work?
There were many more panels, and somewhere there's a photo of that.
Okay, thank you. And then secondly, when you did your friability test, the one photo sort of implied it was, let me go back. When you did your friability test, did you do it on the material around the drop cloth in that photo, or was it from some of the other photos where there were no drop cloths?
I did it on the drop cloth as well as in other areas. So I did it in many areas throughout the complex. But I assure you that I did do it off of the drop cloth.
Okay, thank you.
Any other questions? Okay. Are there any questions based on commissioner questions that we need to address?
No.
Excuse witness.
Thank you, commissioners.
I know these 10:27, 10:28 on my clock right now. Let's go ahead and take a 10-minute break. Everyone's good with that. I'll come back to the next witness. That'll be 10:38 on my clock. referencing our exhibits clearly, so we can kind of get to that spot easy. So appreciate that. Go ahead when you're ready.
At this time, the division would like to call Inspector Severin McGowan, please.
Mr. McGowan, do you swear that the evidence you are about to give to the commission in this matter shall be the truth?
I do.
Commissioners, Division Inspector Severin McGowan submitted written testimony, which is admitted into the record as Division Exhibit 5. Additionally, as counsel deposed Mr. McGowan and designated portions of that transcript are in the record at Joint Exhibit 24. We do have some live questions for Mr. McGowan, and we'll proceed with those. Good morning, Mr. McGowan. Would you please state your name and describe your role with the Air Division?
Good morning. My name is Severin McGowan. I work with the Indoor Environment Program within AQCC at CDPHE. I'm an Environmental Protection Specialist 3. I'm a work lead. I conduct inspections. I also help train new inspectors. I review permits. I approve permits. I do complaint inspections as well, public outreach, all kinds of stuff.
And how long have you been an inspector with the Indoor Environment Program?
I've been at the Indoor Environment Program for over 11 years.
As a rough estimate, about how many inspections have you conducted in your time with the division?
Over 1,000 inspections.
And prior to joining CDPHE, do you have any experience with asbestos work?
Yes, sir. Prior to joining CDPHE, I worked for an asbestos consulting firm. I was a certified air monitoring specialist as well as an asbestos building inspector. Prior to that experience, working with them for about 1.5 years, I worked for a general abatement contractor and was a certified asbestos supervisor.
Thank you, Mr. McGowan. I'd like to go ahead and start talking about the inspection you conducted at the Pine Creek Apartments. Can you please confirm, did you conduct an inspection on June 15th, 2021 at 630 South Dayton at a facility known as the Denver Pine Creek Apartments?
Yes, sir, I did.
And do you remember what time you arrived that day?
I arrived around noon.
And was Mr. Alberto Mota at the site when you arrived?
He was.
And was he Edge's project supervisor on site that day?
Yes, sir, he was.
In his deposition, Mr. Mota testified that he had been on the site at least 2 hours before your arrival. Based on what you saw at the site, do you have any reason to doubt that timing?
I have no reason to doubt that.
And in total, when you arrived, how many Edge workers were at the location that day?
There were 4 total workers on site when I was there inspecting.
Were all 4 certified as asbestos abatement workers?
Yes, sir, they were.
Can you please walk us through what you saw when you arrived on site on June 15th?
Yeah, I pulled up to the site. I noticed what appeared to be the crew in the parking lot. It was a beautiful day. Was happy to be inspecting that day. Pulled up, met Mr. Mota. I had recognized them from previous inspections. Asked him what they were doing. They mentioned that they were about to leave to go pick up some waste that was taken off-site mistakenly. Don't really know, that was kind of confusing to me. I was kind of thrown off by that, but I said, okay. Almost immediately I looked up to the side of the building and said, well, Albert, what's going on up here? Is that your containment? He acknowledged that, and I proceeded to ask him if I could have consent to enter to go up and conduct an inspection. He said yes. So we went up to the site and to further the inspection.
What did you think you saw on that 3rd floor window?
Like a critical barrier that had failed and had fallen down.
And did that give you any concern?
It was definitely concerning because the job was in active abatement stage. And when you have a critical barrier down, there's a chance for asbestos fiber migration and contamination to spread from the active work area to other areas outside of the active work area.
And during your inspection, which floor did you inspect?
I was inspecting floor 3. Well, yes, inspecting floor 3, walked up through the 1st, 2nd, and got to the 3rd floor.
Excellent. Thank you, Mr. McGowan. For those of us who might not do this day in, day out, who haven't done over 1,000 inspections, can you give us a little bit of an idea of what you see when you get to an active abatement site like this? What does the containment look like? What is that process?
Yeah, every job is a little bit different. This one,
wanted to do an inspection randomly because of the magnitude of this job. There was a severe fire that did occur on a portion of the third floor. In a job like this, it requires what we call a full containment. That's for friable asbestos abatement. And it's a very highly engineered and regulated work area. I think I can equate it to like, maybe like the movie E.T. where you like see, a bubble and they have to go into these containments. It's not that same, but it's similar where you have a decontamination unit. You have an area that's completely sealed in plastic sheeting. You have negative air machines that create a vacuum, making sure everything goes into the containment. You have devices to measure your negative air pressure. But realistically, I mean, it's very highly regulated to prevent fiber migration and asbestos contamination from escaping the work area.
Thank you, Mr. McGowan. Turn your attention to the slideshow here, Joint Exhibit 8 is page 11. Can you describe what we're looking at?
Yeah, this was a side view of the decontamination unit that was installed at the work site. On the far right of the photo is this small clean chamber behind the wooden studs right there, which there's a picture of the shower with the red and the blue hose. There's the water heater below. And then there's a third and final chamber called the equipment and dirty chamber. That is to the left of the shower. So this is a decontamination chamber or a variation thereof. And these are really important because this is how anybody and everyone is supposed to enter and exit through and get into the containment exit out of the full containment. Individuals have to completely strip down naked in a clean room. They have to put on their protective suits. They have to put on their protective respirators. Any additional PPE, personal protective equipment that they have to wear, they have to don that in there. They would proceed through the shower, not taking a shower at that point, but proceed through the shower to get to the equipment and dirty room. And then they would be entering into the work area itself. So, very highly regulated way to enter, the way to exit, basically almost opposite of that. In that third and dirty equipment chamber, that's where you would be stripping your suit off, leaving all your respirator on, proceeding to the shower, showering off, washing your hair, using the soap, taking off your respirator at that point, and then exiting out into the clean room where your clothes should be located, towels should be located, and you would be storing your personal protective equipment there, drying off and redressing, and then you would be able to leave, that site and do whatever else you need to do.
Thank you, Mr. McGowan. Can you help the commission understand why that extreme level of precaution for both sort of the containment, negative air pressure, and the decontamination unit is so important on a site like this?
Well, it's very important because asbestos is a known carcinogen, and in a job like this, and with a friable asbestos abatement taking place, you have to contain the work area. You have to contain it to prevent, exposure and contaminations from spreading outside. So it's very important that these procedures are in place to make sure that you're not contaminating anything else and it's staying with it.
Thank you, Mr. McGowan. I'd now like to turn to the 3 alleged violations against Edge at the Pine Creek apartment. Let's start with the allegation concerning section 3J3. I'd like to remind the commission and the witness that the commission has already determined it to be undisputed that Edge was in the phase of asbestos abatement in apartments located on the 3rd floor of the building. The commission has also determined it undisputed that on the day of the inspection, the containment had collapsed and lost pressure. Mr. McGowan, given those established facts, can you help us understand what is used to measure and record pressure differential at a containment site like this?
I can. The device is called a manometer.
And how does, what function does a manometer serve in this role?
The manometer does measure the negative pressure from inside or the differential pressure between the work area and outside of the work area.
Was there a manometer on site the date of your inspection?
There was a manometer on site.
Showing you what's been marked here as Joint Exhibit 8, page 3. Is this the manometer was on site that day?
That's correct. I did take this photo. Unfortunately, there's a light right there, but yes, I did take this photo.
And was this manometer functioning as required under section 3J3 when you arrived?
No, sir, it was not. It was first and foremost, the negative pressure had not reached the appropriate level that is required to be maintained throughout the project. It was reading negative 0.002 inches of water column. The minimum requirement would be negative 0.02 inches of water column and must be maintained as soon as they establish negative pressure until they tear down the containment after they've passed final clearances. In addition to that, the manometer is required to be recording the negative pressure from the very beginning when they establish it until they've passed clearances. This manometer and the equipment they were using, they did not have a recordable strip chart. There was one present, however, it was not in operation, it wasn't working, there was no paper, and it was not printing. In addition to that, the time was off, and there was no location programmed on the manometer. And that's really important because the location ties it back to the job itself. So if anybody were to question if they have any issues with negative pressure or if anything were to have failed, then they could have this evidence to prove that this was taken on this site. This is how long the pressure was down. This is what the pressure was recording. And there was nothing on this one that had any of that information. In addition, there was a thumb drive capability there, but there was no thumb drive, no flash drive, and no documentation.
Mr. McGowan, is it your understanding that each of those features is required under section 3J3?
Yes, sir.
Is it your understanding that maintaining negative pressure is required by 3J3?
It is.
And at your inspection, did Edge ever provide you any historical information about the negative pressure of containment that day?
No, sir, they did not that day and not any time after.
Did you ever ask for it?
I did.
And is it your understanding that 3J3 does allow for an equivalent technology to a strip chart reader?
It definitely does. It states that in regulation. However, in this case, no equivalent measure or any readings at all were ever presented to the division.
Would the USB function as an equivalent if it were working?
If it were working, I believe yes. If they could provide us with that, we would have accepted it.
Was it working that day?
There was no capability and the supervisor had no knowledge of how to do it, did not have a flash drive and had no way to access any of that information.
Thank you. I'd now like to move on to what Edge did in response to that loss of negative pressure. Is the loss of negative air pressure at containment on a project like this an urgent issue?
Very urgent.
Why?
Because under an active abatement containment, if your containment fails and pressure drops, there's a great potential that asbestos fibers and contamination can exit out of the work area into areas that should be accessible to the public or could be accessible to the public or workers or anybody else that's going to be entering the building or around the site.
When you inspected the Pine Creek apartments, do you recall any evidence of a major storm the night before?
I do not recall any evidence of that. No, there was no downed trees. There was no evidence of moisture. I remember it being an absolutely beautiful day.
And when there is a loss of negative pressure, what does Regulation 8 Part B require a general abatement contractor to do?
When there's a loss of negative pressure, the requirement of the regulation states that they must maintain it throughout. So if they were to lose pressure, then they should immediately get that back up to pressure because of the requirement to maintain that at least negative 0.02 inches of water column be maintained. So they should act immediately to get that up.
Remind us, when you arrived on site that day, what were the Edge workers doing?
The Edge workers were in the parking lot getting ready to leave, and that was stated directly by Mr. Moda.
And are you aware whether or not they had checked the manometer earlier that day?
I'm not aware that they checked anything until I went up there and brought that to their attention.
Are you aware of any facts that would suggest edge workers attempted to repair the damaged containment before you arrived?
No, sir, not at all. They were in the parking lot.
And once you identified the loss of negative air pressure, about how long did it take Edge to restore it?
It wasn't that long. I don't really know how long because I was speaking with Mr. Moda at that point about some other issues like the project design and some things that we were discussing. That was one of the first things that I went to the manometer. Mr. Moda was there as well, observed the manometer, the photo that you mentioned and that I took, and said, hey, you got to get the pressure up immediately because this is an active abatement containment. At that point, he sent a worker in and the pressure was reestablished at the appropriate levels prior to me leaving the site that day.
Based on your experience as an inspector and the thousands of inspections you've conducted, did Edge's actions to restore the loss of negative air pressure compare with or comport with the actions of other general abatement contractors in similar situations?
Well, once I went up there and identified the issue and spoke with Mr. Moda, I would say yes. They reacted almost immediately and they were able to get that pressure back up. However, I would have expected them to do that already because, they need to be maintaining it and actively ensuring the integrity of their containment at all times.
Thank you, Mr. McGowan. I'd now like to turn to the alleged violations concerning the clean room on site that day in section 3K1A. You've already given us a great description of what a clean room serves. Can you give us a brief description of what the clean room you found on site that day?
Yes, sir. It was a very small clean room, would not meet the regulations requirement of being adequately sized for the size of the crew. It was approximately 3 by 3 square feet. We kind of use that term because most of them are around there. I didn't necessarily measure it, but I said approximately 3 by 3 square feet. So very small. And the regulation does require that it be adequately sized for the crew so they can store their clothes, so they can store their PPE, so they can be able to undress and be able to proceed through the decontamination chamber and also exit out, ensuring that they're not exposing themselves to anybody outside of the area, as well as making sure that any type of contamination and everything stays inside the room.
Thank you, Mr. McGowan. Showing you Joint Exhibit 25, page 30. This is designated language from Mr. Moda's deposition. Here he indicates that usually our guys will put them in black bags or not leave them in bags and put them on top of their work boots per se, but not really inside, talking about the clothing of workers in a clean room this type. Is this what you would expect to see from workers at using a 3 by 3 clean room?
Using that size clean room, definitely, because there's no room inside of the clean room to store anything.
Thank you. I'd now like to move to the allegations concerning section 3Q and the critical barriers that were left in place. Can you please explain your understanding of what Regulation 8 requires a general abatement contractor to do with critical barriers at the end of an abatement project phase?
Yeah, at the end of the abatement, 3Q is after they've passed final clearances, which include the visual and the air clearance. So they've received that written notification that they can tear down the containment. They are required to dispose of the critical barriers containing components as asbestos contaminated waste because the clearance criteria does not require that it be completely free of asbestos contamination. Therefore, there is the possibility that there's asbestos contamination on those critical barriers. And we want to protect the environment, and get those disposed of appropriately. So that's what the requirement states. That's what the regulation states.
Thank you, Mr. McGowan. To reiterate, this is Joint Exhibit 38. This is a language from Regulation 8 Part B, Section Q that you just described. Next, I'd like to turn to some photographs you took at the site that day. Can you tell us what we're looking at in Joint Exhibit 8, page 23?
Yes, this was a photo that I took. This was in an area that they had already completed abatement. There are some contents that were placed there. And then there was also critical barriers still installed next to the roofing joist where the rafters and the roofing joist met.
Thank you, Mr. McGowan. There's a laser pointer to your left there. Would you mind highlighting for the commission what you're talking about when you say critical barriers?
Yes, just the top button. Okay. Oh, nice. Right up here, this is where the critical barriers were installed. You see red containment tape, you see the polyethylene sheeting, and they're placed, these critical barriers are taped up in between those ceiling joists.
Thank you, Mr. McGowan. Now turning to page 15 of Joint Exhibit 8, a little bit dark in this photo, but can you point to what drew your attention to this photo?
Yeah, this is another photo that I took while I was on site, kind of the same locations up here next to the ceiling joists adjoining with the rafters. That's where those critical barriers were still installed, and this was an area that was previously abated.
And here we can see the roof. Is this an area where fire damage had destroyed the roof?
No, sir. This was on the east side of the building. There was not heavily damaged fire at all here. There are critical barriers still in place.
And like your optometrist, I'm showing you another photo here, maybe a little clearer. Joint Exhibit 8, page 14. Can you explain what we're looking at here?
Yeah, this is to me a little bit better, clearer picture that I took of these critical barriers that were still in place. You know, it takes some effort to do this. I've done abatement. I've installed critical barriers. This stuff takes time. It's very intricate right there to make sure that they're in place and that they stay in place. These appear to be old. They appear to have some have delaminated from the roof deck, as well as they were dusty and dirty. So yeah, that's just another photo that I took.
Thank you. And commissioners, these photos are showing up quite dark on the screen. This is in the Google Drive at Joint Exhibit 8, page 14. You can see a little more clearly what Mr. McGowan is describing. Finally, Mr. McGowan, a couple more photos here. Can you explain what you saw in these photos and what conclusions you drew?
Yeah, these were some of the representation of the critical barriers that I noticed when I walked up onto the third floor with Mr. Moda. I recall asking him directly, are these critical barriers? These are areas that, you know, were already under abated. He said that this was his first day on site and that he could not answer that question. I said, okay, well, they definitely look like critical barriers, and they're areas where critical barriers would be installed. And then we proceeded on with my inspection.
I want to follow up on what you just said. Why would these and the photos before be in areas where critical barriers would be installed?
Just like the critical barrier I observed on the exterior, on the window of the exterior that had fallen down, they're air passageways. Okay, so these are air passageways where air could go in and out of the work area. So therefore you have to, per regulation, cover those with critical barriers to prevent that air exchange from those locations.
I'm sorry. Right here, this is Joint Exhibit 8, pages 16 and 18. Just one last time, if you would, again, Joint Exhibit 8, page 14. You mentioned that these are areas where they would block air transport. To your understanding of what you saw on that day, would there be any other function here?
No, these were not, to me, not serve any other function. They weren't in an area where moisture intrusion could get to. There was no hole in the roof. There was none of that. And same with the other ones, like they weren't preventing any moisture intrusion. You know, earlier I was sitting there talking about, you know, other things like, I don't know. I just, I feel like it was only critical barriers. They were only serving that purpose. Actually, it was during Mr. Cross's opening statement about the smells and things like that. I did not notice any smells or anything. So, you know, all I could say and conclude that they were critical barriers.
Commissioners, give me one moment, please. Mr. Mr. McGowan, just one last question. This photo here, Joint Exhibit 814. Would you have any reason to believe that there would be smells infiltrating to the interior from that location?
No.
Thank you. Nothing further.
Thank you. Mr. McGowan,
Hello.
met before?
We have.
I took your deposition some time ago. During that deposition, I asked several questions. I've got a copy of your deposition if you need to look at it. Just ask at any point.
Thank you.
You said you met with Mr. Moto when you did your inspection, correct?
Yes, sir.
You had run into Mr. Moto before, correct?
I had inspected some of his job sites. Yes, sir.
And you were familiar with him enough that you were on a first name basis with Albert, correct?
I did, yes.
All right, and I asked you during that deposition if you had good interactions with him. You did, right?
Yes, I did. He was very cordial on site.
And you believe that he was a truthful person?
I had no reason to believe that he wasn't.
And that's based on prior inspections that you performed on his project, correct?
That's correct. And his overall attitude when I arrived on site.
Okay, and when you arrived on site, he had just arrived on site as well, correct?
I have no idea.
Okay, any evidence to suggest that he had been there that morning or anyone from Edge's crew had been there for a substantial amount of time that morning?
I have no idea.
Okay, when you arrived on site, there was no removal of ACM taking place, correct?
They were not actively removing ACM, but the containment was an active abatement.
Sure, and that two different things, correct? I'm asking, did you see anyone actively performing gross removal?
No, I did not.
Nobody was in Tyvek suits, correct?
No, they were in the parking lot.
Nobody was in the containment, correct?
That's correct. Nobody was in the containment.
We talked about we saw some pictures up there. We'll look at others maybe now or during closing. That you do agree that this building had been ravaged by a fire. Is that fair to say?
Yeah, there's a substantial fire on the third floor of the building.
And that's where the work was being conducted, correct?
Not at this time.
Okay. There were holes in the roof of the third floor, correct?
There were holes on a different area, but not the areas that they were working on.
Okay. We talked about, I mean, I think I said this in the opening statement, everybody would agree. Well, we'll get to that in a little bit. Let's talk about negative pressure for a second. And the failure of the containment. I thought you said when you were testifying to council that you saw that there was no evidence of a storm when you showed up that day.
I did not see evidence of a storm. That's correct.
And Mr. Modis testified separately. Have you taken his deposition or have you read his deposition at all?
I did read it.
Okay. Have you read all the depositions in this case?
I have not.
Mr. Modis, though?
Yes, sir.
Read Mr. Cox's deposition?
I did not.
Okay. Mr. Moda testified during his deposition that the reason why that they had to put up, or the reason why the containment had collapsed was from weather the previous evening. Did you see that?
I did see that.
Okay. And I asked you during your deposition if you had any reason to dispute that. Do you remember what you said?
I don't recall.
Do you want to look at your deposition?
Sure.
I'll go. May I approach the witness? At my own risk?
Watch out.
There you go.
Thank you.
Can you go to page 76, please?
Yes, sir.
I'm on line 5. My understanding is that this was a fire loss that caused the exterior of the building to be breached, had holes in it. Do you have any reason to dispute that? Do you?
You said 75 or 76?
76,
And row 5. correct?
line 5, correct. My understanding is that this was a fire loss. It caused the exterior of the building to be breached, had holes in it. Do you have any reason to dispute that? You said, I don't recall, correct?
It says I don't recall.
And then the next question was, okay, and then my further understanding that overnight there was bad weather and wind penetrated into the top floor of this building, caused the critical barriers to fall down or come out. What was your response?
The response was, I have no idea.
You don't know one way or the other, right?
Pertaining to what?
Whether the weather caused the critical barrier or the containment to collapse.
Well, we were talking about the bad weather, and you're talking about the critical barrier that I noticed with Mr. Moto when I pointed that out to him.
Yes, it says, and cause critical barriers to fall down or come out.
Because you had first started and you mentioned, my understanding is that a fire loss that caused the exterior of the building to be breached and had holes in it. So I'm confused. Are you asking me about the critical barrier or are you asking me about the holes?
I'm asking about the containment that was collapsed that day.
Okay,
Do you have any evidence to suggest that was not caused by weather?
I do not.
Okay, that's the point I'm trying to make. And I asked you, we talked about that a little bit. Is that something that happens sometimes for a critical barrier to lose pressure?
Yes, sir. The critical barrier can fall down.
Okay. And then when that occurs, it's up to GAC to try to reestablish pressure as quickly as possible, correct?
Yes, they need to do that.
And when you inspected, Edge was with you, they very quickly did so, correct?
After I identified the issue, they went inside and fixed the critical barrier.
Okay. We saw a picture of a manometer on site. Edge had an OmniGuard manometer in place, correct?
That's correct.
And that stores the data electronically
I'm not sure if that did or not.
with a normal manometer would, correct?
It depends on the version and if they know how to use it.
Okay. And you can hook that up to a printer and print out the data as well,
I
correct?
do not know. I have not done that.
Okay. Did you see a port for printing?
There was a flash drive USB port on that, but I don't know if it's for printing. I think it's for obtaining the documentation or the readings from the manometer.
Okay. It had been reset, correct? It wasn't programmed, fair to say?
No, it was on when I walked up and inspected it.
Okay, the power had come on. Do you have any reason to dispute that there was, well, let me set the context. Mr. Moda testified that there was a power loss overnight and that there have been several power losses on this project. Did you see that in his deposition?
I did see that.
Do you have any reason to dispute that?
I have no idea about the power at all, so no reason to dispute it.
Okay, and you agree with me that a power loss can cause a manometer to reset, correct?
Yes, I do agree that that could happen.
And Edge also had a backup manometer in place just in case reset caused a malfunction, correct?
I don't know if that was the reason why they had it, but when I inspected and the manometer was not appropriately functioning and programmed, they went ahead and grabbed a manometer and plugged in a new manometer.
They had another one on site for this exact reason.
Yes, they did. Well, don't know for that exact reason, but they had another one on site.
Okay, and you talked about, you requested the data and they weren't able to provide it, right?
That is correct.
Okay, and they told you during the discussions following your inspection that the manometer had been stolen that evening, correct?
Yes, in an email thread, one of the Edge representatives mentioned that they had that manometer stolen.
And do you have any reason to dispute that?
I do not.
Okay, and are you aware, I mean, have you gone through the exhibits in this case, including Joint Exhibit 12, which is a police report for that?
I have not looked at that.
See Mr. McModa's testimony that this was a vacant building, they had problems throughout with things being stolen.
I did see that.
Any reason to dispute any of that?
No reason to dispute it.
You agree with me that there is no requirement specifically in Regulation 8 that says a general abatement contractor has to print out the data every single day, correct?
They have to be recording it and they have to
Maintain it.
They may have to maintain it, correct?
But Regulation 8 doesn't require that they print it in hard copy every single day, correct?
They have to be able to, the division has to be able to reference that, to be able to understand that they've maintained negative pressure. So they have to have that available and they should be.
I understand that. My question to you is very specific. There's nothing in Regulation 8 that says that a general abatement contractor has to print it out every day, correct?
No, that's correct.
Talking about the clean room, you said it was a very small clean room. It was a 3x3 pop-up, correct?
Approximately correct.
And you're familiar with that 3x3 pop-up, correct?
Yes.
You heard it in my opening statement. I've mentioned this in a lot of things I've filed before this commission. That was permitted by the division for 20 years, wasn't it?
Yes, that was.
Since
I don't know 20 years, but I haven't been here that long.
You'll defer to Mr. Burns on that, on whether it's 20 years.
If you're asking that question, I guess so.
But ever since you started being an inspector, that size clean room was allowed, correct?
Well, when I started until the regulation changed.
In March of 2021, correct?
Yes, sir.
All right. And when I asked you if any language in the regulation changed, you said you did not recall any of the language actually changing, correct?
Yeah, not substantially, no.
All right. It was just the enforcement of that language, correct?
That's correct.
All right. And that was 3 months before this inspection, fair to say? That change?
When it was, I believe adopted, I think, yeah.
Okay. And following that adoption of that enforcement policy, you ran into contractors who had not become aware of the change, the reversal of 20 years of policy, correct?
I had definitely inspected jobs, where there were pop-ups installed as a clean room.
After March of 2021.
Yes, sir.
Contractors had not become aware that the division had reversed this policy.
I don't know if they were aware or they just didn't change what they were doing.
And I asked you during your deposition, is it fair that some people might not have gotten notice that if they've been using that for 20 years, the division reverses its policy, but not the actual language of Regulation 8, you could understand that there might be a slight learning curve there.
Can you shorten your question a little bit for me?
I wish I could. That was the exact
Okay.
question I asked you during the
Okay,
deposition.
so, you just mentioned that, is it fair that, can you just repeat it real quick?
I asked if you could understand that how a general abatement contractor who had been using that same 3x3 pop-up on thousands of projects for decades might not get the information, and it might be a learning curve that to find out that the division no longer allows 3x3 pop-up chambers. Do you remember what you said?
Objection calls for speculation and enters facts not in evidence concerning the number of times edges use such a pop-up.
Yeah, I mean, I think that it's a long question, but Mr. Cross, will you state your position on that?
I mean, I can just, if we want to, I can just read the exact question I asked him in the deposition. I was trying to avoid that for the sake of time, but I'll re-ask the question. Can I have you go to page 129?
121?
129.
29.
I'm sorry. 118. I'll read the question, you read the answer. And again, I apologize, I ask long questions. My question was, I mean, I think you would agree with me, when there's a change like that, there's gonna be somewhat of an adjustment. If, like, say, Alberto Mota, I know he wasn't there throughout the course of the project, but he's doing this job for a full decade. And that it's okay, that being the pop-up containment or pop-up clean room has been okay with every inspector for a decade, and then all of a sudden they change it without changing the language of Regulation 8. You can understand why a few people might not recognize there had been a change. What was your answer?
My answer was I could understand that.
Okay, and you wouldn't recommend enforcement on that basis alone, fair?
At that time, that's definitely fair.
Okay. Regarding the critical barriers, we agree, everyone agrees, that if those were part of prior containments, it would be wrong to leave those behind. It's considered by the Regulation 8 to be asbestos-containing material, correct?
Asbestos contaminated, yes.
Okay, it has to be destroyed, but it would not be a violation if, well, first, let me give you the context. You saw that Mr. Mota said that that was used to mitigate odors, correct?
No, he didn't say that. Or you said I saw that?
In
Or
his
he told you
deposition.
that?
I'm talking about it in his deposition.
Okay, because he didn't say that on site. I don't recall.
If he, let me just then put it in hypothetical. It wouldn't be a violation of Regulation 8 for a general abatement contractor to use poly to cover penetrations to mitigate odors, correct?
It would not if they were not used as critical barriers.
Same for penetrations in the walls or to keep out wind and rain. That would not be, if it's fresh poly, it wouldn't be a violation, correct?
That's correct.
Okay. And you don't actually know that the poly that you saw that day was actually from an old containment, correct?
I do not know, but it was intricately placed and in areas where critical barriers would be installed, and it seemed, like they were, and kind of odd that they were installed in a way that they were installed, because if they were preventing moisture or water intrusion, I don't know why they would have installed them specifically, on the rafters next to the joists and all that, like the way they did.
Can you say, and I asked this exact same question, to Mr. Burns, and I'll probably do so again when he gets up there. Can you say definitively that there was no wind coming from behind that poly that was shown in the photographs? You have evidence to
I
say-
don't know how you can see wind in that photograph, but
Not saying wind, I'm saying when you were on site,
I said wind.
I know.
Didn't you say wind?
I did, I'm not saying whether you saw it,
Oh.
I'm asking if you have evidence that no wind, I mean, when you got on site, can you say definitively that no wind could have possibly been coming from behind that poly?
I do not know.
Okay. Those are all my questions. Thank you.
Any redirect?
Briefly. Thank you, Mr. McGowan. Just a couple of quick questions. Did Edge ever present any concrete evidence from the manometer or otherwise to establish when containment had been lost?
No,
Why not?
they did not have a printout, a strip chart. They had no paper in their manometer. They had not recorded or obtained the documentation, or excuse me, the information about the negative air pressure from the manometer. I recall Mr. Moda not even knowing how to do that. So no documentation of any negative pressure was ever presented to me or the division.
Thank you. And from your understanding concerning the critical barriers on a project like that, from your experience, is that reinstallation of barriers something that would be documented by the general abatement contractor?
I would expect it to be.
And why is that?
Because, well, when I was a supervisor, anytime I had any fluctuation or if a critical barrier fell, I automatically would write that in my supervisor's notes, relay that to my superiors, my superintendent, whoever it may be, make sure that we got that back up, record it when it went down, when it got back up, et cetera. So if the division or anybody else wanted to look at it, we would have that information.
And are you aware of whether Edge provided anything like that in this case?
I'm not aware of anything provided by them about that.
Thank you. Nothing further.
Commissioner questions? Mr. Slesky?
You said, when you arrived initially on the apartments, that Mr. Moda said he had been there for 2 hours. Is that right?
He did not mention to me how long he had been there. He said that I said, what are you guys doing? He said, we're about to leave so we can pick up some waste that was taken on site.
I thought you said you asked him how long he'd been there.
No, sir.
Okay. When you arrived, you saw the criticals, but they were hanging out the window, the ones that were down, the one that was down?
Yes, the critical was hanging at the side of the building, on the window.
And in your mind, were you thinking, oh, those are down, there's no negative pressure? You kind of thought that and wanted to go up and see.
That's correct.
So Mr. Moda didn't see that?
Not until I pointed it out to him. I mean, I don't know if he saw it, but when I mentioned and well, it's like, what do we have going on here? I said, that's an issue. Can we go upstairs? He said, yes, you can.
And he didn't even say, oh my God, or anything like that.
Not that I recall.
That's all I have from that.
Commissioner Rudolph?
Thank you. I have some questions about sort of the timing of all of this, because when you showed up, they were still doing active abatement, which is why it was a concern that the critical barrier on the third floor had failed. What I'm struggling with then is the requirement to take down the critical barriers. That's part of the other claim. Where were those barriers and why did they have to come down if the it were still in active abatement. Can you kind of walk through that for me?
Oh, without a doubt. Good question. The third floor was a large area. They were working on the far south side of the third floor. That was where the active abatement and containment was established. The areas where the critical barriers were observed were in other areas like the middle or to the north side of that third floor. So they had worked their way down to the south side, at least that's what it appeared to be, because their permit actually said they were doing the entire third floor, but didn't break it down by different sections. So those areas that had already been worked on, they still had the critical barriers in place, not the active. Those photos were not from the active abatement work area.
So there would be some sort of critical barrier between that part of the third floor that was still under active abatement and those areas that had been cleared?
Yes, ma'am. There is a critical barrier wall
Okay.
defining the work area from the areas that had already been worked on.
And is there a temporal requirement for when you must take down the critical barriers once you have finished? Or is it possible? I mean, I don't know what the requirements are regarding that. If there's, we'll just leave it at that.
Okay. The regulation under 3Q says after you pass final clearances, that's when you tear down your critical barriers and you dispose of them. And doesn't go into the amount of time.
Okay, thank you.
Couple questions here.
Commissioner Blankenship?
I have a question about the regulation requires the alarm function must be audible. It appears in this picture of the gauge that the audible alarm was deactivated because it evidently was not, you could not hear an alarm when you were there.
That's correct. The pressure was under the set limit for the alarm to go off, but it was not going off. The manometer was reading, well under that. However, it was stating waiting for pressure, which is it was not like armed per se, because it has to go over that to be armed. And then once it would drop under that, it would go off. So the alarms, that's an issue because when was it ever established to begin with?
Right. It appears to me in looking at this picture that there is a with a sound symbol emanating from it, and there's an X on top of it, which would indicate to me that the audible alarm was not engaged. Possibly.
Yes, if there's an X on it, yes, that would be correct.
Do these types of gauges typically have battery backups?
Yes, sir.
And was there any evidence presented that it was said that there was a power outage? Was there ever any investigation to determine if there was a battery backup and if it was operational? Do you know?
So the power outage, I did not witness any power outage.
Okay.
So I didn't investigate whether they had a battery or not.
Okay, but you learned later that they had indicated, or they have indicated that the reason the gauge wasn't functioning properly was because of a power outage.
Yeah, if that's what they said.
Okay, all right. But definitely these types of gauges typically have a backup battery.
I believe so, yes.
Okay, all right, thank you.
You're welcome.
Commissioner Milford?
Could you walk us through the sequence of turning on the second manometer and what the purpose of doing so was?
Sure. When I was inspecting the manometer with the supervisor, Mr. Moda, he couldn't get it to work. And I don't know why. So he just said, we have another one, we're just gonna swap it out. So at that point, he asked somebody to go grab it. They came back. He had already sent somebody inside to fix the critical barrier. And then, however long after, I don't exactly know the time, that manometer was reading and was working appropriately.
Yes.
So when you said the first one, he couldn't get it to work, we did see a display. What about it wasn't working?
Yeah, I think there was, issues with, actually, I don't know. I don't know really why they swapped it out because it was on and it was reading.
Commissioner Reader?
Yes, thank you. Following up, so when they swapped the manometer out, the second one was reading and showed the appropriate amount of negative air pressure when they hooked it up?
It was reading the appropriate amount of negative air pressure by the end of my inspection because they had fixed the critical barriers.
Okay, thank you. And the question I want to ask, for those barriers in the cleaned areas that you felt were left in place, when you saw those, since you know Mr. Moto from other inspections or anything, did you ever ask him, hey, Albert, what is that? Why are those still up? Why didn't you take those down when you took everything else down associated with the remediation and moved to this other area?
Yes, sir, I did. That was actually one of the first things because I noticed it after I walked up the stairs because it was in areas that had already been cleared. And he said he didn't know because it was his first day on site.
Okay, thank you.
Any other questions? Commissioner Thomas?
Now, when you have done other inspections, is temperature typically, hot temperature, typically an issue for containment, loss of containment? Does it present challenges for containment?
In my experience, the hot weather has more an effect on the individual because it's really hot and they can get exhausted. In terms of the containment in hot weather, I have not seen that hot conditions affect the containment or actually critical barriers from falling, because in my experience, the tape would be more gummy and would be still adhered. When it gets cold, however, that's when the adhesive properties would kind of tighten up and allow for them to fall. So that's my experience.
Thank you.
Commissioner Slutsky?
I'm really having trouble with this clean room thing and the requirement and the size and all. Is it possible that on a site, maybe not this site, but maybe this site, that a 3x3 pop-up would be okay? That would be enough?
Not in my experience, no. Because that's where you have to, completely get undressed. You have to have your towels, you have to have, respirator cartridges. You have to have maybe, your hard hat, whatever else it may be. And on a site where you have, a crew of 4, like all of that has to be in an area that's this big. And it just doesn't meet the regulation, doesn't meet the requirements.
Well, it meets the regulation.
It's not adequately sized to house the crew, the size of the crew, their equipment and their clothes.
Would it be enough for 1?
It's possible.
2?
No, not really. Not in my opinion.
I think you indicated that if this was the only violation, that maybe it would have just been a warning.
I would agree with that, especially given that it was, the same year that a couple of months after the regulation was changed and adopted.
So have you inspected other areas where this was the only violation and it was just a warning?
I would have to look through all of my notices of inspection. So I don't know, but usually at that point, they would build a clean room and get it constructed appropriately sized.
Sure. So this was added to the list of violations because, well, there were other violations and you were just, I'm asking.
Oh, great question. All of my observations are listed on my notice of inspection. So this was one of them. And then because it was listed on my notice of inspection. Then this gets, discussed and passed on to the enforcement team, who then decides whether, we need to put it in there. And so that's what happened. So I noted it and listed it.
Thank you.
You're welcome.
I have a question, Bill.
Yep, Commissioner Blankenship.
You mentioned, and you were the author of the notice of inspection. And you just mentioned that you handed it over to the enforcement team. And then ultimately there was a compliance determination letter issued in this situation. What involvement did you have in the process after you submitted the inspection, notice of inspection to the compliance team?
Our protocols are to discuss the projects with the enforcement team and go through the notice of the notice of inspection document, and go through that. And essentially at that point, then, collectively it's determined whether there's going to be any type of enforcement. And then basically at that point, it was out of my hands until I did and held and was part of the notice of alleged violation conference that was held on this. And then ultimately after that, that's when that compliance determination letter was issued.
So at any time, were you asked to give a recommendation of what action you believe should be taken?
I don't recall that.
Okay, thank you.
You're welcome.
Any further questions? Commissioner Arnold.
Thank you. And thank you for the testimony. On the picture of the manometer, wanting to make sure I have that all straight. There's a police report submitted as part of the record that says that the manometers were stolen the night before. Is that a picture of the one that was supposed to that replaced the ones that were stolen? Or is kind of help me understand that piece?
I haven't read the police reports. I read Mr. Moda's testimony saying that manometers were stolen. The photo that we showed up here was the one that was in operation when I first walked up to that containment area.
Thank you.
You're welcome.
Commissioner Reader.
Thank you. Just a quick follow-up from my earlier question. You said it was Mr. Moda's first day on site, so he couldn't speak to whether those were those things that you're saying were barriers left in place that Edge is saying may have just been rain, wind barrier, asbestos barriers versus weather barriers, I guess I'll call it. Did anyone from Edge ever get back to you to follow up to provide any more information on those barriers? Presumably there was a previous Edge project manager before Mr. Moda who would have known the answer to that.
Yeah, Mr. Moda was the supervisor on site. And again, he had mentioned that it was his first day. And when I read in his testimony, it appeared as though it definitely wasn't his first day, but that's what he told me. And then in terms of those barriers, I did, and I believe it's in the record, I sent an email along with my notice of inspection to Edge Environmental. And that kind of had, the notice of inspection and some additional information. I did receive a response from an Edge representative, I believe it was Matt Sloan, mentioning that it was critical barriers. And then I questioned him on that. And then he responded further saying, no, I made a mistake. I shouldn't have called them that. It was something else. And it was something to that extent. I don't have it in front of me.
Okay, thank you.
You're welcome.
Commissioner Arnold.
Thank you. Just a quick follow-up on that. You were saying that there was critical barriers in place on the third floor to make sure that they were taking care of the area that was active abatement. And these were pictures taken outside of that area that had already been abated. If there was wind leakage or air leakage in the parts of the third floor that had already been cleared, would it have a negative effect on the critical barrier on the I believe the south end that was still active?
Not that I'm aware of.
Okay. Thank you.
Any further questions? Commissioner Reader, I see your hand up. You have another question? Okay. Any questions based on commissioner questions from the parties? Division?
I just have a quick timeline. Just a quick timeline clarification. Mr. McGowan, is it your understanding that the theft of the manometer in question happened before or after your inspection?
It's my understanding that it was after.
Thank you.
Mr. Cross?
Yeah, very briefly, and EDGE representatives informed you that the actual manometer that was on place that day had been stolen.
You have a microphone?
Yeah, is that not working?
No, it is there.
EDGE representatives indicated to you that the actual manometer that was on site that day had been stolen, correct?
Yes, they did send that an email that that manometer had been stolen.
And in that, you referenced critical barriers, Matthew Sloan saying I shouldn't have said that. He was basically saying, we call poly critical barriers. It wasn't actually critical barriers. It was poly. I shouldn't have called them a critical barrier, correct?
I would have to look at the exact email.
That's all right. That's all I've got. Thank you.
In that case, I think we're done with the witness. Mr. McGowan, thank you.
Thank you, Commissioner.
All right, time is 11:38 currently. We're planning on taking a 30-minute lunch at around noon. Looks like we've got about 45 minutes excluding commissioner questions for the next witness. We have an option to take our lunch now or to go through that and then take our 30-minute lunch after that. Do commissioners have a preference?
I'd say let's get the lunch over with.
Okay. Man's hungry. Everyone good with that? Okay, that's what we'll do. We'll break for lunch now. Call it 11:40. We'll be back at 12:10. Okay, we will continue. Division, if you're ready to call your next witness, we are ready for you.
We are, thank you. The division would like to call Mr. Curtis Burns.
Mr. Burns, welcome. You swear the evidence you are about to give to the commission in this matter shall be the truth?
I do.
Very good. Extra, you may proceed.
Thank you, Mr. Burns. Commissioners, the division's expert Curtis Burns has submitted written testimony, which is marked as Division Exhibit 4 and Division Exhibit 26, both in your binders. He was also deposed by his counsel, and the designated portions of that transcript are in Joint Exhibit 44. Mr. Burns is an expert in asbestos remediation practices applicable to both sites in this case, and was designated as such. We are pulling up the presentation here as we speak, and I will dive right in. Mr. Burns, you've been qualified as an expert in this matter. Can you please tell us what your current role with the division and what you do in that role?
Yes, my current role with the division is I'm a field operations supervisor in the indoor environments program within Air Pollution Control Division. My roles and responsibilities is basically to train and teach the inspectors of the division on how to conduct compliance inspections. I also work with our admin staff and trying to keep the program going. I work quite a bit with the industry. I act as their technical resource. If they have questions, work with training providers to develop and improve curriculums. I work with the GACs or new GACs to approve GACs, general abatement contractors to work in our industry. Work with consulting firms to get them established to work in our industry. I've served on numerous task force, federal, statewide. Been involved with compliance documents, writing advisories. In my spare time, I assist in drafting language for the commission.
Thank you, Mr. Burns. If we could allow Ms. Higgerson to share, she has our presentation. Yep. While that's happening, Mr. Burns, can you please tell us how long you've worked in asbestos regulation here in Colorado?
Almost 35 years now.
And do you hold any degrees that would help inform your expert opinion today?
Yes, I have a Bachelor of Science degree in Environmental Sciences. Also have minors in Industrial Hygiene and Hazardous Materials Management.
Thank you. I'm not going to ask for your full 35 years of credentials, but can you give us an example of the types of trainings you've taken that inform your expert opinion?
Specific training in regards to asbestos, there are basically 6 disciplines in the asbestos industry. I've taken the training for all 6 disciplines numerous times, as well as I've sat in on those trainings, audited the classes, and once again, like I said, helped develop the curriculums. I've also had numerous trainings in regards to hazardous materials management and other things which would lend some of those aspects to the asbestos industry.
And are you familiar with Air Quality Control Commission Regulation 8 Part B?
Yes, sir, I am.
Can you tell us a little bit about how you're familiar with that regulation?
Yes, I got introduced to regulation number 8, Part 8 in 1991 and began to enforce that regulation on behalf of the state health department through a contract at the Tri-County Health Department. And since then, I think I've participated in all of the reg revisions from 1993 to now. I may have missed one.
In his, pardon me, in his opening, Mr. Cross talked about some of the specifics of Regulation 8 and things not being explicitly prohibited. And your understanding of Regulation 8, that it is intended to cover every single possible type of violation or act that might be a violation of the regulation?
No, sir, it's not possible. We never had that intent in drafting the regulations.
So what is the intent? What is the function of the regulation?
The regulation, well, first of all, the regulation is broken into 2 parts. What we call the regulated asbestos, which would be friable. And then we have what's considered non-regulated, which would be the non-friables. We, as the division, as the commission, we only authorize by statute to regulate friable asbestos. So friable asbestos in Reg 8, we go through a much more extensive information in terms of how to remove that or engineering controls versus the non-friables. So we only provide generalities in that sense because we didn't want to be over prescriptive in terms of telling the GACs what they do. We want to give them their professional freedom, if you will, to use their innovative skills to do what they need to do and comply with the regs.
And in your estimation, in your experience and expertise, where does that sort of professional judgment end and the regulations start as far as what might constitute a prohibited act?
Is there anything in specific?
In the removal of, well, specific to this case, the removal of asbestos containing material from a building, the size of a clean room, things like that that are pertinent to this case.
Yeah, so once again, when we begin talking about friable materials, there are requirements. So you mentioned the clean room. We did put more specific language in the regulate pertaining to a clean room. Whereas when we're dealing with a non-friable material, we, once again, left more general statements in terms of what you should do.
Thank you. Before I turn to the specific violations in this case that have been alleged against Edge, preparing for your testimony, can you give us an idea of what materials you might have reviewed?
Yes, since I was brought in a number of months ago, I've read several of the depositions provided by various parties of the case. I've read the notices of inspection from Mr. McGowan and Mr. Wolf. Read the compliance determination letters generated by the division. Read some EPA documents, read our regulation, our statute, and a host of other documents I can't think of right now.
And Ms. Burns, would you tell us, were you here sitting in the room today and hear the testimony of both Mr. Wolf and Mr. McGowan?
I was.
Thank you. Moving into the alleged violations at the Eagles Nest facility, are you familiar with the allegations there?
I am.
Thank you. Would you explain to us the difference, as you understand it, in Regulation 8 between friable and non-friable asbestos-containing material?
Yes, I can. Actually, Jeff Wolf did a great job in giving me the definition. Friable materials are materials which, when dry, can be crumbled, pulverized, or reduced to powder by hand pressure. And for those who are not familiar, a great example would be like the ceiling tiles above your head. That's a solid material. However, that's the type of material that you could put in your hand, apply pressure, it would either crumble, right, pulverize, or reduce to powder just because of the nature of the material. A non-friable material are things which cannot be crumbled by hand pressure. An example of that would be like the floor tiles, which are in the hallways or the bathroom, or the siding, the transite siding that we're discussing today, or transite water pipes and other examples I could mention, but we won't waste your time.
Thank you. And taking that next step further, next slide, please. Thank you. Are there conditions in which non-friable asbestos-containing material can be rendered friable?
Yes, there are.
And for the record, I'd like to point you to Joint Exhibit 38, page 125. This is the statement of basis and purpose for Regulation 8 Part B that was adopted in January 2021. Mr. Burns, would you please walk us through your understanding and experience of how a non-friable material can become friable?
Yes, I'm sorry. Council, did you say exhibit?
Joint Exhibit 38 should be in the large binder there. I know the language on the screen is a bit small. I apologize.
Yes, okay. So actually 38 has the entire regulation. There we go. Yes, sir. I'm sorry. Now, repeat your question, please.
Yeah, and can you please explain to us your understanding of how a non-friable material such as transite can be rendered friable?
Yes, in Regulation 8, in a couple of different sections, one that you have up on the screen right now is the statement of basis, but also the definitions of non-friable. We give examples in terms of how a non-friable can be rendered friable. That would be grinding, sanding, drilling, cutting, or grading. Those are examples, but those are not all inclusive on how a non-friable could be rendered friable.
How else might that happen?
There are some non-friables could become friable just through age, deterioration, impact, such impacted by what we call a catastrophic loss, like a fire. Fire will burn a non-friable, which will basically burn away the binders and release the asbestos fibers, which would then make it friable. If we're talking about transite sheets or something of that nature, you can hit it with a baseball, smack it with a hammer, cut it with a saw, or even hailstones, depending upon the age of the siding and the size of the hailstones.
Could breaking transite off the side of a building render it friable?
Breaking it off, if you just use the word breaking it off, Could you elaborate on that for me?
Breaking it without removing nails, breaking it into smaller pieces as you're pulling it off the side of a building, perhaps with something like a flat bar?
Yes, it is a strong potential that the material could be rendered friable.
And what about dropping it 20 feet to the ground?
Most likely that would render it friable.
Thank you, and I'd like to, does EPA, Division Exhibit 28, pages 19 and 20,
Thank you.
for those who don't have Clark Kent's sight. The glasses are for show, for writing. All right. So, Mr. Burns, while you're finding that, would you mind telling us whether EPA has addressed the question about whether or not transite can be rendered friable by dropping it to the ground?
Yes, I can. EPA actually issued what was called a determination. And just to back up, give that a context real quick. EPA has a website that they maintain, which is called the Applicability Determination Index. And this index is a repository information where people can write into EPA with inquiries or ask for clarifications. And EPA has issued a number of documents over the years in terms of how to handle or impacting transite materials. And what you have on the screen right now will be a document with a control number of C108. And it talks about dropping transite from a building. Commissioners can read it. Do I need to read it?
I can read it out loud for you there.
Okay.
Dropping category 2 materials such as transite panels from a building as a means of transporting it to the ground will also cause the asbestos, the ACM, asbestos containing material, to be regulated in most conditions. Is that your, oh, sorry, the microphone wasn't on. Is that consistent with your expert opinion on how transite might be rendered friable?
It is.
And is this consistent with the language and the purpose of Regulation 8 Part B?
Regulation number 8 Part B does not state that per se, but it is consistent with the intent, yes.
And is it consistent with the commission's finding and statement of basis and purpose?
It is.
Thank you. I'd like to turn your language to some additional language from that same guidance from the EPA. This is Division Exhibit 28, page 19. Here it says the extent of breakage, which would normally result from carefully removing the transite panel from a building and lowering it to the ground prior to demolition, would not result in crumbling, pulverizing, or reducing the panel to powder. Is this consistent with your understanding of what might not render something friable?
It is.
And is this consistent with your understanding of Regulation 8 Part B and its treatment of friable material?
It is.
Finally, one last piece from this exhibit. This is page 19 again. It states the extent of breakage which will render the ACM friable depends on some degree on the condition of the ACM prior to the abatement operation. Can you explain what this section is talking about?
Yes, I can. There are some forms of asbestos, what I would call in their functional state, may be in good condition, if you will, or when it was manufactured, it was in great condition. But over a period of time, the integrity of that material could actually change. So as an example, we're talking about transite siding. You're talking about a cementitious material, which has been out in the environment for at least for 40 years now, because we stopped manufacturing and installing transite quite a few years ago. But the simple fact that it's been sitting out in the environment, exposed to the elements, the sun, the rain, freeze thaw over the years, it could actually weaken the integrity of that transite, which would make it more susceptible to becoming friable if impacted or just in its natural state on its own. It could actually begin to slough, emit fibers just because the binders have begun to break down.
Thank you, Mr. Burns. And I note this is not division guidance. This is from the EPA. Can you help us understand why EPA guidance on issues like asbestos contained in this guidance would be relevant and important to the Colorado's regulation?
Yes, absolutely. As the commission may know, EPA came out with a document years ago called the NESHAPs, National Standard Hazardous Air Pollutants. As part of that section, there was an asbestos section. Back in 1985, Colorado was one of the first states that were able to put together a program in terms of Reg 8 that the EPA found acceptable. And the EPA delegated their authority to us, to the state of Colorado, to enforce the NESHAPs. But as part of that condition, Reg 8 had to be at the minimum standards of the knee shots. So we have to basically enforce and walk the line, if you will, of what EPA does to meet their minimum. And so because of that, we respect their guidance documents when they put them out.
Thank you, Mr. Burns. I'd like to now turn to the language of Regulation 8, Part B, Section 3S2. Can you describe generally what this section addresses?
Yes, 3S2 is a section that talks about, as you see, asbestos cement products. But to give that some context, Section 3S actually applies to what we consider special materials or special conditions, and 3S2 is specific to cement products.
And under 3S2, does a project that handles non-friable material versus one that handles friable material different?
Yes, it is.
What are the major differences between those types of projects?
I would draw your attention to the last few lines of this paragraph. I mentioned early on that there was a big difference with friable materials. One, that's the only authority we have to regulate is the friable materials. But in regulating friable materials or dealing with them, you have to be a certified company using certified individuals, which means they've been through some training, depending upon which discipline they're working in. The certified company, once again, has to be approved by the division. They have to submit a notification form to the division outlining how they're going to remove the asbestos in accordance with Reg 8, as well as follow the engineering controls and work practices established in Section 3. So that's for friable materials. Non-friable materials, you do not have those requirements so long as you keep it non-friable. Now I want to draw the distinction as to why, all right, because friable materials, when they're handled, they have a greater potential for releasing fibers into the atmosphere. Whereas non-friables do not because of the way they're manufactured. So that's why there's more emphasis on friable materials in Reg 8 versus non-friables.
Thank you. And during a project, is it possible for one to start as a non-friable removal, but then become a friable removal project requiring those more stringent requirements?
Yes, sir, it is.
Thank you. I'd now like to turn to the alleged violation of Section 3S4, specifically looking at 3S4C as it relates to the removal of material carefully with minimal breakage and disturbance. Can you please explain to us why removal of non-friable material in this manner is important?
Yes. So the reason why you only see one line, once again, for non-friables is because we don't have the authority to add that specificity or that prescriptiveness in terms of how to deal with it. So what we wrote in the reg is just basically to handle it carefully. Because if you handle it carefully, that will not break up the material, which will then going to emit asbestos fibers.
Thank you. And for the record, this is Joint Exhibit 38, page 69, Section 3S4 of Regulation 8, Part B. And what does minimal breakage mean in this context?
Simply stated, as few as possible.
And would this standard apply to transite siding?
It would.
And is it possible to remove transite siding carefully and with minimal breakage from a building?
Yes, it is.
In your opinion, at what point would removal practices no longer be considered careful and with minimal breakage?
In the particular instances of this case, dropping them from an elevated level, not properly removing the nail heads or cutting nail heads, flipping the shingles off intact or in large pieces if possible, that to me would demonstrate that it's not being handled carefully.
Thank you. And to that end, Mr. Burns, I'm showing you Joint Exhibit 27, page 156. This is something that Mr. Wolf testified to earlier. Drawing your attention to the bottom there, the language concerning the work practices. Maybe a tough one for me to read too.
Yeah, I'm not Clark Kent, so let me say 27, sir.
Yes, sir. Joint 27, page 156. Mr. Wolf read this into the record earlier. I won't repeat it verbatim. Here, Edge indicated that its intent was to keep the transite siding non-friable throughout abatement. And as transite is nailed to the building, we will be pulling nails or clipping the heads of the nail and pulling the transite off in entire sheets. Can you help us understand why that work practice and that specific language is important to careful removal with minimal breakage?
Yeah, what the contractor stated here on this application is that these removal methods is what we're going to employ. And the division reviewed these and basically concurred that employing these practices would be an example of handling the material carefully and not render it friable.
Are there other conditions they could have put in there that would have also been careful removal?
Yes, once again, as I was previously stated, we did not want to curtail the innovativeness of the contractor. So they could have used a myriad of different methodologies, but it was their choice, as long as they keep it non-friable.
Thank you, and bear with me a second. I'm going to jump through a couple here, get back to them. Or not. Sorry, this didn't make it into the slide. Can you pop me back open? Well, sorry about that. Mr. Burns, I'd like to turn your attention to, well, let me start over. Are you familiar with the deposition of Mr. Ryan Whitcamp in this case?
Yes, I did review it, but I did not commit it to memory.
That's okay. And Mr. Cross mentioned earlier that Ryan Whitcamp is the owner of Edge. I'm going to read something from his deposition and ask your opinion on that. At Mr. Whitcamp's deposition, at page 110, starting at line 12, in relationship to what work practice would consider he would have used to remove transite, he said 2 ladders, 2 guys, airless on a rope, flat bar tied up to the ladder, climb up, spray it lightly. You don't want to go overboard on it. Break your piece off, hand it to the next guy. It goes in a bag. Once the bag gets too heavy, drop it down, tie it off, new bag. In your experience, in your opinion, would practices such as that be more likely to result in careful removal with minimal breakage?
If I was actually to review that or listen to Mr. Whitcamp, I would actually ask for a couple clarifications. I would actually ask him to clarify, what do you mean by break it off? I'll also ask him to clarify, what do you mean by drop the bag? So it's possible.
Okay.
With some clarifications.
All right, thank you for that. Turn your attention now to photographs Mr. Wolf took. We talked about these earlier. This is Division Exhibit 10, page 124. We heard testimony that this is the sighting that Edge found when it arrived on location. It was contracted to remove. In your estimation, in your opinion, would it be possible to remove siding in this condition carefully with minimal breakage?
Absolutely, sir, yes.
And why is that?
Well, even though some of the siding is already damaged, it can still be removed safely. Looking at the smaller fragments, well, let me back up and say, looking at the photograph, I see 3 panels, and I'm focusing on the one in the center. And right beneath the center panel, there appears to be 2 sheets of 2 shingles of transite which are broken. And there's some smaller fragments there. So those pieces could easily be wetted with amended water, plucked off as they are, placed directly into a bag. And then the larger pieces of shingles could actually follow the similar removal. If the nail heads were still holding those shingles on, they could follow the work practices which were basically stated by Edge in terms of removing the nail heads and lifting the shingle off and once again placing it to a bag. So even though those are damaged, they could still be handled appropriately where we would say they're non-friable.
Thank you. Now, instead of what you just described, what we heard from Mr. Wolf as well as Mr. Rodriguez in his written testimony is that Edge was breaking the tiles off the building around the nail heads, which broke at the corners, and then dropping them 20 feet down to the ground. We heard testimony from Mr. Wolf that this is where they landed and where it was dropped. Based on what we saw in the prior photo around what siding was still on the wall and what we see here, in your opinion, would you say that the transition from what was on the wall to what we see on the ground here constituted careful removal with minimal breakage?
The end result of what I see in this photograph does not constitute minimal breakage or carefully handling the material.
And why not?
The first thing that comes to mind as I look at this photograph, that there are no intact shingles on that photograph. The largest piece of the shingle may at most be a half of a third of a shingle, and then there are so many more smaller fragments and pieces of an original shingle.
Thank you. And in your estimation, would it surprise you that Mr. Wolf found that the transite siding he found there that he applied hand pressure to had been rendered friable? Would that be consistent with your experience?
Yes, and I would not be surprised.
Thank you. Mr. Burns, I'd now like to turn to the allegations concerning adequate wetting under section 3S4A. Can you please explain for us why adequate wetting is critical during ACM removal?
Yes, adequate wetting is actually, well, removal of asbestos is basically a system, if you will, of redundant engineering controls. And wetting is one of those. And it's important to apply wet, amended water. And if we're talking about a friable material just for a moment, it's important to apply that amended water to the material so that the water penetrates and saturates and keeps the asbestos fibers bound. And if they're released, it would prevent them from becoming airborne. But when we're talking about a non-friable form of asbestos, such as, and when we're talking about 3S4A, when we talk about wetting, and specifically shingles, it is my professional opinion that wetting should be done in a certain situation, or a certain time, or a certain sequence.
What would that be?
When we're talking about shingles, transite shingles, they are designed and manufactured to be impervious to water, right? You don't want your house to leak when you got transite shingles on it. So they're designed to repel rain, snow, or any other precipitation. So to wet that shingle before you take it off the wall is ineffective. To wet that shingle once it's on the ground is ineffective. The time you want to actually wet that shingle is when it's being removed from the wall, when the breakage is occurring, all right? When it breaks, that's what's going to release the asbestos fibers. That's when you want the wetting to occur, which is now going to suppress those fibers to keep them from becoming airborne. Some of these shingles, which have been on buildings once again for a number of decades, have begun to deteriorate at the overlap point. And so as you begin to remove those shingles, you're going to have some abrading which is taking place, which is once again going to be releasing those fibers. So it's important to apply the water at the time that the shingles are actually being removed, being impacted, not before, not after.
Thank you. And turning to the specifics of the Eagle's Nest project, Mr. Rodriguez testified that they had a single airless sprayer. As we heard from Mr. Wolf, he did not see that, but taking Mr. Rodriguez's testimony, they had a single airless sprayer. Guy on top would come down the ladder to about the 6th rung based on that testimony to grab it, go back up and spray it, bring it back down to the 6th rung for the person on the ground to use it to spray it after removal. In your estimation, could a process like that result in adequate wetting during the removal process?
No, sir, it could not.
Why not?
Because as I just described, the wetting should occur at the time that the shingle, at the time that the shingle is being removed. All right, so for the gentleman that's up high, that's doing the physical removal to wet the shingle, once again, it's ineffective. Okay, because now he's lowered the water hose or the air of the sprayer down to the guy below. And as Mr. Wolf also described, this gentleman that's on a extended ladder, 2 feet, 1 hand, there's no way he's going to actually be able to apply mended water while he or she is removing the shingle and keeping it minimally broken and then place it in the bag. It just can't be done.
Thank you, Mr. Burns. Now I'd like to shift to the Pine Creek apartment complex and Mr. McGowan's testimony. We heard some questions from the commission and concerning the regulatory change that occurred. And so I'd like to ask you some questions on that. Can you please explain to us the impetus and the reasoning for the regulatory change in 2021 concerning clean rooms?
Yes, I can. As I stated previously, I've been in this industry since 1991 as a regulator. So I've actually seen things transition over time. When I first came into the industry, the contractors were actually building their decontamination units. And they were building for the size that they needed based upon the project and the size of the crew. Somewhere around the end of the 90s, going into the 2000s, someone introduced the disposicons, the pop-ups, the 3x3s to our industry, and they took off like wildfire. Everybody began to use them. Now it's been asked, why did the division allow it? It was not so much that we allowed it, it's just that we could not stop it. At the current language that was in the regulation, it says that you must have a clean room. There was no specificity on what size it had to be or what it needed to look like. It just said clean room. For the most part, up until that point, everybody recognized what we considered an acceptable clean room. But because there was no language in the reg that says that a pop-up was disallowed, we could not stop it. But that's because we didn't stop it means that we liked it. All right, none of us liked it. None of us inspectors liked it because we inspectors we're subjected to the same conditions as the abatement workers on site when they're doing their removal. So we too have to strip down to our bathing suits for our bodies, to our birthday suits, and do the same thing. So that means we have to set our clothes here, all right, proceed to the decon, do what we're gonna do on the inside, and then we have to exit the decon. Now, I apologize if this offends anybody, but we have to exit the decon naked to get from point A to point B, where our clothes are. And quite often, we're talking about a dirty environment because we're talking about construction sites. So we're not talking about a sterile environment. So we were never in favor of it. However, because of the regulatory language, there was nothing that we could do about it.
So I'd like to point your attention now to, this is the language in 3K1A. This is Joint Exhibit 38, page 57. This is the language you were mentioning about the requirement for a clean room.
Yes.
Now I'd like to turn your attention to page 57 of Joint Exhibit 38. This is Regulation 8, Part B, Section 1B29, the definition of clean room. Is this what changed in 2021?
The definition, but as well as some of the statement in the previous.
In the previous slide?
Under 3K1. What we added in 3K1, we said must be sized to accommodate the clothes and equipment. That language was not in the previous version of the regs. We, as one of the authors or drafters, co-drafters of the regulation, as working with the stakeholders, that language is specific as to you see it now. And the reason why we left it general like that is because the clean room needs to be sized based upon the project and the size of a crew. So we didn't want to say have a decon, 5 by 10 by 20, because that may not be necessary on some projects or it may be inadequate on others. But what we were trying to state here in this paragraph is the intent. All right, we wanted the clean room large enough to hold the clothes, the PPE, to allow for drying off in the shower. So we intentionally put to the words that you see there now. So that was one of the biggest changes that we made to this particular section. And then as you stated in the definition, which is on the next slide.
Thank you. And just one question, if these 3x3 pop-ups, you're familiar with them, you've been in them before?
Yes.
Would it be possible to store all of the equipment, have the clothing and boots of 4 workers plus an inspector in a 3x3 clean room and still allow you to do what you need to do in that room?
Yes, impossible.
Thank you. And was the changes you just walked through in 3K1A and 1B29 conducted through a public rulemaking process?
It was.
And did stakeholder outreach occur before the rulemaking?
It did.
And can you tell us a little bit about that stakeholder outreach?
Yes, as part of stakeholder outreach, we published several drafts of the regulations on the division's webpage, on the commission's webpage. We emailed them out to training providers and anybody that was on the comment list at the time.
And after the rules were adopted in January 2021, did you do any training or outreach to contractors in the regulated industry then?
Yes, we did.
Can you tell us a little bit about what that entailed?
It was primarily done through notifications once again, the contact list, comment list of those who become parties through the stakeholder process. Information is posted on our webpage, the commission's page. But we also, and I would say also, I specifically reached out to the training providers to provide them copies of the new regulations and to discuss with them some of the changes which were approved by the commission.
So if general abatement contractors were keeping up to date with the regulatory changes, would they have been informed of these changes once adopted?
They would. And if I may elaborate or extend my answer, the primary reason that I provided the information to training providers is because everyone that works in our industry, who's certified to work in our industry, must go through annual training.
Is that what's called refresher training?
That is called refresher training. So as they went through their refresher training, they would have received this information. But then there were others, like I said, who received it directly from us.
Thank you, Mr. Burns. Finally, I want to turn to something that Mr. Cross mentioned in his opening related to the Denver Pine Creek apartment site and the critical barrier that had failed. He said that no spill had occurred. Is it possible to say with any certainty at all whether a spill occurred through that downed critical barrier or not?
No, and to elaborate on Mr. Cross's question, I think he may have been thinking of something visible that you can see there on the ground. When we're dealing with asbestos fibers, and for us, when we talk about a spill, we're also talking about those fibers that you can't see. All right, so the fact that there was a breach in a critical barrier we couldn't see those fibers, but there was a high potential that there was a release of fibers from that work area.
And is that why containment is in fact so important on projects like that?
Absolutely, sir.
Thank you. Nothing further.
Cross-examination?
Yes, please. Or good afternoon.
Afternoon.
We've met before, correct?
We have.
All right. I'm gonna go through this in the order of the violations, starting with lead. You never visited the lead fill site, correct?
That is correct.
And you agree that Regulation 8 requires someone making a friability determination to actually handle the material, correct?
Yes, you asked me this question and I answered your question during the deposition. But I did not elaborate on my answer. So for the purposes of renovation and demolition, the building inspector is required to touch and feel the material to determine if it's friable.
And if they didn't, that would actually be a violation of Regulation 8 by itself, if they didn't touch the material to check to make sure whether it was friable or non-friable, correct?
For the purposes of, yes, for renovation demolition, you're correct.
Okay, and you didn't, since you never visited the site, you never handled any of the transite that was in that photograph or anywhere else on the site, correct?
That is correct.
All right, and to know if something has been rendered friable, you gotta be able to know if it can be crushed or crumbled, pulverized, or reduced to powder with hand pressure, right?
No, sir, I don't agree with that wholeheartedly.
Well, isn't that the definition of friable?
That is the definition of friable, but that is not the only way. Unless that was the only way, that is not the only way.
All right, well, let me move on for a second. If the regulation prevents making something turned on, or regulation prevents rendering something friable, correct?
One more time.
The regulation prevents rendering non-friable material friable, correct?
I don't understand your question.
Sure. I'm referring to section, or the provision that governs the removal of non-friable material. Let me see if I can pull it up real quick. Or actually, I'll probably just read it to you to save some time. I'm referring to section 3S4. You're familiar with that section, correct?
Yes, sir.
All right. 3S4 governs the removal of non-friable material, correct?
That is correct.
And subsection 3S4B says that you must remove the materials using hand removal methods or power tools that do not subject the material to cutting, grinding, sanding, bead blasting, sandblasting, or otherwise damage the material in such a way as to render it friable, correct?
Correct.
All right. Notice we the edge, didn't cut it, grind it, sand it, bead blast it, sandblast it, correct?
That is correct.
Okay. And then you have this catch-all at the end, or otherwise damage the material in such a way as to render it friable, correct?
Correct.
Is there a definition in Regulation 8 as to what render it friable means?
There is not a definition to what render friable means, but there's a definition of friable.
Correct. Yes. All we have is the definition of friable. That phrase, render friable, is not defined in Regulation 8, correct?
Correct.
What the division has done in part is to refer to the EPA opinion. You remember going through that?
Yes.
I'd like to actually pull that up if I could. And that is Division Exhibit 28. And I'm going to try to share my screen, see if I'm capable. All right. Yeah, it's on the screen, but it's also in front of you in the binder, Division Exhibit 28. Okay, you're familiar with this document, correct?
Yes, sir, I am.
All right, and this talks about transite and how to render transite friable, correct?
It does.
And in fact, somebody had a question about some confusion they had regarding when transite becomes friable, so they basically asked the EPA for an opinion. Fair to say?
Fair to say.
Okay, and this was generated. I'm looking at the first paragraph here. One of the first things they said, let's highlight. in this opinion was, as you stated in your memorandum, the word broken has been deleted from the definition section because it could be mistakenly interpreted as substantially increasing the scope of the standard. Do you see that?
Yes, sir.
So the EPA actually removed broken from the standard because they were afraid it was being heightened by people, correct?
Correct.
Breakage is different than rendering it friable, right?
That is true.
Okay. Here's the next sentence says, most non-friable materials can be broken without releasing significant quantities of airborne fibers. It is only when the material is extensively damaged that the potential for significant fiber release is greatly increased. Do you agree with that?
I would agree.
Now here, I quoted this in my opening statement. There is a difference between merely breaking a transite panel and crumbling, pulverizing, and reducing to powder, correct?
Correct.
So breaking transite, you agree transite is cement board. It's cement mixed with asbestos fibers, correct?
Correct.
It's very durable, right? That's why it's used for siding, for roof tiles, for piping, correct?
Correct.
Okay. And just breaking it alone is not going to render it friable, right?
Agreed.
It needs to be so extensively damaged that it has been crumbled, pulverized, or reduced to powder, correct?
Correct.
And breakage is not prohibited by the rendering friable section, correct? That's something totally different.
That is something different. Yes.
Okay. Now, the EPA talks about some of the things we've seen already in Regulation 8, sanding, grinding, cutting, and abrading. You see those examples.
I do.
And there's no doubt that Edge didn't do any of those things, correct?
To the best of my knowledge, you're correct.
Okay. And then it says here, similarly, we can give examples of work practices which will cause category 2 ACM such as transite to become friable. Any demolition operation, i.e. use of a wrecking ball, implosion, use of a bulldozer and backhoe or other heavy machinery to demolish, correct? You see those?
I do.
And we talked about this during your deposition. You agree with me that that's a totally different category of force than dropping a transite fragment from a ladder onto poly.
I do.
Okay. And this was brought up by counsel for the division. This sentence, dropping category 2 materials such as transite panels from a building as a means of transporting it to the ground will also cause it to be regulated in most conditions. You see that?
I do.
Okay. You agree that's not an absolute, right?
I do.
Most conditions, not all conditions, correct?
Correct.
And we're not talking about, in this case, well, first of all, let's go up here. They also say a case-by-case determination must be made considering the condition of the material and the forces which have or will act upon it, correct?
Correct.
Okay. And in this case, we don't have the examples that they gave, wrecking ball, implosion, or bulldozer, correct?
Correct.
Okay. I'm not gonna put it on the screen, but there was also some guidance from the statement of basis and purpose. You remember that?
I do.
That gave examples as well as including breaking it up with a hammer or cutting it with a saw. You agree that there's no evidence that Edge did either of those things, correct?
They do not do either of those examples.
I'm gonna talk about adequately wet real quick. The testimony from Mr. Rodriguez was that they were using an airless sprayer with amended water to spray the material before they removed it. Are you aware of that?
Yes, I am.
Okay. An airless sprayer is fine with Regulation 8, correct?
It is.
And then amended water is required by Regulation 8, correct?
It is.
Okay. And they also, the testimony was also that once it was on the poly, they sprayed it again and put it in the bag, correct?
Correct.
And your testimony today is that Regulation 8 says that that's not sufficient. It must be sprayed while it's being removed in case it accidentally, or in case it breaks while it's being removed, correct?
Correct.
I asked you specifically during your deposition, is that specified anywhere in Regulation 8?
You did, but you also didn't ask me to interpret it for you. One of the things I left out in my answer to Mr. Dave Beckham here, one of my jobs is that I teach people in terms of how to read the regulation and to understand it. So the part of the sentence that you're highlighting was the first part in terms of adequately wet, but there's a second part of the sentence which I was just addressing in my description to Mr. Beckham when he passed it.
I'm gonna have you, in front of you, you've got a very large binder. If you could please go to exhibit 44, please. Just to make sure we're all on the same page, I'm just gonna ask you the same question I asked you that day.
Absolutely. And which page after 44?
I'm on 74.
74. Exhibit 44, 74.
Yes. Actually, 72. Tell me when you get there.
I'm there, sir.
I'm at the bottom. I'm gonna read the question if you could read the answer. Okay, is there anything in here that says that you're supposed to be spraying it where it might break to make sure so that you're hitting potential fibers as they come off? What was your answer?
I'm sorry, one more time. Is there,
I'm on line 24, page 72. I said, okay, is there anything in here that says that you're supposed to be spraying it where it might break to make sure so that you're hitting potential fibers as they come off? What was your answer?
my answer was no, sir. I answered the question which was.
Sure, I'm just, right now, I'm just asking you a very specific question. What was your answer?
My answer then and now is to no to your question.
And then what was the rest of that answer?
That language does not exist.
That language does not exist in regulation. Can I have you go to the next page, 74? Just to be clear, I asked it again. I'm on line 3. Okay, and again, regulation 8 doesn't say anywhere that you need to be spraying it at the time of breakage. What was your answer?
No, sir.
Okay. I want to talk about the division's concern with the fact that Edge's crew dropped the fragments from the ladder. Try again to share my screen. You are familiar with the fact that there is a specific provision in Regulation 8 that governs how an asbestos abatement contractor is supposed to remove asbestos containing material from an elevated height, correct?
Yes, I'm familiar.
Wish me luck. And I'm referring to section 301B. Do you see that?
I see something on
It's exhibit 38 in your book, if that would help.
.301 Baker, page 61.
Page 61, correct?
Yes, sir.
Okay, first, there's nothing, there's no definition of what carefully means or minimal breakage means in Regulation 8, correct?
That is correct.
There is this section 301B that says remove asbestos from elevated heights. You see that?
I do.
And it says very clearly for friable ACM that will be removed or stripped. You see that?
I do.
There's an adjective or a modifier before ACM limiting this to friable ACM, correct?
Correct.
And it says in 301B, carefully lower the materials to the ground and floor, not dropping, throwing, sliding, or otherwise damaging or disturbing the materials. See that?
I do.
This does not apply to transite, correct?
That is correct.
And there is no provision anywhere in Regulation 8 that says you cannot drop non-friable asbestos containing material, correct?
That language does not exist in Regulation 8. You're correct.
Okay. Regarding Pine Creek, you never visited that project either, correct?
That is correct.
You heard me say in the opening statement, let's talk about the loss of pressure in the containment. You heard me say that you testified during your deposition that that's something that happens on projects, correct?
I did.
It is not an uncommon occurrence, correct?
Correct.
And I asked you during your deposition, if loss of pressure is an automatic violation of regulation 8? You said no, correct?
Actually, if you can read your exact question and my exact answers, that would be helpful.
That'd be great. Let's go to page 85 in exhibit 44.
Page 85, which line are we looking at, sir?
I'm at 22.
Line 22.
Is the containment losing pressure an automatic violation of regulation 8? What was your answer?
I said, no, it is not.
Next question. When does it become a violation of regulation 8? What was your answer?
It becomes a violation of regulation 8 when we had a loss of pressure and gross abatement continues versus stopping the work and repairing the containment.
No evidence that Edge performed any gross abatement when the containment had lost pressure, correct?
One more time.
There is no evidence that Edge performed gross removal of asbestos contained material after the containment had lost pressure, correct?
I am unaware of that information, sir.
There's concerns about there was some discussion about, I said that there was no spill created. You said there might have been a spill created. Edge wasn't charged with a spill on this particular enforcement proceeding, correct?
Correct.
There's concerns about the manometer. You're familiar with the manometer, correct?
I am.
And we agree that the regulation 8 only requires that a general abatement contractor record and maintain the negative pressure data, correct?
Correct.
And a manometer does that electronically, correct?
Correct.
And
As well as produce a physical copy.
it can, right? I mean, you can hook up a printer to it. You can print directly on the machine. You can stick a USB in there and download the data, correct?
Correct.
And Edge had a manometer on site that day, correct?
Yes, correct.
And we talked about the power loss. You're aware that Mr. Moda testified that the project suffered many power losses. Are you aware of that?
I am.
Okay. And this was after a fire. It's a vacant building. It's been damaged. Does that surprise you at all? That there was multiple power losses?
Does it surprise me? That's a difficult question to answer, Counselor. Because
Objection calls for speculation.
Overruled.
Well, for me as an inspector who's been doing this for a while, it does happen, but for me, something we didn't talk about today, which I don't want to bring in today because it wasn't mentioned, is that the project design would actually accommodate and account for power being needed on the project. And so for me, if there was a power loss, it would raise more questions for me in terms of why and if this project was adequately prepared for.
Okay. We talked about what a power loss might do to a manometer. It might reset a manometer, correct?
Correct.
And they do have batteries, but those batteries only last so long, correct?
Some of them correct.
Okay, and if it's an older one, like our phones, may not last as long as when you first bought that manometer, correct?
Correct.
All right, and if it loses power, if the building loses power and the battery runs out, then it could reset, correct?
It's possible, correct.
I asked you if that was a automatic violation of regulation 8. Do you remember what you said?
I think I said no.
You said no, and in fact, you said, we're not looking for a gotcha moment, correct?
Correct.
That would be a gotcha moment. Building lost power, manometer reset. When they showed up the next day, the date and time isn't there, the project hasn't been decided. That's not necessarily an asbestos abatement contractor's fault, correct?
Right, but I also think I had more context to that gotcha moment, did I not? When I said we don't look for a gotcha moment, did I also have additional context to the answer?
Check real quick. We'll move on. I'm tight on time. Let's talk about the clean room for a second. You heard me say in opening statement that the division allowed it for 20 years, correct?
One more time, sorry.
The division allowed a 3x3 pop-up chamber for 20 years, correct?
Yes,
And it sounds like division didn't necessarily like it, but during that 20-year period, division didn't issue any warnings or alleged violations against contractors for using a 3x3 pop-up chamber, correct?
it was not a violation at the time, so we could not issue any alleged violations.
And that changed in March of 2021, correct?
Correct,
3 months before this, before the inspection on the Pine Creek project, correct?
correct.
All right. I understand there's a rulemaking process, but you understand that not every single GAC can participate in that rulemaking process. You understand that?
I do.
I asked you the same question that I asked Mr. McGowan. If you would agree with me, there might be a learning curve in that situation. You agreed with that, right?
I do.
And you yourself also experienced a situation where contractors were still using that 3x3 pop-up chamber after March of 2021, correct?
Correct.
And you, like Mr. McGowan said, you would not recommend enforcement on that basis alone, correct?
On that basis of alone, no.
Okay. The last issue on Pine Creek is the use of poly. Have you read the depositions in this case? Are you familiar with the testimony in this case?
Yes, but once again, I did not commit them to memory.
Okay. You're aware that Edge's representatives are taking the position that the poly that was found that day was used to cover penetrations because of sewage, rotting food, correct?
Correct.
Okay. And you're aware that Edge is maintaining that it was using poly to seal holes in the roof and the eaves to prevent wind intrusion, rain intrusion?
I do recall hearing.
Okay.
Yes.
And I mean, if wind is entering the space, I mean, this is all happening on the third floor. I understand some of it's on one side and on the other, but if wind is entering a space, then that can mess with the manometer, correct? It can mess with the pressure of the containment.
It's possible it could affect the manometer. Yes.
And if the manometer, as we discussed earlier, if the pressure changes and it goes below what's set on the manometer, an alarm goes off, right?
Right.
Everybody has to stop what they're doing, correct?
Correct.
They all have to find what happened, restore the containment immediately before any gross abatement can take place, correct?
Correct.
It's disruptive to a crew. Would you agree with that? Slows everything down if the alarm keeps going off because they're losing pressure.
Yes, it can be disruptive to a crew.
Okay. And so I asked you, do you, Mr. Burns, know if the poly that was observed on that day was used to block wind, or was it used as part of a prior containment? Do you know?
I do not know.
Okay. And I asked you, I think specifically, I think your exact answer was, I could only speculate. Is that fair to say?
That is fair to say.
Those are all my questions. Thank you.
Redirect. Yes, thank you. Just to follow up on a couple of things, Mr. Burns. As we talked earlier, I asked whether or not the Regulation 8 Part B was intended to cover every possible eventuality or every act, contemplated under the sun. You said no. Can you please remind us how Regulation 8 is drafted and how it's sort of a rule of general applicability?
Yes, we draft Reg 8 through what we call a stakeholder process, where we bring members from the industry in. We all sit down at the table, and in this particular instance, it was during COVID, so all of our meetings were over Zoom. So stakeholders participated. We would present draft language, post it to the commission's website for people to download, digest, comment on, and when we come together as a group, people offer their constructive criticism or suggestions. And over a period of time, we eventually agree on language that we present before the commission, which is adopted with changes or no changes.
And is the language adopted intended to generally cover all of the broad things that could happen on a site, even if it doesn't specify each one of those things?
The general language, yes.
Thank you. If we could pull up the exhibits for Mr. Burns at slide 7. Mr. Cross asked you about the adequate wetting turn your attention to 3S4A here in a moment, which is Joint Exhibit 38. 3S4A states adequately wet the surface areas of the non-friable ACM to prevent dust emissions throughout the removal process. Is there anything in the language of that rule that speaks to when wetting must happen during removal?
Yes, as I was trying to point out, Mr. Cross is actually the second part of that statement there, to prevent, okay, the emissions during the removal process. So that was my, I could say, my extended explanation in terms of when you should apply water. Right, in this particular instance, is when you're removing transite, it's gonna be at the point that it's being broke. That's when it should be actually wetted.
So even if it doesn't say exactly you have to spray at the time of breakage, does throughout cover that?
It does.
Thank you. And if we could turn now to, well, I'll ask you a general question. Is there language in Regulation 8 Part B that addresses the concerns and issues with dropping transite from 20 feet?
No, there is no language.
Are there issues around the breaking of transite or rendering friable that might apply to such a situation?
Yes. Well, actually, I'm sorry, rephrase or repeat your question, please. My mind was
That's okay. It's lunch, it's second lunchtime. If Regulation 8 Part B does not specifically say you cannot drop transite, are there provisions in either 3S4 or perhaps other provisions in the rule that might address the dropping of transite and why it should be avoided?
Yes, I would actually say under 3S4C there, where we talk about handling material carefully. Once again, it's a general statement, but me dropping something from 20 feet would not be a demonstration of handling it carefully.
Now I'd like to turn your attention to slide 12, if I might. Actually, here we go. Mr. Cross spoke about the language in the EPA guidance that said when transite is extensively damaged, it can be rendered friable. Is the transite on this photo here, Division Exhibit 32, extensively damaged?
In my opinion, it is, yes.
Thank you. Nothing further.
Commissioner questions? Commissioner Thomas?
Yes, so regarding spraying or wetting before removal, how long will that wetting actually be expected to last? Like, is it a minute or two? Is it 10 minutes? Is it an hour?
Well, actually, sir, it depends on the material that we're discussing. So if we're talking about a friable material such as the ceiling tiles, once again, as an example, all right, we would wet those ceiling tiles, all right? And what the regulation says that you will adequately wet prior to, keep it wet during removal, and keep it wet until it's packaged for disposal. So depending upon the type of material you're dealing with and applying the amended water, it may take multiple applications and it may take some period of time for it to penetrate. When we're talking about a non-friable, such as in the shingles, all right, the water is going to remain on the shingle long enough for it to dry. And if it's a hot day or a cold day, it can be, a difference in temperatures, which is going to affect that. But once again, that water will not actually penetrate a non-friable to start with.
Thank you.
Commissioner Riddle?
Thank you. I have some questions regarding some of the things, a couple of things that you said in your deposition that I read. Just need a little clarification, if you could. And this has to do with the Leadville site. And you had said that, I think in your testimony today, you said that just mere breaking of the material doesn't necessarily of itself result in the material becoming friable. I think that's what you said. It just the mere breaking of it alone. I think in your deposition that you'd said that the breakage may release some fibers, but it could still be considered non-friable. That's the first, if you could talk about that a bit. And then secondly, dropping it We've heard testimony back and forth on whether you should or should not, or can and cannot, or rendering it friable if you drop it. I think one of the things that you were questioned about was if you're dropping it from height, that could be a problem. But then also what it lands on could render it friable. So if it lands on concrete, for example, or rocks, that would be more apt to make it friable versus landing on soil or dirt. Can you talk about those two things a little bit and maybe give some more of your thoughts on those?
Some meat on those bones? Yes, ma'am, I could. First and foremost, let me disclose this to say for the record, and not to sound avoiding, but when I'm giving a deposition, I answer the question that is asked. Okay, I don't provide elaboration or education because that's what they're not there for. So to answer your first question in terms of breakage, yes, there potentially will be breakage of removing transite shingles. And to be quite honest, Division, us, with Edge actually putting on their application that these are going to be the work practices that they're utilizing, we do recognize that there's going to be potential for breakage. Once again, we're talking about old asbestos materials that's been on this building for decades. We recognize that there may be some fragility to it. And so the fact that they're trying to get a pry bar under an edge of a shingle to lift it up enough to expose a nail head may cause that shingle to break right there at that edge where the nail head is. We understand that, okay? But once again, that's where the engineering controls come in terms of wetting while you're doing this, because if there is some breakage, it's going to suppress those fibers. So the division is not unrealistic, all right? We do not have a high expectation that every one of these shingles are going to be removed intact. Be quite honest, we expect there to be breakage, okay? But the question is how much breakage? As that breakage went to the extent now that you can't find an intact shingle anywhere, that a shingle is in more pieces than it is in holes. So that's what I meant by my answer. So yes, there will be breakage. We expect to be breakage, but that breakage will be minimal. And as I was asked to define what minimal is, in as few of those pieces as possible. So in my description, you may have potentially, well, let me say, for those who are unaware, the majority of times shingles are attached with two nails, one in each upper corner. So recognize what I'm describing is potentially you may have 3 or 4 pieces, you know, a couple of small triangles and then a large sheet, right? To give you 3 pieces, right? So that would be acceptable to us. Does that help? And then I believe the second part of your question was I talked about dropping materials from an elevated height and that the surface that it lands on. And Mr. Cross asked me that question, would that make a difference? And my answer was yes. All right, yes, if you drop transite from an elevated height onto a sheet of poly that was on dirt or grass, yes, that may soften the impact. However, what we didn't talk about is that once you drop 1 or 2 shingles there, that's now going to give you a hard surface. Now you have sheets of transite shingles impacting each other. All right, so you no longer have a non-friable landing on a soft surface such as in grass, poly, or soil. It is now landing on a hard surface, which is a cementitious product. All right, the contact of those 2 materials is going to cause materials to break.
That's helpful, thank you.
You're welcome.
Commissioner Reader?
Yes, thank you. 2 quick questions. Just scroll back up here and find them. In terms of determining friability, you know, we've talked about it basically it sort of crumbles in your hand. Is there any kind of laboratory standard for this in the asbestos industry? I mean, do you ever send samples out so you have lab data to prove something? Or is it just always just the inspector saying, yeah, or is it just really a common sense kind of interpretation?
To answer your first question, no, there is no laboratory standard. There is no laboratory analysis to determine friability. That is something that's made in the field by the inspector that's there to see the material, touch the material.
Okay. And second question, it came up in your testimony looking at, not sure what the exact title, but the work plan that Edge had for Eagle's Nest with clipping the nails and so forth. when Edge got there and Ortiz Brothers had already taken off the balcony, so there was a lot of damage. They may have changed, they may have deviated from the work plan. Should they have, because of what Ortiz Brothers had done, would the division normally expect them to update that work plan before proceeding with work if they were changing how they were going to do things?
Yes, sir. And actually, the division has a higher expectation. There's a section in the regulation which we did not talk about, which is the spill provision, section 3T. It talks about if someone, a contractor or a consultant or an owner comes to a site and recognizes that we have friable materials which have been rendered friable, friable materials which have been damaged or released, or non-friable, which has been rendered friable, they have an obligation to themselves and to the division to report that to us. So with that being said, when Edge arrived on site and noticed that this non-friable material had possibly been rendered friable, under section 3T, they should have provided a notification to the division within 24 hours saying, hey, this transite is no longer non-friable. You actually have a spill up here. And at that point in time, Edge would have stood down, we would, for lack of better words, unapproved their application saying that you can't address that tile now in a non-friable manner because you have a spill here that you must address. So to answer your question, sir, that's what actually should have happened in this scenario.
Okay. Thank you.
Well,
Any other questions from commissioners? Seeing none, any follow-up on the commissioner questions from parties?
Nothing from the division. Thank you.
Yes, briefly, Mr. Burns, going in reverse order. Thank you. Mr. Burns, going in reverse order. Edge has not been charged with failure to report a spill in this enforcement proceeding, correct?
correct.
You mentioned something about minimal breakage or that transite might break, but you wouldn't expect that we get into a situation where you cannot find a single intact shingle on the poly. Remember that testimony?
I do.
Okay, I asked you very specifically during your deposition, could you tell me by looking at that photo if the transite was broken by Ortiz Brothers or Edge? Do you remember testifying that you could not?
I do.
That's still the case, I assume.
That is the case.
There's discussion of landing on rocks or concrete. There's no concrete underneath the poly, correct?
I don't know, sir.
Do you have any evidence that there were rocks under the poly?
I do not.
Those are my questions. Thank you.
Okay, Mr. Burns, you are excused. The division is welcome to call its next witness.
Good afternoon, commissioners. Ms. Beth Foley, who works as the enforcement coordinator of the Indoor Environment Program, submitted written testimony, and we discussed this morning. It's in Google Drive that you all have access to as Division Exhibit 33. She was a replacement witness for Laura Maniac, who is unavailable. Ms. Maniac was the longtime program manager for the Indoor Environment Program, and Ms. Foley worked very closely with her on the enforcement process, including working with her on the enforcement process for these two sites. At this time, because we submitted written testimony, and in the interest of time, we're just going to rely on the written testimony that she submitted. And that discusses how the division calculated the penalties for this case and how the enforcement process unfolded for both of these two cases. So at this time, we'll rely on that written testimony, and she's available for cross-examination.
I'm not finding it.
I'm not finding it either.
Which exhibit?
33, Division Exhibit 33.
Division Exhibit 33 in the Google Drive folder. It was updated, I believe, last night.
Vision 33.
Possible you might have an outdated link.
The 32.
Can I ask staff direction on this one?
It should be in the folder. I haven't seen it.
You're seeing it?
It's in the commissioner's October folder.
Think Div X 33.
DivX 30, we got DivX 32.
Under the evidence and written testimony folders.
Let me send everyone a link.
Division exhibits.
Division exhibits.
We should probably confirm that we're all working from the same drive. It's possible.
There's like 40 different drives.
Baby pictures.
Yes.
Three is that?
Yeah, that's what we're looking
We
for.
can put the link maybe up on the screen and then we can all.
Actually,
Oh.
hang on a second, we've got some version control issues, if I can just ask staff for a little.
There's no 33 in
Not in mine either.
Is the updated exhibit list, and in that exhibit list, you open it and the links to the exhibits are in there. So it says 2025, 10, 15 updated exhibit list and links to exhibits.
And where are we supposed to find that?
That's in the,
Actually, can we hold for just a second? We're gonna ask Sarah to just put it in, make sure that we're all seeing it in the same place. So
Are you calling anyone else?
Are we calling anyone else?
Joy, it's not.
We should put it in the Zoom if that's
Easy to
helpful.
get out of here then, right?
just a sec here,
Yep.
please.
Got some cross-examination stuff during yours.
Oh,
Some deposition reading.
oh.
It should be in there now.
Okay.
Got it.
Yep.
I found it. It just popped in.
You have that one.
I'm looking at it right now.
So could someone with a mic
evidence.
give us instructions about how to get there?
Yeah, can someone help us navigate to it?
That's what I,
specifically?
yeah.
What's the folder channel?
It's from this.
No,
No,
go back to where you were.
I'm not seeing it.
Go to evidence.
Commissioners folder.
Evidence.
Oh, I don't know what folder this is.
And it should
It's
be
evidence. It's evidence.
Division.
folder. Edge environment evidence.
33. Okay, now
And then
hit.
if you
I see it.
scroll.
I'm going to interject, but it is possible that if you have the right, you might need to refresh the folder. Sometimes.
Yeah, that's what I go.
Had it open for a while.
That takes, you know, a couple
I
people.
think it's worth like.
well, there was a working.
Jeremy, too, if you could split up and get half of us, help me navigate to it.
Yes.
Should just send a link to.
Yeah.
Email. Yeah, I'll just get. I haven't seen. I've just opened it.
Was Tom sent it over? I got the one you did.
I got it.
So one you
Got it.
over.
Yes.
Okay. It's just. Send you that link.
Martha, you got it.
Got it.
I used to push the updates and it was like, you got 4 hours and I'm like, shut it down.
John, you're good? Okay. You got it?
It's in there.
Garrett?
33 you're talking about.
Mhm.
You're talking about exhibit 33?
Yeah, best Foley's
Yeah, probably got some
testimony.
other email.
You can also put it up.
Let's see.
Oh, I had it. There it is. Oh, it's probably,
Does everybody have their copy?
Greg, you're good? Okay.
Everyone good? Okay, great. In that case, Mr. Cross,
Yes.
cross-examination.
Yes, please.
We need to bring Ms. Foley up to the witness stand and swear her in. Good afternoon, Ms. Foley. Do you swear that the evidence you are about to give to the commission in this matter shall be the truth?
I do.
You may proceed.
Thank you, Ms. Foley.
Hi,
We've met before.
we have,
I have not had the pleasure to take your deposition. You're the lucky one, I think.
have not.
I'm really just up here because I haven't had a chance to take your deposition. I want to get a little bit of information, how you calculated the penalty.
Might I ask if you get a little closer? to the
Sure.
microphone? Thank you.
Thank you for letting me know if I'm too quiet. Just yell at me again, please.
Quiet.
Oh, is that better?
That helps.
Please. All right, I'm gonna start by just posting. Well, I guess could you just, I've got your written testimony, but could you just explain how the division calculates a monetary penalty in this case? Use the lead as an example.
Okay, penalty assessment. We start with a penalty assessment table, which splits up the regulation line by citation, or by citation. And in that, each citation is then given a range of minor, moderate, severe with an associated penalty. That penalty assessment table and each citation with that minor, moderate, and severe associated penalty is based on what I would use. And this is the similar language to what the EPA uses, is based on gravity. Or you could also use severity. I like to use the word gravitas because it doesn't overlap in any way when we use those words. I'm gonna give you a little bit of an example because that might illustrate it better. What I mean by gravity, each section of the regulation doesn't have the potential to affect public health negatively in the same way. The regulations state that each person on site has to have an ID available on site. And then there's another section of the regulation that addresses engineering controls. You can see that the gravity of those are not equal. There's a section of the regulation that says we have to have a permit posted in a visible location. There can be a violation of that, but what kind of weight does that carry? So that's our starting point where we determine whether the alleged citation is in the category of minor, moderate, or severe. Now, we can take each section then and break it up into another computation by, for example, 15 workers are on site and 12 of them don't have their ID. So that's another added computation to whether that should be minor, moderate, or severe. So that's our starting point. Once we determine whether there's enough evidence to include a citation, we will compute that range. And if we find that there are additional factors to multiply or to add to that specific citation, we'll consider those factors. Some of those factors are some things such as proximity to the public, willfulness, duration of the project, size of the project, cooperation. So the entire process of calculations for penalty is computational. It involves numbers and it begins with the actual citation itself and its potential to cause harm based on what I would term gravity, gravitas, severity.
And I don't remember the name of the document, but did you say a table sheet or
We have a penalty assessment table. That's not something that was generated by Laura and I. This was by decades. It is my understanding it's been revised maybe a couple of times over the years to reflect the current inflation, but it's not something that gets revised periodically, but that is our starting point.
you know if that was ever produced in this?
I do not know. I
Then,
do not know.
then you talk about multipliers. Where do you get the guidance for how much to multiply and when to multiply?
Again, we have formulas and that's embedded on our calculations. It might be, and I'll give you an example. I think that's the best way to start. If we find that there was close proximity, and meaning that right next to the project where there was a potential leak, we'll call it that, there was public access, maybe just 25 feet away, maybe it was 25 yards away, maybe it was a half a mile, maybe it was a mile. Laura and I delve into, and I want to characterize it like this in a general terms, the context, as well as any aggravating factors.
But is there some sort of document that says if there's close proximity to the public, you have to multiply by 50% or 100%?
We have that as a formula that we apply, yes.
That's in a document somewhere?
It's part of our penalty assessment, yes.
And was that ever disclosed in this enforcement procedure?
I don't know.
You take into consideration the factors from CRS 25-7-122?
Can you familiarize myself?
Sure, I'll just ask you about these factors. Do you take into account the compliance history of the licensee?
That is an option.
Okay, and Edge had no alleged violations prior to the Pine Creek matter, correct?
To the best of my knowledge.
Lack of good faith effort on behalf of the violator to comply. Do you have any evidence that, or do you have anything to suggest that Edge didn't comply with the inspector's instruction?
I've never considered that as a factor.
Ever?
Lack of, can you repeat?
Lack of good faith effort on behalf of the violator to comply.
Yeah, I've never considered that.
Whether the violator previously committed the same violation. Do you ever take that into consideration?
No.
Okay. No evidence here that Edge committed any of these same violations previously, is there?
There's no evidence to my knowledge.
Duration of the violation. Do you ever take that into consideration?
Yes.
And on the Pine Creek project, it was remedied as soon as they became aware that the containment lost pressure, correct?
Yes.
And on Leadville, it was one morning's worth of work, correct?
Can you repeat that?
Yeah, on the Leadville project, it was one morning worth of work, correct?
To the best of what I've heard today in my recollection, again, it's been over a year before I've been able to delve into the specifics, but that is what I do recollect and what I did here today.
Okay, economic benefit of non-compliance. Do you ever take that into consideration?
Not frequently. We don't have a formula for that because it's so variable. However, sometimes on occasion, it's more obvious.
Obviously.
For example, if a certification expired, yet somebody continued to do work and they were 2 days past the expiration date. Well, there was an economic advantage to continuing to do work without paying for that, the fees for that certification. So something like that's very obvious. Otherwise, it would require a formula that we do not have to determine, nor do we have that, I want to say that the depth of staff to make those kinds of determinations. So as a matter of practice, we leave out economic benefit.
That's not part of your calculation.
For the most part, no.
No indication that Edge did any of this for an economic benefit, correct?
That's true. I would consider that speculation.
Okay, threat to public health, you've already discussed that. Malfeasance, do you take that into consideration?
No.
Whether legal or factual theories were advanced for purposes of delay, I assume you guys aren't worried about that.
I'm going to ask you to repeat that again.
Sure. Whether legal or factual theories were advanced for purposes of delay, I assume that you guys were not taking that into consideration.
That is not something I've ever considered.
Okay, and whether the violation occurred within or impacted a disproportionately impacted community, do you take?
I cannot address that. But the very nature of us making the determination that a violation has enough evidence to be elevated to an enforcement case not only suggests, but we believe there's enough evidence, again, that there's enough weight to that public health was threatened.
Okay, and I've pulled up exhibit 33. Do you have that in front of you? Should be in the smaller volume.
We didn't have printed copies of it because she was such a last minute witness. So she has a computer in front of her, which has her division exhibit 33 on it, if she needs to reference it.
All right, thank you. So which page?
6.
Could you repeat that?
Sure. Do you have access to exhibit 33?
I do.
So, and can you go to it's like page 9? All right, so this is for the Leadville project. The following is a breakdown of the range of base penalties for the penalty calculation. You see all those?
Can you refer to a line, please?
Yeah, I'm on line 26 at the bottom. Following is a breakdown of the range of base penalties for the penalty calculation.
I see that.
So my first question was gonna be, where did these come from? It sounds like there's some document somewhere that has this range in it.
That comes from the penalty assessment table.
Okay. And so you have penalties for violating section 3S2, ranging from $1,000 to $5,000.
$1,000 would be minor, $5,000 would be severe.
And then you have penalties for violating the first 3 subsections of 3S4, correct?
That's correct.
Okay. And then the division assessed the maximum penalty for each of these for a total of $9,000, correct?
I believe that's correct.
And then those base penalties were doubled based on willfulness, leading to a penalty of 18,000?
Correct.
Okay, willfulness because they were dropping the transite?
Willfulness based on the knowledge that Edge was trained in, should have had, and should have used to prevent that violation. So again, in some instances, we're providing context, pardon me, but it was Ms. Maniac's belief, based on the evidence, that this was a willful act. There was sufficient knowledge to know what to do, how to do it correctly, and to execute it.
Okay, and then that gets us up to 18,000. The division then increased that by 50%, another $9,000 for the size of the project, correct?
Correct.
So you added a 50% multiplier, not to the original 9,000, but to the already doubled 18,000, correct?
Can you repeat that?
Sure. You add a 50% additional penalty, not to the original $9,000, but to the doubled already $18,000.
I'm going to be really honest with you right now. This is where I slow down in my process. And I want to give you my honest answer. I don't want to give you an answer that's incorrect. So I've got a bit of an overload brain in doing math right now, but I did write this. And as you are reading it, I'm going to say yes, but I'm not going to do the math in my brain right now. So yes, as you're reading it, that's how, if you can understand what I said, you're correct.
Okay, when you increase something by 50%, you're basically increasing it by half of the original amount, correct?
Right.
So why did you increase the $18,000 by 50% and not the original $9,000?
You're asking why. I did not calculate this particular penalty.
Okay.
Laura, our program manager did. So I can't speak to what she did as well, because I did not even get the chance to read her written deposition or testimony. And I have not had the chance as well to go over the facts of this case, which the last time I looked at it in any detail was over a year ago. And I'm saying that to provide context as to why I can't speak to it.
Sure, you don't know why the division.
I can speak to process.
Right.
I can speak to calculations. When we want to get into this one, again, I have not read her testimony. I wasn't part of that process. I was part of these 2 cases from the initiation to the point where it began appeal and we had a settlement agreement as soon as it went into appeal. At that point, what I could offer would have been redundant to what
Sure.
Ms. Maniac.
And I think you're justifying that you don't know why the division applied a 50% increase to the 18,000 as opposed to the
What
original
I
9.
do know is that there is a formula that was used, and we use it every single time.
But you don't know why that formula adds 50% to 18,000 and not 9,000.
Again, I am gonna be really honest. I would slow down. This is what I would need to do.
Okay.
And I don't feel like I have the opportunity to do that. I'm really literally not able to do math at this specific moment. But what I can say is that we always use the formula every single time. I agree to this penalty because Laura and I review every single case together, bar none. There are occasions when she develops the penalties all on her own and I review it. There are occasions when I develop the penalties and she reviews it. So I support what she wrote.
But you don't know where it came from.
It came from a formula.
Do you know if that formula has ever been provided in this enforcement proceeding?
I do believe we've addressed it in enforcement proceedings, yes.
Provided to Edge the formula so we can figure out where these numbers came?
I don't know whether it has been provided to you.
It says this was another $9,000 was added for the size of the project. Do you know what the monetary value of the project was?
The total penalty assessed was $36,000.
I know, I'm talking about the contract Edge had on this particular job.
What Edge's contract, what you received is what Edge received is compensation?
What was going to be the contract price, or what was the contract price? Do you have any
I
idea?
do not.
Do you have any idea what the total square footage was gonna be for removal?
Can you repeat that?
Do you have any idea what the total square footage of transite removal is gonna be?
I believe it was around 450 square feet.
Okay, so that's 450 square feet of removal warrants a 50% penalty worth $9,000.
Yes,
You know how much
yes,
of
it's in
that?
range.
Do you know how much of that they removed?
Excuse me?
Do you know how much of that they removed?
How much was actually removed? I know what was on the permit and the permit needs to be followed because that was what was permitted.
You understand they didn't complete their job because a spill was declared on the first morning of work.
What was on the permit and then what was ultimately removed. You're asking for almost. And I don't want to put words in your mouth. But if there was can I ask you to clarify, because what I'm sort of hearing is that maybe there was no threat to public health based on what was disturbed.
No, that's the next one. There's another 50% for proximity to public, another $9,000. That again is 50% not on the original 9, but on the 18 again, correct?
Well, let's address proximity to public. This is outdoors. These are multiple units. That's far different from containment.
I understand that, but my question is, I think I know what your answer is gonna be. Do you know why the 50% increase was applied to the 18,000 and not the original 9?
I think that requires, again, me getting into Ms. Maniac's.
You don't know.
I'm sorry?
You don't know. Is that fair to say?
I think what's fair to say is I can't address it now for a number of different reasons.
Sure. Let's talk about the original 9,000. There's a paragraph here where you basically acknowledge that part of that is duplicative. Are you familiar with that?
Yes.
Okay, and you're saying that while you have penalties for section 3S2, you don't think it would be appropriate to also have a penalty for section 3.S.4B. Correct?
This decision to remove a section was based on not completely, but partially on the appearance of being duplicative, because both of them identify or speak to non-friable materials being rendered friable. This is my understanding, and this is my understanding then to the best that I can articulate and remains so now. If we were to dive into the specifics in each element of the citation that we're referencing here, we could make an argument that they weren't duplicative. But in the interest of being fair, I believe, again, an offering what could be termed negotiated settlement, we determined that it had enough appearance, perhaps enough interpretation of being duplicative. So we decided to eliminate it.
Okay, well, you said negotiated. This wasn't a negotiated settlement, right? This is division assessing a $30,000 penalty against Edge, correct?
I consider it negotiated through the process of offering early settlement offers through a notice of alleged violation conference where we have open discussions back and forth.
Sure.
Where we request additional evidence throughout the whole process. So where we discuss the violations and the penalty calculations in these conferences. So where we respond to the evidence provided. So I mentioned factors of increasing the penalty. We have such factors, as I mentioned, with cooperation, et cetera, where we can decrease.
Sure.
We're always allowed that potential to remove a violation should we see there's at least insufficient evidence, or if there's a gray area, call it a gray area, we'll remove it.
Okay, but we're past that phase, right? We're past the negotiation phase. The division's here asking this commission to award $30,000 against Edge over Edge's objection, correct?
Mhm.
So yes.
Correct, I'm sorry.
Okay, and you believe that the division has made the determination that this section right here, assessing a penalty for both 3S2 and 3S4B would be duplicative, right?
It had that potential.
Okay.
Duplicative.
But 3S2 says the asbestos cement roofing shingles, siding, or other asbestos cement products must be removed in accordance with section 3S4. You see that?
I do, well, I don't see it, but I hear you.
Okay, not just 4B, but 3S4, which would include 3S4A, 3S4B, and 3S4C, correct?
Correct.
Okay, but the division is not removing 3S4A or 3S4C. They're only acknowledging that 3S4B is duplicative. Wouldn't you agree that it's all duplicative? If you're asking for $5,000 under 3S2 and then another $4,000 under 3S4, which are the same requirements on Edge, wouldn't you agree that's duplicative?
No, I would agree that's why we have section A, B, C, or D. That's why, that's why we break it up.
3S2 incorporates all three of those, right?
I would want to right now read that whole section. I break these down into elements, a specific citation. I call them elements. I would read it again right now and again. I'm going to emphasize that I haven't looked at this for over a year, but nevertheless, this was considered and reconsidered and reconsidered. And look, this is not a one-off. We look at these over and over and over again. We allowed for the elimination of one because it could be considered duplicative. It was Laura's decision that the rest were not duplicative. I can attest to that.
You don't know the basis for that decision?
Based on the language of the reg and a reading of the reg, a reading of each section. Again, I'd have to have that in front of me to address it.
Does she have the joint exhibits?
Yes. It's the big binder there.
Well, let me just see if I can do it this way. If you could handle that, go to joint exhibit 38, please.
Regulations.
Yes, please. 3S2. What?
Mike, do you know what page that's on?
59 in the regulation. I don't know what page of the.
Okay.
Yeah, can you tell me what of 3S2 did Edge violate that was not also a violation of 3S4?
Here is where I would go back to the compliance determination order, the line item that addresses this, and the language that Laura used in that line item to specifically address which section she referenced. We can go back to that compliance determination order to see this section of regulation and what language Laura chose to clarify the violation. So this is where we can reconstruct, not just monetarily from formulas, but, and I'm talking reconstruct because Laura's not here, but we can reconstruct it through the language that's been used in the enforcement documents, specifically the compliance determination order and those lines. I know that one of them it's in the second section entitled conclusions.
Sure.
That each one of these is addressed. And Laura, at a minimum, provides language as to why this section was cited and violated.
And the commission has those compliance determination
Yes.
letters. Your counsel could ask you to go through that with you if you want. I'm just asking, as you sit here right now, can you tell me how Edge violated 3S2 in a way other than subsections of 3S4?
In order to do that justice, I would need to look at the compliance determination order.
Again, without looking at that, you cannot tell me.
I didn't create the document, so I can't attest to that.
Thank you.
Redirect.
Just a moment.
You have the doc, okay. When did you find out that you were gonna be a witness in this case?
Last Wednesday.
So you had about a week to prepare for this?
No, I had,
Take your time.
maybe 4 hours.
The penalty matrix that council was asking you about, is that a sensitive document?
Yes,
Why is that?
an internal document. I don't have the exact legal terms, but I consider it maybe deliberative. So we use it internally. It's not a public document.
In your written testimony on pages 7 and 9, we don't have the document up right now, but you can perhaps look at it on your screen. Pages 7 and 9, there are ranges given for each of the violations that are in the compliance determination letters for Edge. Where did those amounts come from?
Can you repeat the page number?
Page 7 and page 9. I believe.
Thanks, Mike.
Yes, let's see, page 7, lines 28 through 31, or is that 9? Page 9, lines 28 through 31. are for Leadville, it looks like. Do you see those?
I believe I do. I'm on page 7 at the very bottom.
Okay, yeah, sure. 7 at the very bottom, if you could scroll to 7. And that's page 7, lines 25 through 28. Do you know where those amounts came from?
The assessment table.
So those amounts, actually, those ranges for each of the relevant violations here have actually been provided to Edge.
Yes.
On page 10 of your testimony, your written testimony, you explained your methodology for applying aggravating factors. Kind of went through the math that council was asking you about. Is the math the same for all sites? Essentially, you know, you plug in your base penalty and then the math is kind of,
Yes.
so you didn't do anything for this site that would have been different for.
Nothing different at all.
How many penalty calculations do you do per year, would you say?
Myself.
Sure.
Hundreds. Well, in a year's time, I wouldn't say hundreds. Maybe 75 to 100.
And how long have you worked with the division?
Just over 7 years.
So you've potentially done 700?
Yeah. Yes.
How do you ensure that penalties are fair across all facilities?
Because Laura and I
If we can take a quick break if we need to.
No, I'll be good.
You sure?
Can you state the question again?
Sorry. How do you ensure that penalty calculations are done fairly across all facilities?
We review all the cases that have occurred in what I would consider and what you would consider the recent past, 1 year, 2 years, 3 years, 4 years. For any similarities, we have tracking spreadsheets that tell us how many citations for this particular case, what was the penalty, and we have a range. So we have a range. We always check that. We don't want to be out of the range. So that's just another step we take to ensure that any penalty we assessed is at least at a minimum standard comparable to what we've assessed in another case.
Do you take a lot of care to do that?
That has been my major focus since I started 7 years.
Can we put up 3S2 on the screen? I want to ask you about your testimony where you talked a little bit about the recalculation and potentially duplicative penalties and how you had, when you looked at this, you recalculated and said that the correct penalty, or maybe one version of a correct penalty, would have been $30,000 to avoid some potential duplication. Yeah. So council was asking you about 3S2 and asking you about why there wasn't just one violation for this whole thing for 3S2. Can you, just reading 3S2 there, it looks to me like that's talking about friability and saying, it says that these products are non-friable and will remain non-friable during removal. And then it obviously says it must be removed in accordance with section 3S4. Is that your understanding of that section?
Yes.
That it mainly has to do with friability.
Yes.
Okay, and then if you could scroll down a little bit. And then the only violation under 3S4 that has anything to do with friability is 3S4B, correct?
I would agree with that.
Okay, so the remaining violations in section 3S4 do not concern friability.
Exactly.
Thank you, Ms. Foley, you excused. I understand that to be the division's last witness.
That's it.
Okay. Mr. Cross?
No witnesses.
No witnesses from Mr. Cross. All right. Any reason for a rebuttal at this point?
We do have some deposition testimony from witnesses that aren't here today that we would like to highlight and read into the record briefly for the commission, perhaps after a short break.
Okay, we'll take a 10-minute break and we'll come back. We'll call it 2:20. Going, thank you. Okay, division.
One moment.
Oh, sorry.
We're just getting situated here.
Ready?
Yes, so commissioners, for the witnesses who weren't here today for us to cross-examine them, we are relying on portions of their deposition transcripts as our cross-examination, and so these records are obviously voluminous, and we wanted to provide for you kind of excerpts for the things that we are relying on in our case to effectively cross-examine these witnesses. So at this time, we'd like to read some selected portions of those deposition transcripts. We promise that we will try to go quickly through this. We thought it was important that you hear and see these, although these are in the record. We thought it was worth spending some time going through what some of these witnesses said. Again,
Just to be clear here, we're talking about, a limited recitation of the actual questions and answers, no argument.
no argument,
That's coming
simply putting language on the screen from the depositions with the citations, and you can review those yourself. And these are, like I said, voluminous summarization of voluminous records, and that's what this is intended to do.
Okay.
Okay, starting with the first slide, this is Mr. Rodriguez's testimony about what he saw at the Leadville site when he first arrived. If I had just read the permit, I would have asked more questions and made more phone calls, maybe even called you guys. And then later on, I told myself so many times before even starting the removal, just to leave. And this is from Joint Exhibit 35. You'll find page numbers at the top there. These are all from Joint Exhibit 35.
And I'm sorry, I didn't hear what site this was referring to.
This is for the Leadville site.
Okay.
Michael Rodriguez was Edge's on-site supervisor for the Leadville site. Question, how many workers do you think you would have had? Do you think you should have had to do the job? Answer, I believe at least 4 and better equipment. Question, can you tell me about the equipment you had and what better equipment would mean? Answer, I only had 6 foot ladders when we needed minimal extension ladders, and not just 1, 2 extension ladders. But if I had the authority, I would get bucket lifts out there, some kind of man lift. Something where we could work in a safer way because ladders aren't that safe. This is testimony about what he did before starting work. Okay, and after you had picked up the pieces in the area where you were going to start work, you started removing siding where the balconies had been? Answer, yes, ma'am, but before removal, obviously, we cleaned the floor and then we laid down our poly drops. We cored off our caution tape, an asbestos sign was put there. Our permit was posted and we had our bags, our suits, our PPE, and then we began removal. This next slide is his testimony about whether Edge was removing nails and whether that was causing breakage. In certain instances, there was little corners of it where the nails are attached. And on some of them, I did notice breaking at the nail point right there. And then later on, question, so David was prying the siding off without removing the nail first. Answer, yes, yup. Question, okay. Answer, see, I know now that the permit specified clipping the nail heads and all that. I did not know that back then. This is testimony about the work practices in Edge's notice. Question, so you hadn't read the work practices section at the time Jeff asked you? Answer, yeah, I hadn't read it. Question, you had not? Answer, no, I had just started my day off. This is testimony about the airless sprayer and its location. Question, so when you say the airless is right here and it looks like you're Answer, it's right here. Question, where are you pointing? Answer, at the base of the ladder. It's at the base of the ladder because that was the most convenient spot so me and him could share the airless. Question, would you say the second rung, the first rung, which rung? Answer, maybe sixth rung. I had to step up to get it. I had to step up to get it. And he had to step down to get it. We were both just compromising, trying to get the job done. This next slide is testimony about the transite on the liner. Question, there's several pieces of transite on top of the poly, right? Answer, yes, ma'am, too many. Question, why do you say too many? Answer, because I had stepped away I was taking bags to the trailer, and David had prepped this area and had started removal, and I hadn't made it quite back yet to help him pick it up. So I believe he got a little overzealous in the rhythm of work, and there was more debris than we would have liked to have had on that floor. Because it's removal and bagging, and here I was literally carrying bags to the trailer when this happened. This next slide is testimony about what happened to the transite when it landed. Question, so are you saying it may have fallen and broken but stayed on the poly? Answer, yes, ma'am. Question, okay. And you were concerned if it had fallen broken and the pieces came off of the poly? Answer, yes, ma'am. Question, but you were not so concerned if it broke but stayed on top of the poly sheeting? Answer, yes, ma'am. This is testimony about the photo that is currently at Exhibit 32, Division Exhibit 32. Before I do that, you picked up Exhibit 52, which in this case is now Division Exhibit 32. It was numbered differently during the deposition. And said, it's a horrible picture? Answer, it is. Question, why do you say that? Answer, because if it would actually show how I had everything set up, how everything was set up and corded off, it would have been a more professional look to it. This angle is like someone went crazy. The next slide is more testimony about the photo that is at Division Exhibit 32. This right here is like 5 minutes of what he dropped in 5 minutes while I walked away. Then later on.
Yep.
Exhibit 52. Sorry.
You're fine, sorry. Chop it up.
The debris we see on that photo is about 5 minutes, you think. And then finally, last slide on Michael Rodriguez. This is more testimony about the picture at Division Exhibit 32. Question, when you say it shows a big doo-doo, do you mean that's more transite pieces than you think and then should be there on the poly? Answer, this is something I would see at a job site that wasn't professional. Question, why isn't it professional? Answer, because there's too much debris. Like I said, it's just because I was shorthanded. I didn't have the right equipment, and we were trying to do the most with the least of what we had.
Commissioners will now read in deposition testimony of Mr. Alberto Moda. Thank you. Moda was the EDGE supervisor at the Pine Creek location at the inspection on June 15th. Mr. McGowan inspected the site. This is testimony about when Mr. Moda usually arrived at a work site. My first question is, how soon, or do you know when you first arrived on site that day in proximity to when Mr. McGowan arrived on site? Oh, so yeah, if I'm not mistaken, we would arrive on the job site at 7 a.m. Question, okay, answer. So usually I get there 20 or 30 minutes prior to crew arriving. Question, okay, do you recall if you arrived at 7 a.m. on this particular day, or is that just your normal standard habit and practice? Answer, honestly, I wouldn't be able to say for sure if I arrived at 7 a.m., but that was usually the time when I will get there. There's other day, depending on the weather, sometimes 7:30 a.m., 8 a.m., 9 a.m., but it's hard to remember exactly what I arrived that day. This is testimony about identifying the critical barrier that had failed. The deponent. Okay, yes, like I said earlier, we both noticed. I had just walked away from that area like 2 hours prior. We were outside working because of the heat. That's why Ryan sent us out somewhere else. So we both noticed, both Senator and I noticed the critical was down. This is testimony about power issues at the Pine Creek site. Question, and did the fire to the building affect any of the power to the building? Were there any power issues on that project? Answer, from what I believe, yes, there was issues at the beginning. And then later on, they were able to hire someone to come in and isolate what we could draw power from the interior of the building. Question, okay, did the building lose power during the project? Answer, multiple times, yes. More testimony about the power issues at Pine Creek. Answer, yes, that's not true because we go back to we kept having issues with the power. There wasn't sufficient power to keep everything running. So once in a while, I guess it would overheat and then it would trip the breakers on our machines. A couple of machines would turn off and that would drop our pressure. And this is testimony about the theft issues. Question, but you guys were experiencing enough break-ins that someone hired a security company to be on site? Answer, after the second break-in, they hired the security company. And I think Front Range is not the company. I honestly don't remember who it was. Question, what number of break-in was that one? Do you remember? Answer, I don't remember what number it was, but I'm pretty sure there were about 4 or 5 break-ins through the project. This is testimony about the weather and containment issues at Pine Creek. Question, you stated that the 3rd floor was exposed to the outside. Have you worked at sites where that's common? Answer, oh, yes, for sure. Question, and when you know that there's a site is exposed to the outside, does that make it more difficult to maintain your critical barriers? Answer, not necessarily. It's just that it's like any other opening. There's just a critical, some are bigger, some are smaller, but this job, we just had so many issues with the weather. This is further testimony about weather impacts. Question, and assuming, given your experience, you've been on a lot of jobs where there's bad weather. Answer, yes. Question, when you know that bad weather is a factor in your containment, do you keep a closer eye on the containment? Answer, we do. We usually do just try to make sure at the end of the day, everything is nice and tight. First thing in the morning, check everything once again. Obviously, you're going to have some days where criticals fall, but yeah. Next is testimony about EDGE's practices concerning the manometer. Question by Mrs. Splittick. When you were at the site earlier, on the 50 or so days that you had been on the site, on any of these days, had you ever set the printer? Answer, ma'am, everything was set except the printer being online. I don't usually leave the printer on. Question, okay, so you didn't have any printouts from any days that you had been on that job? Answer, at the beginning of the job, we did, but they had stolen another manometer. This is further testimony about the manometer. Question, and is there a way to download data from a manometer like this? Answer, if you scroll through, there's like a little port where you can connect the cable. Oh, the USB right there. Question, right there, indicating. Answer, yeah. Question, the USB port? Answer, right there. Question, okay, you could do that, but honestly, I've never done it. I've never seen it done. This is testimony about the pop-up clean rooms. Question, okay, you said you used PVC pipe to construct it. Did you typically store clothes up in the piping in the top of the clean room? Answer, no, sir. We would usually put them, I don't know if you can see where the water heater is at the ground. Usually our guys will put them in black bags or not leave them in bags, put them on top of their work boots per se, but not really inside that room. Finally, this is testimony about Mr. Moda's experience in replacing containment after teardown. Question, okay, so you have been working with EDGE for a number of years at that point. Have you ever worked on a site where you've rebuilt containment after tearing it down? Answer, yeah, with them, no, I never did.
Next, we have limited deposition transcript, parts of the transcript from Josh Berard, who is one of EDGE's experts in this case. His deposition transcript is a joint exhibit 42. First slide. This is testimony about Mr. Berard's qualifications as an expert. Question, are you certified in engineering and methods for abatement? Answer, no. Question, are you an expert in methods and engineering related to abatement? Answer, okay. I mean, I don't know if I would say I'm an expert, but I worked in the abatement field for a few years, so I'm pretty aware of what needs to be done. I guess as far as word for word, the regulation, it's pretty extensive. So I may not know it, from front to back, but yeah. Next slide is testimony about Mr. Berard's work history. Question, okay, you are a former Edge employee, correct? Answer, correct? Answer, correct. Question, when did you work for Edge? Answer, I believe it was 2016 to 2018. Later on, question, okay, what was that time from 2016 to 2018, the sum total of your experience in asbestos abatement? Answer, abatement, yes. And you said it was 18 months? Answer, about. Question, I'm not looking for an exact, but about 18 months? Answer, yeah. And then this last slide is testimony about his expert opinions in this case. Question, you have not reviewed any documents of the time Edge was doing their work at the site to determine if they were doing that work correctly? Answer, no. Question, you don't intend to offer any opinions about the correctness or quality of the work that Edge did at the Eagles Nest site? Answer, I can't. I can't really make an opinion on that since I really have no idea. And then we have one final document. I promise we'll try to go through this quickly. That's Carl Cox. His deposition transcript is a joint exhibit 43. First slide, question, do you have any formal education or degrees in engineering? Answer, no. Do you have any formal degrees or education in material sciences? Answer, no. Do you have any education or formal degrees in physics? Answer, no. Next slide is testimony about the information underlying Mr. Cox's opinions. Question, did you look for any scientific literature in performing your opinions today? Answer, I did not.
Slide misalignment there.
Oh, yep, there's a slide misalignment there. I'll finish reading this one and we'll. I did not. Question, did you look for any guidance documents that maybe were put out by various industries that were involved in asbestos abatement? Answer, no. It's my understanding that this is a case, did or did not Edge violate Regulation 8. So that's what we are here to talk about. And that's on page 50, lines 7 through 15.
Which one do you want?
We have a version control issue, sorry. Okay, I'm on page 125, lines 8 through 10 and 23 through 25. I'm just gonna read through these and
Exhibit
there we go. Yes, exhibit 43. Question, as you sit here today, can you think of any instance where you dropped transite 20 feet? Answer, I cannot. Later on, question, have you ever seen anyone else drop transite from 20 feet high? Answer, no. Now I'm on page 63, lines 7 through 21. Question, what's the last transite removal job that your company did? Answer, I'm not sure we started it. I'm not sure we started it yet or not. At Porter Hospital, there is a phase that either went last week or goes this week, so currently. Question, and is that transite that is on the outside of the building? Answer, it is. Question, how high up? Answer, it varies. It is 20 feet up around the 3 sides of the building, and the 4th side of the building, you can remove it by standing on the next building's roof. Question, you're not going to remove it with a ladder? Answer, no. On that project, I already have a lift on site. Now I'm on page 124, line 23 through 125, line 1. We're usually above ground and usually have lifts. So it would be unlikely that we would have a scenario where we would have dropped something like this. And that testimony was given in relation to how Mr. Cox usually conducts transite removal jobs. The next slide includes testimony about removing or clipping nails. Let's start with that. Pulling nails or clipping the heads of the nail. Why would you want to do that? Sorry, there must be something missing there. Later on line 15, question. So it would be designated to prevent damage. Answer, yes. And ensure that removal is done carefully. Correct. Next slide is testimony about removing transite in full sheets. Question, and the reason that it is pulled down into entire sheets is to prevent breakage. Answer, correct. The more intact, the more you've tried to complete your goal of minimal breakage. This next slide is about page 128, lines 6 through 12. This testimony is about the photograph that is at Division Exhibit 32. Question, are you able to tell me where minimal breakage occurs? Answer, minimal breakage is in the regulation and it is not defined. So I do think this meets the regulation for minimal breakage. I do. And that's as far as I want to go with your spectrum thoughts. And then the last slide, page 136, lines 1 through 3 and 5 through 10. Question, why take the risk of dropping it on the ground, onto the ground and risking that it's going to break even further? Why not just remove it with a scaffold? Answer, I don't know why they didn't use scaffolding. Could they have used scaffolding? Answer, probably, because this scaffolding is based on the ground and it looks like they probably could have. And that's all of them.
Okay. So we call this rebuttal a second ago. You introduced it as kind of cross of Edge's witnesses. In that case, I'm going to give Edge an opportunity, should they choose it, for a redirect.
No redirect.
Okay. No redirect, no rebuttal, I'm assuming.
Nope.
Okay,
Correct.
In that case, I believe we are ready to proceed to closing arguments.
Right. Be important for his work. That's closing. Closing too, yeah. Working?
Yeah.
All right.
Commissioners, we appreciate all of your time today. I know this was a long hearing. It's been a long day. You have a lot of documents before you. You've clearly read a lot before this hearing and heard a lot at this hearing. So thank you for your time and attention to this. As you heard this morning, the standard of proof in this proceeding is a preponderance of the evidence. So if you think that there is even slightly more evidence on the division side of the ledger here than on Edge's side, you should uphold the violations in the division's compliance determination letters. I'd like to walk you through some of the key evidence that supports those compliance determination letters. We'll start with the violation at let's start with the violations at Leadville. And we'll talk first about the violation that Edge rendered the material friable. Jeff Wolf, the inspector for that site, told you that he saw Edge breaking dry siding off of the exterior of the building in violation of the approved work practices. He said he saw them toss it to the ground from 20 feet high, where he observed the siding bouncing, breaking into more pieces as it hit the ground. This is a photograph of what he saw. shattered pieces of transite scattered all over, on and off of the poly liner that Edge had placed. There were some questions about the surface that this landed on. I would note that it appears to be a dry, hard surface. And if you see in the forefront there are actually rocks, big rocks, right there. I think there was some testimony today about landing on hard things. It's possible that that transite landed on some of those rocks. Mr. Rodriguez testified that he had cleaned up this area prior to starting work that day. So that means that anything you see there in that photo came from Edge. Jeff Wolf physically touched the transite that fell on that liner, and he determined that it was friable, something that he has extensive training on and has done many times throughout his 15-year career with 10-year career with the division, a 15-year career in asbestos in total. The testimony of Curtis Burns supports Inspector Wolf's findings. You heard from Mr. Burns that transite can be brittle and subject to easy breakage if it is compromised, impacted, or mishandled. Inspector Wolf is the only person that you have heard from today and who has testified in this proceeding who physically touched the transite and made a friability determination with his own hands and with his own eyes. To counter Inspector Wolf's friability determination, Edge has offered not one, not two, but 3 different expert opinions to offer the same opinion, that dropping transite from a height of 20 feet will not render it friable. Those witnesses are Ryan Whitcamp, Josh Berard, and Carl Cox. None of those experts saw the transite in question or determined that it was friable themselves. And 2 of them aren't even here to testify today, to be cross-examined or to answer your questions. I do want to note that Ryan Whitcamp is online. Not only do these expert opinions fly in the face of what Inspector Wolf saw with his own eyes and felt with his own hands, they are simply not credible. Ryan Whitcamp, Edge's owner, is not an unbiased expert. He is an actual party in this case. He is the owner of a company that is facing enforcement. He has no active certifications, as you can see from the text on this slide, and hasn't had any relevant training in 5 or 6 years. And finally, he wasn't even present at the site in question. Josh Berard, Edge's second expert, admitted that he's not an expert in asbestos abatement practices. The sum total of his experience in asbestos abatement is 18 months working for Edge. Although Mr. Berard is an asbestos building inspector and therefore is qualified to make friability determinations, he did not physically observe the transite that was dropped by Edge on that day. Nor did he make a friability determination based on any personal observations of that transite. Mr. Berard also said that he hadn't reviewed any of the documents related to Edge's work practices or engineering methods, and had no idea what equipment they'd used, hadn't looked at any pictures from the inspection, and had no opinion on the work that Edge did. And Carl Cox, Edge's third expert, has no formal education in engineering, material science, or physics, and no specialized training in making friability determinations as an asbestos building inspector. What's more, Mr. Cox admitted, as you see on the screen here, that he has never seen transite fall from a height of 20 feet and has never seen anyone do it either. Mr. Cox's opinion about what would happen if you dropped transite from a height of 20 feet is nothing more than pure speculation. He has never seen it and he has never done it. Ultimately, what Mr. Cox says about the effects of dropping transite are not credible. All 3 of Edge's experts contend that dropping transite will not render it friable. These opinions are directly contradicted by a 1992 EPA memo that you heard a lot about, providing guidance on what kinds of removal practices will render transite friable. EPA concluded in that document that dropping Category 2 materials such as transite panels from a building as a means of transporting it to the ground will also cause the ACM to be regulated, in other words, friable, in most conditions. While Edge maintains that it is not responsible for the damage to the transite that was caused by the contractor that came to the site before, who removed the decks, Edge is certainly responsible for its own handling of the material, for ripping it off the building, and letting it free fall from a height of 20 feet to shatter onto the ground and into pieces. Let's discuss the regulatory language. In maintaining that transite cannot be rendered friable by dropping, Edge's experts ignore or misinterpret language in Regulation 8 and its statement of basis and purpose. Mr. Burns walked you through all of that language today. Regulation 8 is clear that heavily breaking or damaging a material will cause it to become friable because it reduces the material to a state in which it is likely to emit asbestos fibers. Remember, that's what we're worried about. We are worried about the likelihood of a material releasing fibers into the air where people could breathe them in. And while section 3S4B, which you see here on the screen, gives examples of cutting, grinding, sanding, bead blasting, and sandblasting as prohibited activities, it goes on and it further states that it is prohibited, contractors are prohibited from doing anything that would otherwise damage the material in such a way as to render it friable. It is regulatory interpretation 101 that all words in a rule must be given effect. The final clause of this provision in section 3S4B clearly indicates that there are more ways to render a material friable besides the examples that are given in the first part of that sentence. In case there was any doubt about this, the statement of basis and purpose speaks directly to how improper removal or handling will render transite friable. The statement of basis and purpose for the 2021 rulemaking states, when these materials are not removed intact, the matrix will crumble, which will allow the asbestos fibers to be emitted. In the end, Edge's experts' opinions fly in the face of guidance from the EPA, the clear language of Regulation 8, and the statements of this commission in adopting the regulatory language. And again, nothing that these experts say overcomes Inspector Wolf's friability determination. Remember that he touched the material and he was able to render it friable. Edge rendered this material friable. Let's move on to the requirement to handle the material carefully with minimal breakage and disturbance. As an initial point, I want to note that the requirement to handle non-friable material carefully with minimal breakage and disturbance is separate and apart from the prohibition on rendering it friable. In other words, even if Edge hadn't rendered the material friable, it still violated section 3S4C because it did not remove the material carefully with minimal breakage and disturbance. Regulation 8 does not define carefully or minimally. That means you should give them those words their plain and ordinary meaning. Edge's actions do not comport with any definition that you could possibly find of those terms. Let's talk about the removal notice that Edge filed. You heard that one function of the approved removal notice is to put in place work practices that will minimize breakage and disturbance. Edge did not comply with those practices. Edge's supervisor on site, Mr. Rodriguez, admitted this at a deposition. You can see the text on the screen from that deposition. He admitted that he didn't read the notice and that the workers that day did not follow it. Edge was removing the transite in full sheets without clipping or pulling the nails prior to detaching it from the building. Edge's failure to follow its notice, which was a requirement, is one fact among many, which supports a finding that Edge failed to remove the transite with minimal breakage and disturbance. Why remove the nails? Because as Mr. Burns told you today, if the transite is pried off the building without removing the nails, it will break at the corners, causing more damage than necessary. Removing nails is a simple act that saves from additional breakage. Edge's owner, Ryan Whitcamp, said the same thing, and you can see the text on this side from his deposition transcript at Joint Exhibit 41. We know that Edge's failure to clip or pull nails before removing the transite actually did cause additional unnecessary breakage. This is a portion of Michael Rodriguez's deposition transcript, which is at Joint Exhibit 35. And on this page, at page 52, Mr. Rodriguez testified that he had observed his colleague prying the siding off without removing the nail first. And as his colleague was doing so, Mr. Rodriguez said that he noticed breakage at the nail point. Why remove the transite in full sheets? You heard today that that's also designed to ensure minimal breakage. Edge's expert, Carl Cox, agreed with that. As you can see from this language from Joint Exhibit 43, his deposition transcript, page 115, he said that he agreed that the more intact, the more you've tried to complete your goal of minimal breakage. Edge would have you believe that they did the best that they could given the circumstances, that they were just cleaning up a mess that someone else had made. If they were just cleaning up a mess that someone else had made, we would not be here today. They were making an even bigger mess. Mr. Rodriguez testified that all the transite that you can see in Division Exhibit 32 was put there in 5 minutes. This is his deposition testimony to that effect. Whoops. At page 61 of Joint Exhibit 35. He said, "This picture shows a big doo-doo. This is something I would see at a job site that wasn't professional. There's too much debris, I was short-handed, and I didn't have the right equipment." While Edge is not responsible for the condition of the transite as Mr. Rodriguez may have found it that day, Edge is definitely responsible for its own mishandling of the transite. What Edge did resulted in further breakage of the material, as evidenced by Mr. Wolf's eyewitness testimony. One final point, the Ortiz brothers did not do anything that you see in that picture. That was all Edge. These facts speak for themselves, which could be why there is not a single witness on Edge's side who stands by how Edge removed that material. Not a single one of their witnesses says that what Edge was doing that day was the best, most careful way to remove the transite. Edge's owner, Mr. Whitcamp, testified that if he were doing the work that day, he would have had 2 workers up on the ladders, both on ladders. He would have had one of them removing the transite and carefully handing it to the second person, who would then place it in a bag. And once the bag got heavy enough, they would slowly lower the transite to the ground in a bag, where it would then be double bagged and then placed in a dumpster. This is exactly how EPA said that this job should be done. You can find his deposition testimony on this slide, but it's also at page 125 of Joint Exhibit 41. Notably, Mr. Whitcamp said that this method that he would have done if he was there that day would minimize breakage. That is not what Edge did. Edge did not do this. Let's talk about what Mr. Cox said. This is deposition testimony from Mr. Cox at page 136 of Joint Exhibit 43. In addition to saying that he as a general practice, does not drop transite, as we discussed earlier, Mr. Cox testified that Edge could have used scaffolding at this site, and he didn't know why they hadn't. Edge did not use scaffolding at this site. And finally, Mr. Rodriguez himself, at Joint Exhibit 35, page 62, said that 1 ladder was less than ideal for performing this removal, and he, like Mr. Whitcamp, would have preferred having 2 ladders, or even a man lift, which he said would have been better and safer. Edge did not use 2 ladders. Ultimately, 3 of Edge's own witnesses proposed ways that Edge could have done this differently to minimize breakage and disturbance. Edge did not do any of those things. Edge ripped the transite from the wall, breaking it over the nails that they hadn't removed, and dropped it to the ground below from a height of 20 feet, where it shattered into pieces onto the ground. You can see that in this picture. From Division Exhibit 32. Finally, let's talk about adequate wetting. Section 3S4A requires general abatement contractors to adequately wet the surface areas of non-friable ACM to prevent dust emissions throughout the removal process. Mr. Burns walked you through some of that language and why it supports the idea that transite must be continuously sprayed during the removal process. Inspector Wolf testified today that he did not see and did not hear an airless sprayer. It would have been very loud. You heard him say how loud that would have been. He also said that the material on the liner was dry. He saw no evidence of water, no evidence of wetting. You can draw your own conclusions about whether you see any signs of wetting in this photograph. If you believe Inspector Wolf and your own eyes, that is enough to uphold the division's determination. But in case you need more, Mr. Burns testified that the key point in time for wetting is the moment of breakage, because that is when asbestos fibers will be released. According to Mr. Burns, wetting must be done simultaneously with removal. Pre-wetting and post-wetting is not sufficient to meet the adequately wet requirement in the regulations when it comes to transite. Edge argues that this is a heightening of the requirements of Section 3S4A, but it is not. It is simply applying the language of 3S4A and applying it to the purpose of spraying. It is the purpose of spraying to prevent emissions of asbestos. So what Mr. Burns says is in fact entirely supported by and consistent with the regulations. Let's explore how Edge claims that it was wetting this material. Edge would have you believe that its 2 workers were sharing a sprayer, tediously and methodically handling it back and forth from about the 6th rung of the ladder. One stepping down to get the sprayer before removal, the other stepping up to get it after they let it fall to the ground. I'd like you to take a moment to consider how that would work. Well, the video that Inspector took is grainy. It does clearly show someone working at height and someone at the bottom of the ladder on the ground. You don't see at any point in that 40-second video the person on the ladder moving up or down the ladder, nor do you see any movement that looks like spraying. And the person on the ground is walking away from the site. That person is not using a sprayer. And of course, Inspector Wolf, who watched this all happen with his own eyes, has testified that he didn't see any of that. As the fact finders, you can draw your own conclusions about whether Edge was following practices that would have enabled them to adequately wet the transite. As I close out on the Leadville violations, I want to make one final point. Think back to Mr. Wolf's testimony that Edge was working at an occupied apartment building. It was the middle of summer in Leadville. It was a beautiful summer day. Residents had their windows open and they were walking through the site. Mr. Wolf testified that there were kids walking around the site. The people that were walking through that site were not wearing protective gear. Edge's workers, on the other hand, were. They were wearing full protective gear with respirators and everything else, protective suits and all the other things that they are required to wear. Jeff Wolf also said that this was one of the worst sites that he has ever seen in his 15-year career. There is no known safe level of exposure to asbestos. What Edge did that day put people at risk. And we're asking you to hold them accountable for that. Let's move on to the Denver site. Take a water break. Again, there are 3 violations at Denver. This is the compliance determination letter, which is Joint Exhibit 22. I'll start with the allegation that Edge failed to maintain and record negative air pressure in the work area. Negative air pressure serves as a vacuum, keeping contaminated air from leaving the work area. As you heard from Mr. Burns, if negative air pressure is lost at any point in time for any amount of time, asbestos fibers can be released into the clean area where unprotected people could breathe them in. There is no dispute in this case that Edge's containment failed. There is no dispute that Edge's manometer was in no condition to be accurately measuring and recording the negative air pressure. The alarm wasn't sounding, the printer wasn't on, and none of the project data was programmed into it. Edge would have you believe that acts of God or events outside of Edge's control excused any failure to maintain negative air pressure. The division recognizes that things happen which may be outside a contractor's control. However, given the inherent dangers that are posed by asbestos, when those kinds of things happen, the expectation is that they be identified and fixed quickly. This is all the more true when issues are ongoing and recurring, as Mr. Moda says they were. Mr. Moda said there were recurring power losses at this building. They had recurring issues with the weather. They had recurring thefts of things at the building. There is ample evidence in the record that Edge did not identify and fix issues quickly. First, Alberto Moda, Edge's on-site supervisor, said they'd been having ongoing issues with containment. We acknowledge there were issues with this building. There were holes in the roof. There were issues with power. Edge knew all of this. The key point is that Mr. Moda said that when these issues happen, you have to keep a closer eye on containment. Second, Inspector McGowan told you that when he arrived for the inspection, which was around noon on a Tuesday, he found the crew outside and they were getting ready to leave. The containment failure was readily apparent to Inspector McGowan, who says he pointed up to it and pointed it out to Edge's supervisor. And he asked to go inside and check the situation out. And only then did the issue get fixed. Third, Mr. Moda, Edge's supervisor that day, testified that he had been there earlier that morning. He may have gotten there as early as 7 a.m. because that was his usual practice. That's the time that he usually arrived on site. When asked about the inspection, he stated, "I had just walked away from the area like 2 hours prior." There was testimony from Mr. Moda about how he and the crew, or he had arrived at the site earlier on and left the site and then came back. We're not exactly sure when, but sometime around when Inspector McGowan showed up. So if he was there earlier that day, he did nothing to notice or fix the issues. Fourth, there's weather data that we've gathered, which you can find as Joint Exhibit 45, which indicates that a storm may have happened on June 13th, 2 days before the inspection, not the night before the inspection. But even if you assume that the containment and the power failed the night before the inspection, that's what Edge contends happened. Why didn't Mr. Moda fix them when he arrived on site that morning? He had been on notice about the weather, obviously. He had been on notice about the power issues. And he admitted that those conditions would cause him to keep a closer eye on this site. So why wasn't he inside fixing it when Inspector McGowan arrived? Remember that the containment failure was so glaringly obvious to Inspector McGowan that he noticed immediately when he walked up. And he asked Mr. Moda to stop what he was doing and go inside to further inspect. And upon going into the building, they discovered additional issues with the manometer and the other violations that you heard about today. Aside from the containment failure, the condition of the manometer shows that this was not just a simple case of a machine that failed or an act of God. A loss of power doesn't excuse the lack of paper in the manometer, which Mr. Whitcamp admits was required. Mr. Whitcamp said, there's testimony from him on this slide, quote, "It has to be able to print, it has to be functioning, it has to have paper in it. So we make sure the printer is on and it's doing its job and they can shut the printer off." There was no paper in this manometer. Mr. Burns testified that paper printouts provide assurance that asbestos fibers have not left the work area and that all of the engineering controls that have been utilized have remained intact and effective throughout the entire duration of the project. We don't have that assurance here because of EDGE's failure to record the negative air pressure. Indeed, the whole purpose of having paper printouts is to help in situations exactly like these. If negative air pressure goes out on the manometer loses power, we want to know exactly when that happened, and we want to know how long it was out. We do not have that here. Indeed, Mr. Whitcamp admitted that having a paper printout could have helped in this particular circumstance. You can see that language on this slide. As Mr. Burns and Inspector McGowan told you, USB data is only the equivalent of a strip chart reader of a paper receipt if it can be provided immediately when it is needed. It was not provided by EDGE here. In fact, Mr. Moda testified that he had no idea how to download USB data from a manometer and that he'd never seen it done before. So if EDGE was putting all of its eggs in the USB data basket, it hadn't trained its workers on how to go in and get that data. So while there are some things that happened here that could have been outside of EDGE's control, there were definitely things that EDGE could have done and didn't do to quickly identify the issues and fix them. And for that, they should be held accountable. Let's move on to the clean room violation. It is undisputed that the clean room at this site was a pop-up size clean room, about 3 feet by 3 feet. It's also undisputed that the EDGE crew that day was 4 people. You made those findings when you considered the division's motion for a partial summary judgment. According to section 3K1A of the regulations, a clean room needs to hold clean work clothes, clean disposable clothing, replacement filters for respirators, towels and other necessary items, and street clothes. That's a lot of stuff, especially when you multiply it by 4 people. Not only that, but workers, and as Mr. Burns told you, potentially inspectors who need to come and visit that site and inspect the site have to be able to use that clean room. So it is really important that that clean room be adequately sized. They have to use it to suit up, to don all their respiratory protection on the way to the work area, and then dress into clean clothes after they're done with their shower. There are privacy issues with that as well, as Mr. Burns told you. A 3x3 pop-up is not big enough to fit all of the things that it needs for a crew of 4 people and still have enough room to function as a place where at least one person can change in it at a time. Mr. Whitcamp admitted as much. He stated, quote, "If we had too many people, or if there was, not enough room for everyone's shoes, everyone just sets their jeans and shoes right here." He was looking at this picture at the time. Walks into the pop-up. You can put 5 or 6 guys' underwear and shirt up there pretty easy. You throw your suit on, you take your mask, and you go in. The only complicated part about this is if you try to fit everyone's shoes in there and pants. Otherwise, it works just fine. And Mr. Moda also testified that workers regularly left their clothes and their boots outside the clean room. When looking at this picture during his deposition, which is Joint Exhibit 8. He said that workers typically left clothes outside the clean room. You can read the quote. You can decide whether it's more likely than not that the reason that the crew did this is because clothes and boots for 4 people wouldn't fit in a 3x3 clean room. Let's talk a little bit about the regulatory update. You heard about the regulatory update that happened in 2021. You heard from Mr. Burns that the division pursued this change to the regulation to clarify in the definition of clean room that the room had to be adequately sized for all of the things that it needs to hold because of the prevalence of pop-up clean rooms. The division had noticed a problem with pop-up clean rooms, that they weren't big enough, and they did something to address that in the regulations. You heard from Mr. Burns that they discussed this change with industry and that they made it clear why they were pursuing it. I don't have to tell you all what goes into rulemaking. You know that. You know that there is a lot of work that's done by the division ahead of the rulemaking process to work with stakeholders on regulatory language, to gather their input and feedback, to make changes to the rule based on that feedback. And you know that regulatory entities often participate as parties, very vocal parties. You know that the commission adopts rules in an open proceeding. There is a process. These changes are not made fairly. They are not made in the dark of night. And particularly in a regulated industry where you know there are rules that apply to you, you follow those regulatory updates very closely, or you should at least. It is not unfair for the division to enforce rules that have gone through that process, particularly where the regulated community, as was the case here, had advance warning of the change in enforcement. Even so, regulations have an adoption date. They have an effective date. In this case, the rule was adopted in January of 2021. It became effective in March of 2021. And this inspection happened in June of 2021. EDGE had ample opportunity from January when the rule was adopted to June to learn of the change in enforcement, which was announced to the regulatory community, to ask questions and to put protocols in place to ensure compliance with any new requirements. And finally, the last violation at Denver. The division alleges that EDGE left up critical barriers after completing the abatement work in certain areas of the building. Critical barriers are placed to, 1, make sure that asbestos fibers don't get into places where they shouldn't, and 2, to block airflow so that negative air pressure can be maintained. Regulation 8 requires critical barriers to be treated as asbestos waste once the abatement is done. They have to properly be disposed of. They are considered asbestos waste. So they are disposed of as asbestos waste. And that's because there's a high potential that they are contaminated with asbestos fibers. The photographs in these next 2 slides depict one of the allegedly reinstalled critical barriers. EDGE wants you to believe the unlikely story that these critical barriers were reinstalled after abatement work had been completed to block from bad smells and protect against weather conditions. Testimony from both Mr. Moda, EDGE's supervisor, and Inspector McGowan cast doubt on that story. Mr. Moda testified in his deposition transcript at Joint Exhibit 25, page 72, that he had worked in the many years that he had worked for EDGE, he had never reinstalled containment components. You also heard Inspector McGowan say that he did not think that there was any reason to reinstall these to protect against weather. As you can pretty clearly see, there are no holes in the roof here. The holes in the roof are on the other side of the building. The conclusion that he drew was that these had been left up after abatement work was done and that they hadn't been disposed of properly. As the fact finder, you can decide whether Mr. McGowan's conclusion is more likely than not to be correct. As I close out my discussion of the Denver violations, I'd like to remind you Mr. Burns' testimony that each one of these violations at the Denver site could have led to asbestos fibers being released in areas where they should not be. And this put not only EDGE's workers, but anyone who was entering the building at the risk of exposure. My last point is about penalties. I want to briefly touch on the penalty calculation in this case. You heard from Ms. Foley, and she told you how the division's penalty process operates. They go to great lengths to try to make sure that they are treating people fairly in the penalty process. There is a section of the Colorado Revised Statutes that applies to penalty calculations. And this is what the division applies. And so this is what you need to apply here today, these factors. I will note that this sets a maximum penalty of $25,000 per day for each violation. It directs the division to consider the seriousness of the danger to public health, whether or not the violation was willful, and the duration of the violation, and the record of the person committing the violation. If you find that EDGE committed these violations, we think you can weigh these statutory factors and determine a reasonable and fair penalty. We have provided Ms. Foley's testimony and the division's penalty calculation as a starting point for you in doing that. With that, I'm done. Thank you.
All right. Okay, thank you very much. I thanked you at the beginning of the day. I'll thank you again. I know we gave you a lot of stuff. You guys have been very attentive today. You have very good questions, so we appreciate the attention you're giving this matter. I'm gonna try to be pretty brief. I think the witnesses did a decent job of making as I intended to make, so I'm not gonna hammer them again. But I do want to start in the same order, go through the Leadville project first. Talked about what EDGE encountered that day. I'd like to show some more pictures. These are pictures of the balconies that EDGE saw when it showed up on July 28, 2022, and more balconies. We don't have pictures of every balcony, but no one disputes every single balcony had been ripped off in the entire project, resulting in these photographs taken by Jeffrey Wolf, which show asbestos abatement, asbestos containing material, debris in the soil throughout the entire apartment complex. This is a diagram that Mr. Wolf created, illustrating where the asbestos containing debris was. It was everywhere, every single place. Now down here on the lower left is the building where EDGE was working that day, the only building it worked on that day. The entire apartment complex was an asbestos abatement spill declared by Jeffrey Wolf. That's what they walked into. That's what they had to deal with. And I don't doubt his opinion that that is the worst site he's ever seen, but I hope he agrees that it wasn't caused by EDGE. EDGE wasn't charged with that spill. That was Ortiz Brothers. I will never understand why they are not here and why they are not subject to discipline. Instead, we're focusing on EDGE for removing the fragments that were left behind. So let's go through each of the violations. The first, from the compliance determination letter. The allegation is that EDGE rendered a previously non-friable material friable. Talked about that quite a bit. This is coming from section 3S4. Now the division has alleged that EDGE has violated each of these subsections. I'm going to go through them in the order that the division's compliance determination letter goes through them, starting with section 3.S.4.B. I've made this point over and over again. I'm not going to make it again. There's no dispute that EDGE engaged in any of the activities that are specifically listed in this subsection. We are talking about the catch-all provision, otherwise damage the material in such a way as to render it friable. When I took Mr. Burns' deposition, he agreed with me. There's no definition in Regulation 8 of the phrase rendered friable. We do have a definition of the term friable. which means that the material, when dry, may be crumbled, pulverized, or reduced to powder by hand pressure. Friable also includes previously non-friable material after such previously non-friable material becomes damaged or disturbed to the extent that when dry, it may be crumbled, pulverized, or reduced to powder by hand pressure. It's a fundamental concept. You have to be able to grab a piece of it with your hand, squeeze it. It should crumble, pulverize, and reduce to powder. And in my mind, as I've always thought about it, you should be able to sprinkle fine particles of the material. So we don't have definitions for crumble or pulverize or reduce to powder. This is from Mr. Burns' deposition. So I started asking Mr. Wolf about it. Now, this is something that's very important. You heard Ms. Splittick focus on this intensely, and Mr. Wolf testified to this. He claims that he went on to the poly and he grabbed a piece and he determined it was friable as their key piece of evidence. What I would love to have seen would be a little baggie with that piece in it that he could show you guys today, that he could crush it with his hand. It would resolve this. We wouldn't be here right now, but they didn't do that. They have the burden. They didn't do that. So instead, we're all trying to piece it together based on the limited evidence that they gave us. So during the deposition of Mr. Wolf, I started asking him about this term. I gave him the definition of crumbled from the dictionary, which says, having fallen apart completely, collapsed, or disintegrated. I asked him, would you agree with that? He said, can you read it again? Sure. Having fallen apart completely, collapsed, or disintegrated. He said, having fallen apart by hand pressure, I believe that is correct. So as far as he would go, we talk about pulverize, another word. I gave him the definition from the dictionary, to reduce to very small particles. Do you believe that would reduce to very small particles? His response, it depends on your definition of small. We talked about breakage. And he testified during his deposition, I asked him, any breakage can constitute friable? That's what it says, Regulation 8. That's what it says. Any breakage of any kind of any ACM would make it friable, could be considered friable. Down here at the bottom on line 5, instead of having like close definitions, all of a sudden it sounds like CDPHE is like, you know what? We're just going to say anything can be friable. He says that, I think, is a fair assessment. This is the person that made the friability determination. I talked about it some more. It sounds like you're saying every piece in this photograph, the photograph we focused on all day, could be considered friable because you believe every piece is broken. Every piece could have been considered to be rendered friable. That's correct. On breakage alone, it's exactly what the EPA was afraid of. 30 years ago, they were afraid of that. They went to the effort of providing this document that the division relies on so heavily, where they make note that they had to take the word broken out of the regulation because people were heightening the standard like Mr. Wolf did. They say there is a difference between merely breaking a transite panel and crumbling, pulverizing, and reducing it to powder. There is a difference that Mr. Wolf, who made the friability determination, doesn't seem to recognize. We went through this, and I'm not going to go through it again, but it gave examples. Sanding, grinding, cutting, wrecking ball, implosion. Implosion is literally an explosion. Use of a bulldozer backhoe. That's how you crumble or pulverize transite. Burning. So we asked some people their opinions. They've indicated, or they've suggested that Edge brought in 3 expert witnesses. It's not what happened. We have people that happen to be experts who are witnesses on this project. For instance, this is from Josh Berard. Josh Berard was the certified inspector who performed the spill delineation. He's a witness. To identify that he might give expert testimony because he's a witness and he's also an expert. When asked if a transite tile is reduced to powder, is it releasing fibers? His response, I've never seen it reduced to powder. He says here, if I'm smashing a piece of transite with a hammer for a good 15 minutes, yeah, I could probably reduce it to fiber. There's no way breakage is going to render it friable. This is from Mr. Cox. There seems to be an attack on Mr. Cox's qualification. He's the former president of SEPA. He has managed thousands of transite removal projects. He has testified before this commission. He's involved in the rulemaking process. He's intimately familiar with Regulation 8. He says, transite cement tiles cannot be crumbled or pulverized or reduced to powder with hand pressure. That just cannot happen under in his opinion. Transite is cement board. Humans cannot take cement and crumble it and make it into a powder with hand pressure. Something would have to happen. That something, in his opinion, is some sort of mechanized means similar to what is listed in the document, in Regulation 8. And Ms. Splittick made the point, like, it lists out all those various things: sanding, bead blasting, sandblasting. We have to listen to all of the language, but you also have to consider what is listed there first. Those are all mechanized means. Every one of those is a mechanized mean. You're using some sort of tool to destroy it. Dropping is not the same. It is not listed in that category. Mr. Cox went on to opine that transite is strong enough that it should not even break when it hits the ground. I talked to Mr. Burns about it. He agreed again today. I asked him, using the examples given from the EPA, actually, this is Mr. Cox. I asked him, do you believe that dropping transite from a ladder has the same force of impact as hitting it with a wrecking ball, imploding it, or running it through with the bulldozer, backhoe, or any other heavy machinery? He said no. Totally different category, mechanical versus non-mechanical. Mr. Burns asked the same question. He agreed that that is a totally different category of force than dropping a transite fragment from a ladder. Second alleged violation, adequately wet. Had a lot of discussion about this. Again, I find this important. This is Mr. Wolf's notice of inspection. Notice of inspection is the document he creates on the day to contemporaneously record what he saw that day. Ms. Splittick made the point that this is pretty full. Not shown in this cut is at the bottom, it says page 1 of 1. You can use as many of these as you want. Mr. Wolf agreed. He also agreed that it's important to contemporaneously record things because apparently it takes the division 2 years to issue a notice of alleged violation. It's important to document it that day, especially when we have a video where you can't see a thing. Nowhere in here is there any indication that Edge failed to adequately wet or use a sprayer on the material. Here's the language. Adequately wet the surface areas of non-friable ACM to prevent dust emissions throughout the removal process. Here we actually have a definition. It says adequately wet means sufficiently mixed or penetrated with amended water to prevent the release of particulates. If visible emissions are observed coming from an asbestos-containing material, then that material has not been adequately wetted. However, the absence of visible emissions is not sufficient evidence of being adequately wet. Not particularly helpful. You have testimony from Mr. Rodriguez, who was there on site, Edge's supervisor. They used the airless sprayer. They sprayed the material before they then used a hand bar to remove it. The material remained wet during the process. Those are two different things. Does Regulation 8 require that it remain wet or that it is continuously sprayed? Mr. Rodriguez says he wet it before they removed it and after they removed it. In the few seconds during the removal process, is it gonna dry such that it's no longer adequately wet? I asked Mr. Burns about his opinion that it should be sprayed at the point of contact to avoid breakage. He again today testified. That is not in Regulation 8 anywhere. That language does not exist. Mr. Cox was asked about this and he said he understood somebody suggesting that it should have been continuously wet during removal. This is the language that I quoted in my opening statement. He says it's not a thing. It's not a requirement. It's not a rule. It's never been a good practice. There are no materials where a guy is abating the material and another guy is spraying the back of it with a hose. Imagine that in an elevated position, you got one guy pulling it off and you got another guy hitting him with amended water. That is not an industry standard. The third allegation on the Leadville project is that Edge failed to carefully remove the asbestos cement siding, including dropping it to the ground from an elevated height in violation of Regulation 8. This allegation is that Edge violated 3.S.4.c, remove the material carefully with minimal breakage and disturbance. Again, carefully is not defined. Minimal breakage is not defined. Disturbance is not defined. But we do have this. Brought this up during Mr. Burns' testimony. It could not be more on point. Removal of asbestos from an elevated height. There is a specific section of Regulation 8 that addresses how to remove it from an elevated height. It is very clear. It is limiting the prohibition against dropping to friable ACM. Now, if I'm an asbestos abatement contractor and I'm trying to figure out what I'm allowed to do and what I'm not allowed to do, considering the broad language, it would seem reasonable that I look to other parts, especially one that is so specific as to govern how I'm removing from an elevated height. If it says you can't drop friable ACM, it would seem the opposite is true, that you can drop non-friable transite, cement mixed with asbestos abatement fibers from a ladder onto poly. Mr. Burns agreed with me today and again during his deposition. Is there anywhere in Regulation 8 that says you shall not drop non-friable ACM from a ladder? The answer is no. Mr. Whitcamp discussed this during his deposition. There's been some suggestion that you could use a scaffold. Scaffold would have to be set up on the ground, on uneven terrain, on dirt, on landscaping. Mr. Whitcamp testified that this is not a scaffold job. It would be unsafe. You would have to set up an elaborate infrastructure to remove transite panels around trusses on a deck, deconstruct it all, and then just move 20 yards down and set it up again. It's cost prohibitive and it's not necessary, and a ladder is perfectly safe. We've looked at this a lot. One thing I want to talk about, let's see if I can do this. One thing I want to make clear, there's been discussion that there are a few pieces that are not on the poly. I asked Mr. Wolf about this. Is there anything in Regulation 8 that says if pieces fell off the poly, that is a regulation violation? He agreed. No, there's nothing in the regulation that says the material has to remain on the poly. That is not something we're fighting about today. This is testimony from Mr. Rodriguez when asked about what he encountered that day. He was asked by counsel for the division, was it damaged before David started prying it off? Yes, ma'am. Yes, ma'am. That's why I had told Jeff Wolf, I say we're not really removing, we're just cleaning up, because we weren't removing whole sheets, we were cleaning up broken pieces. He was on the ground level. He's providing testimony under oath. He says, but if I would have seen pieces flying off the poly or breaking, I would have put a stop to that work. He was asked again, and I think you said it would not break if you just dropped it on poly. No, it wouldn't. And I thought I heard you say something that it was impossible, that it was possible it broke on poly, but did you actually see any cement tiles breaking on the poly? No, I didn't. It might break, pieces might break. I'm not saying it's unbreakable. It's just that you have to be dropping it from a higher, we weren't that high up. Mr. Cox was asked about minimal breakage as well. He says, and this was highlighted by Ms. Splitek, I just want to make sure we all understand what Mr. Cox is saying. He reviewed this entire file. He reviewed that photograph. He understands the term minimal breakage as required by Regulation 8. And his fundamental conclusion was, I do think this meets the regulation for minimal breakage. He also said, I'm not saying it will never break. It's pretty unlikely that it will break. There's a big difference in dropping it on concrete and dropping it on a drop cloth, like you said. But if it broke, I still think it would be minimal breakage. I asked Mr. Burns during his deposition and again today, could he tell me from looking at that photograph what came off the wall broken and what broke after it hit the poly, and he could not. Now, I told you this is one of those cases where we're going to have a factual determination for you to make. We have competing stories. Mr. Wolf said that it was shattering that day. Mr. Rodriguez testified under oath that it wasn't, that if he saw it, he would put a stop to it. I told you that you're gonna have your hands tied behind your back. The reason for that is apparently the division's records delete after 90 days. If it's on their servers, it deletes. The only way to save it is to upload it. Mr. Wolf said he uploaded what he felt was relevant. And so I couldn't understand when I was taking his deposition, we're talking about a major asbestos spill. Why weren't more videos taken? Why wasn't this documented like a crime scene? He said it was documented like a crime scene. The ones you are focusing on are a subset. There were lots of other photos taken. Aren't there only 9? That's all I have. There were lots of other photos taken. If they did not make it through the other issues that came about, the document retention, I can't affect that. There were more photos taken that day. You're talking about 1 or 2 or several more? Several more. They were destroyed. In the course of this case, I came across this. This is a stipulated exhibit. It's a document retentions policy. Asbestos enforcement records, which is what this is. Any documents associated with an enforcement proceeding, which is what this is, including photographs, are supposed to be retained for 15 years. They let them be deleted in 90 days. I asked Ms. Maniac about this. He said, it's my understanding that several photographs he took that day and others have been destroyed. Is that your understanding? It is possible they've been destroyed. Does that happen a lot? We typically keep what we need, but not necessarily everything. What you need to pursue an enforcement action. That would be correct. I'm not gonna go through her whole deposition. You guys have it in your notes or in your binders. I went back and forth through her, and at the end, her conclusion was, I asked her, so you're basically saying it's up to them to preserve their own evidence. Correct. Mr. Wolf said the same thing, that it's up to the licensee to preserve their own evidence. Now, I just have to ask, I've never understood that. How is that fair? These are state employees paid with state tax dollars. These inspectors are professionals at obtaining, compiling evidence. They know the regulation, they know what's important. They've obtained evidence and they allow some of it to be destroyed. How is that fair to my client? They're essentially saying that Michael Rodriguez, who was in asbestos abatement contract, should be out there performing the same level of investigation, should be preserving the same evidence. You have to decide if that's fair. You have to decide that a division has met its burden based on that evidence alone. That comports with the fundamental notions of due process. Pine Creek. First allegation on Pine Creek is that Edge failed to program and maintain negative air pressure. I think there's been a lot of evidence of this. There are holes in the roof of the third floor caused by a fire. Wind and rain were entering. That's testimony from Mr. Moda. Again, Mr. Moda, it had been raining a lot. It was real bad. The weather wasn't helping. I'm not going to perform a meteorological forensic analysis, but we did gather some weather data. This is the wind readings from 6 p.m. the night before the inspection to 6 a.m. the morning of, showing a spike in wind that day. It was exposed. And unfortunately, that is not a common event. This is testimony from Mr. Burns. He agreed again today, losing pressure and containment is not uncommon. We have critical barriers that fail for one reason or another. This is from Mr. McGowan. Same thing at the bottom. Are there circumstances where containments fail, or are there issues where critical barriers could fail? Yes. Because it happens. Again, Mr. McGowan, because it happens sometimes, right? It could, yeah. Especially if the containment is exposed to the elements, it could happen that it fails. It could. That's something that happens. Yes, Mr. Burns. Is containment losing pressure an automatic violation of Regulation 8? No, it is not. We went through this testimony again today. He said it only becomes a violation if once it loses pressure, the abatement contractor continues to remove asbestos-containing material. No evidence that occurred in this case. So we're doing a deep dive into manometers and strip chart readers and their equivalents. Mr. Burns agreed that the only thing that Regulation 8 requires is that it be recorded, data be recorded. There is no definition of the equivalent of a strip chart reader. So Edge uses a manometer. This is the manometer that Edge had on site that day. It has a USB key. Mr. Moda said he doesn't know how to use it. That's not necessarily a violation of Regulation 8. If we have to get data, it's stored in here forever. You take it back to the office, we can download years of data and print it out. There is a printer cable right there. You could hook a printer to it right there. There's a paper printer on the left. You could put a roll of paper in there and print it right there. It's being recorded, it's being maintained as required by Regulation 8. Mr. Burns agrees, there is no requirement at the end of every day to print it out and save it. Mr. Burns agrees, if the only thing he saw was that there was no paper in the manometer that day, he would not recommend enforcement on that basis alone. There seems to be no dispute that this manometer was stolen. In these joint exhibits, you have the police report, you have the insurance claim. It was stolen that night. I don't think they're challenging that. Nobody's suggesting that Edge submitted a false report to the police, which would be a crime, or that they committed insurance fraud by seeking the insurance for something that wasn't stolen. It's just unfortunately a situation like this where you have a vacant building with multiple break-ins, the data that we were maintaining got stolen. I don't think anyone suggested that it should be a violation of Regulation 8 if somebody steals our data that we were maintaining. Mr. Moda talked about the building losing power. Mr. Burns agreed, and I went through this with him again today, and I won't again now, that manometers, if their battery fails, could reset. Agreed. It's not instant violation. You're not looking for a gotcha moment. It's not fair. If the manometer reset because of a power loss, which no one seems to dispute, that should be considered a violation of Regulation 8. The next allegation is the clean room. We talked about this a lot. First thing that we need to make clear, this is from Mr. McGowan. The clean room doesn't have to be big enough for every person to be in there at the same time. It's one person and the clothes and equipment of the workers. This is from Mr. Moda, who testified. And again, I'll go through this rather quickly because I think Mr. Burns and Mr. McGowan agreed that Mr. Moda used that clean room since he's been in Colorado from 2010 without problem. Mr. McGowan testified that it was permissible before 2021. Nobody ever considered that a violation of Regulation 8. This is from Mr. Burns. For 20 years, it was not a violation. From Mr. McGowan, you could understand how people might not have gotten word that they reversed a policy that's 20 years old and would still be using it. At the top, would you recommend enforcement on that by itself? He answered no. From Mr. Burns, same thing. I asked him the exact same question. Could you understand how there might be an adjustment period if they've been using the same thing for 20 years, a couple months later, they tell them that it's no longer permissible? He would agree. And again, Mr. Burns said he would not recommend enforcement on that basis alone. Final allegation on the Pine Creek project is the removal of critical barriers. Again, this is where we have a factual dispute. This is from the compliance determination letter. This is the factual finding. The containment components from previous phases were still present in areas where abatement had taken place and had not been bagged for disposal after completion. They believe that the containments they saw were from, or the poly they saw were from prior containments. Here's a few examples. I mean, on this one on the right, you can see light coming through. You can see penetrations being covered. I don't have this in my slideshow, but they focus heavily on the poly that was up in the eaves where there are vents where wind could easily come through. You heard Mr. Burns acknowledge that wind could certainly affect a manometer. With testimony from Mr. Moda that the purpose of this poly was to address wind intrusion, water intrusion. Mr. Moda gave a very lengthy explanation about how wind can affect a manometer. And again, Mr. Burns agreed. I mean, just from sheer efficiency standpoint, every time that alarm goes off, everybody has to stop what they're doing. It is more efficient for them to seal the holes with poly than to have to figure out why they lost pressure, why the manometer's beeping at. Mr. Moda also gave testimony about the toilets and the sewage. And from the odor of rotting food and from refrigerators. I think he says down here that people left food in the refrigerators, and when they moved them, it would leak juice. This is testimony from Mr. Whitcamp, who had visited the site numerous times and also provided firsthand testimony that the purpose of the containment was to mitigate odors and mitigate weather. This is the testimony that I went through with Mr. Burns on redirect, or after I think a commissioner question. I asked, do you have any firsthand knowledge about why the containments that the division claims are in place were put there in the first place? He said, I could only speculate. I asked Mr. McGowan, did he know? Based on the testimony he provided earlier, did you know what the original purpose of that containment was, whether it's old or new? And he said, he admitted, I do not know. So again, that's a factual determination you'll have to make. We, both the inspector and Mr. Burns, agree that they're basically speculating. It's their burden, they're speculating. And we have two people under oath testifying for sure, Mr. Moda and Mr. Whitcamp, the purpose of that containment or that poly. I want to finish talking about the penalties. I went through this, Ms. Foley. I don't understand this. Looking at Leadville, we have separate penalties for 3S2 and 3S4. I'm not going to pull it up again, but I think everyone here would agree that 3S2 addresses asbestos-containing products that contain cement. And it says that in order to remove it, you have to comply with 3S4. There's no way to violate 3S2 without violating 3S4. These are duplicative in their entirety. They're charging $5,000 for violating one section that incorporates the other three sections. So we're charging $5,000 and $4,000 for the same exact thing. And then they double it based on willfulness. I asked Ms. Foley, what does that mean by willfulness? That they knew the rules and they violated them. By dropping transite that is not prohibited in Regulation 8, they add another $9,000. And then they increase that penalty by 50% for the size of the project. Again, this is the point I was trying to make. They didn't multiply $9,000 by 50%. They multiplied the new doubled number by 50% for the size of the project, which was removing a few transite panels around decking. Yes, there's a massive spill, but I just didn't cause that spill. There's 9 buildings. We're talking about removing transite around the decks and the exterior of the building. We're not removing transite from all 9 buildings. They added another 50% and another $9,000 for proximity to the public instead of applying that to the 9,000. So then that gets us to 36. They then admit that it's potentially duplicative, but only section 3.S.4.B. Now, I wasn't trying to be difficult with Ms. Foley. I was trying to understand how they came up with these numbers. Where did they come from in the first place? Where do these factors come from? Because no documents have been produced to us to understand how they do this, other than this is what they always do. So Ms. Splitek appropriately cited the statute that contains several factors. I went through them with Ms. Foley. Compliance history, lack of good faith, whether there was whether the violator previously committed the same violation, duration of the violation, economic benefit, threat to public health, malfeasance, legal and factual theories were frivolous, whether it impacted a disproportionately impacted community. Half of them, or 3/4 of them, she said, they don't use those at all. That's the statute. Those are the statutory factors. So the problem we have is it seems they just kind of use their own internal factors. They won't share with us. Similar to how they use their interpretations of Regulation 8. They don't necessarily comport with the language. That is our fundamental issue with all of this. It's our position that EDGE comply with Regulation 8. We would ask that you award no penalties. We would ask that you reject all of these violations and find that the violations are without merit. Thank you.
Right. Division has one more opportunity to cover anything on Edges Cross.
We take just 1 minute to confer.
Sure.
Recognize that it's almost 4 and we have a hard stop at 5, so I'm only gonna take a couple minutes.
You have an hour, come on.
I have 10 minutes left, not quite 10 minutes left, but I'm not gonna go for 10 minutes. I think as the final point that we wanna leave you all with is that EDGE operates in an industry where it is closely regulated. There are a lot of rules. There's a lot of complexity with how this is done. There's a lot of intricacy with how this is done. And EDGE knows that, and they are highly trained. They take their workers take training every single year. They are paid to do this job, to do these kinds of jobs, and to do them well because of the implications on human health and safety. And as you see from that picture, the job was not done correctly that day. And there were significant risks to human health that were posed by how they did this job. They're also charged with knowing what the regulations require. And when regulatory updates happen, they're charged with knowing what those were. EDGE basically alleges that Reg 8 is just too vague to comply with, that they just can't possibly know how to comply with Regulation 8. You all understand better than anyone, again, how rules are developed and how they're written. You do that. Rules have to be written broadly to cover all potential situations, but they also have to be specific enough to put the people who have to comply with them on notice about what is required. And your rules do exactly that. We've walked you through how your rules do that. So in the end, these cases show a pattern of disregard for the rules that apply here, the rules that you have promulgated, and the rules that protect people from the dangers of asbestos. And so we ask you to uphold the division's compliance determinations. Thank you.
Okay, next up, we will have questions from commissioners to council. You're welcome to direct your questions to either of the parties, and the other party will have an opportunity to respond to that question as well. So I will open that up to commissioners.
This is questions to council.
Council, correct.
Can I ask a clarifying question? If there's a question and we need a witness to help us answer that, are we allowed to do that, or how do you want to handle that?
It's still open, we can.
I'm not, the reason I'm asking is I'm not sure all our witnesses are still, I'd have to check.
Excused, I think, the record is.
That's not there. Yeah, I think, no, we won't be calling up any witnesses, but we do have the reference to depositions as needed, and of course, everything in the record thus far. I think the intent for questions to council are more, legal questions, interpretation questions, verification, that's somewhat open-ended. I know that we as commissioners like to try and get as much information as we can to prepare ourselves for deliberations and decision-making. So we'll leave that there, see how it goes, and I will open it up to questions. Mr. Thomas.
This is a question for the division attorneys. So in Ms. Foley's revised or new exhibit 33, she does mention the recalculation. And so would you be in agreement that the 30,000 is appropriate, or is it the original amount of 36,000?
We would be in agreement that the 30,000 is appropriate in this case.
You have a response to that question as well, or I'm just gonna give the opportunity after the question.
Yeah, I mean, my only response would be that it was reduced because it was duplicative. All of it was duplicative. So we would think 30 is still considerably too high for the reasons I expressed during closing, so I won't restate those.
Commissioner Reader.
Yes, thank you. A question for the division. I'm not familiar enough with how things go from inspection to enforcement, but I want to ask about the observation that nothing was said in Jeff Wolf's inspection report about the lack of an air sprayer. And I'm wondering how something that is one of the major, one of the three major points doesn't appear in the initial inspection report, and how that works from a process perspective, or if I'm misunderstanding the inspection report. Thank you.
I can answer that. As you saw, that inspection report was, every inch of that space was filled in by Mr. Wolf. So I think he did that at the site. He was trying to write out everything as he was still there. So there's that aspect to it. I think there's also, if you look at, and I can pull it up, in Mr. Rodriguez's deposition testimony, or his testimony where he says that Jeff Wolf asked him about the spraying, and that they had a conversation on site about the spraying. And so that indicates and supports that this was something that Inspector Wolf had noted that he discussed with Mr. Rodriguez, and that it had happened. So I think it was, and I don't want to use the word oversight, but in filling out that sheet, which was filled to the brim, I think it just didn't end up in that sheet. But there is evidence in the record that was discussed on site.
Okay, thank you.
I'll quickly restate the first part of what I said during closing is that sheet at the bottom says it's 1 of 1. It didn't show up on my slide, but if you look at the document itself, it was 1 of 1. And I talked to Mr. Wolf about it. They're allowed to use as many pages as necessary. And if they had a conversation about it during the inspection and it didn't make it into the notice of inspection, to me, that suggests it actually mollified any of his concerns.
Further questions? Commissioner Thomas.
I think this one's for Edge's attorney, and in looking through some of the spill delineation report, that was 4 or 5 days after Mr. Wolf's inspection. There is a whole lot of plastic covering, which it looks like wood on the decks. I'm just curious, was that plastic wasn't a result of an order by the division to Edge? Is that correct?
I'm happy to answer that. Thank you. Yes, that plastic, it was not, the division declared it a major asbestos spill. They didn't necessarily order Edge to do it. They ordered the owner to contain the spill by putting plastic poly down everywhere. And if you look at some of those photographs, you're going to see poly everywhere. Edge did do that. They were not ordered to do so. Edge did do that. They went and contained the spill. They sent their crew up there. They put poly down on everything multiple times. It's Leadville. The wind blew it. They kept sending crews back up to reinforce it throughout the winter for a very long time.
Okay, thank you.
I have a question for the division in regard to the penalty amount and then the aggregating factors and kind of how they were calculated. Mr. Cross pointed out that, the principal, the initial violation amount was doubled, right? So that's based on the principal, but that every other 50% increment was then added to the already aggravated amount. Is that the common practice of how that's calculated?
Thank you for the question. Yes, that is the common practice. That is how the division calculates penalties in each of these cases. And that is how aggravating factors are accounted for in the penalty calculation.
How does the division determine which to apply first? You know, if you apply the 50% first, and then you applied 200%, the 2x on that 50%, wouldn't that be a lower number? I mean, is it trying to take the most amount first and stack on from there? I'm trying to understand how that's decided.
These are getting into questions that I don't fully understand, and Ms. Foley is not here at this time. So as I understand it, and based on Ms. Foley's written testimony, it is increased by 100% for willfulness at the initial stage. So that is the factor that increases it by 100%, and then the other aggravating factors are then applied once that has been doubled for willfulness. That is just how they do it. I don't have any other answers than that.
That's our concern, obviously, is that's just how they do it. It's not based on anything. It would seem that if you're going to add percentage increases, you would add it to the principal amount. You wouldn't increase it and then add percentage increases to the compounded amount. It gets pretty high pretty quick if you start to.
And then I'm going to follow up on that question of division. Should we find different amounts? Should we find different levels of severity based on the claims? How, without having the formula or the table, how are we supposed to determine the appropriate amount of either aggravating or mitigating factors and what percentages to apply, et cetera?
And I think the statute sets out what the factors are to consider. I will submit to you that there's a lot of judgment in there. There's a lot of discretion in there. And so I would say you look at that statute and you can apply those factors how you see fit. The division provided the way that they did it and the way that they do it in other similar cases. Ms. Foley testified that that's a large part of her job, is knowing, what the penalties ranges are, applying those fairly across all the different sites that they're seeing and coming up with something that they think is fair. Something that she does day in and day out. I would submit that you can use that as a starting point, and if you think there's reason to go lower or higher, I think you can do that, and that's within your discretion if you're following the statutory factors.
Anything additional?
I would just recommend that, based on our argument, you would start with a principal amount of either violation of S2 or S4, and then apply the factors from the statute to that.
Can I address the S2 and S4? I think I tried to make the point. If you look closely at 3S2, that is about friability. It's specifically about not rendering a non-friable material friable. So that is the potential duplicativeness that Ms. Foley had noted, was that 3S2, which is what EDGE was cited for in the compliance determination letter, is about friability, and 3S4B is also about friability. So that is the duplicative nature of those two violations, not that 3S2 references 3S4.
I'll just restate what I said during closing. 3S2 incorporates all of 3S4. It says you have to remove it. You have to remove asbestos containing material. Sorry, thank you. You have to remove cement containing asbestos containing removal in accordance with 3S4, which is the provision that dictates how you remove non-friable material. Fully, not just the don't render it friable part.
And that was going to be a question I had, so that's why I want to continue, but let's take the questions that the commissioners have. I appreciate both responses. Commissioner Slusky?
Just to jump on that a little bit, this is to EDGE. You, early on in the process, early on, you all had an opportunity to negotiate the settlement. And I'd like you to speak to why you didn't, because I think the division was.
Hold on, Commissioner Slusky.
Oh, no.
Yeah, I think based on some of the previous objections that have been sustained and then kind of the subsequent redactions that have entered, I'm inclined to not allow that question to go forward. Does council have any comments on that? Let division start.
I think we have to be consistent. We've said settlement discussions are not going to be discussed.
We recognize that ruling. We defer to Edge if they want to discuss that or not.
Sure. Yeah, John, we're gonna.
Well, I could try something else if you want.
You're welcome to.
See if I can get a two for here.
I like that question.
And this would be for both the division and Edge as best you can, or maybe you don't want to. I would like to know how many hours each side has spent over the course of the last year or two, whatever it is. And if you could estimate how much you've spent defending your clients. That would be more really for the division. I'll give you a buy on that.
The reminder for the commissioners that, we're trying to answer questions or ask questions that will help us get to determinations of violations.
This would be a determination of penalty.
How?
No, how?
Don't answer that.
Yeah. I'm gonna confirm. Yeah, I think that the penalties we're gonna calculate based on the violation itself, and I fail to see how much they've spent up to this point is relevant to reaching that conclusion. So I'm gonna not allow that question to go.
Well, I'll just say I disagree.
Okay. Noted. Other commissioner questions? Commissioner Reader.
Yes, I have one more follow-up around the penalty calculation. I understand that 3S 2 is around being from non-friable to friable. But 4SB is also around otherwise damaging the materials to render it friable. So isn't 4SB the way you violate, I'm sorry, 4B the way you violate 3.2? If that question made sense.
Yes.
Sorry, I got
Yes. That question did make sense. So what happened in the course of this case, there was a notice of alleged violation that preceded the compliance determination letter. The notice of alleged violation is what, there was a conference about that, and Edge had the opportunity to submit evidence regarding that NOAV. The NOAV did have 4 violations. It had a violation of 3S2 and 3S4A, 4B, and 4C. And then in the process of issuing the final compliance determination letter, the violation for 3S4B was removed. And so that the violation for friability ended up being 3S4. Did I say that right?
3S2.
3S2, sorry. 3S2.
That's how we got to 30,000 instead of 36,000 then.
Yes, because the 36,000 was based on those 4 violations. And then when it became 3, when Ms. Foley looked at that, she said, I think it actually probably could have been 30.
Okay.
So I think our position would be you could have one or the other, but they went with one.
Okay, thank you. That's helpful.
Mr. Cross.
Yes, thank you. I'll be brief. I mean, I would encourage the commission to look at the language of 3S2 and the language of 3S4, and I'll just read it very quickly. The first sentence, this 3S2 is not limited to non-friable. The first sentence says asbestos cement roofing shingles, siding, or other asbestos cement products that are non-friable and will remain non-friable during removal are subject to the requirements of section 3E, notifications. That simply means that you don't need a containment. The next sentence is the important one. The asbestos cement roofing shingles, siding, or other asbestos cement products must be removed in accordance with section 3S4. It incorporates all 3 subsections. It is wholly duplicative. The first fine for 3S2 is duplicative of the combination of the next 3 fines, not just 3S4B.
And in response to that, I would say the next sentence after that, which council didn't read, says if the asbestos roofing shingles, siding, or other asbestos cement products become friable during removal, then there are other requirements that apply. And so what Edge was actually cited for was it became friable, and then they didn't do the things that they needed to do to handle that material once it became friable. So there's a little nuance there. But I think the fundamental point is that 3S2, and especially the violation that they were cited for, is really about friability.
Could Edge have violated 3S2 without have violating 3S4B?
I think you could, I think the violation would be technically of both. They were not.
Well,
Sure, but the ultimate violation that was in the compliance determination letter that we're here to defend today is the violation of 3S2.
Mr. Cross.
Real quick to answer that question, yes, if you violate 3S4A, you violated 3S2. If you violate 3S4C, you violate 3S2.
Other commissioner questions? Commissioner Thomas.
So in the presentation that we've seen about the broken, dropped siding, that is a very zoomed in. It looks like it's 5-6 feet across. And I'm looking through the rest of these pictures and I'm trying to figure out, where did the other pictures that the inspector took reside?
Can I go first?
Can I ask a clarifying question? You can
Let
go
me
for it, and
go
I'll ask a
first.
clarifying
They've been
question.
It's for both of you.
I'm sorry, but if,
Pick one to ask the question, Commissioner
Okay,
Thomas.
the division can go
And
first.
hold on, and timeout. Yeah, Commissioner Thomas, as you frame your question, frame it in terms of if they can point to evidence that's been
Yeah.
presented in the record to help answer your question.
Yeah, and sorry, that was a long-winded way of saying, where in the exhibits here are the inspector's complete set of pictures?
you're talking about for the Leadville site,
Or Leadville by Mr. Wolf?
yes, that would be division exhibit, I believe it's division exhibit 8. I'm sorry, division exhibit 10. Let me just double check that. Yes, division exhibit 10.
Thank you.
And I'll respond to that. That's the 9 photos. Division exhibit 10 is the 9 photos. All the rest have been destroyed. They have a policy that they auto delete 90 days. You can.
It's already come out, Mr. Cross. That
I was just gonna point into evidence. I went through excerpts in my closing, but if you wanted to review Mr. Wolf's testimony and Ms. Maniak's testimony, I went into it with them in greater detail, and they explain, Mr. Wolf particularly explains that there's several more, and I think there's another section of the deposition that said, this is an example of how I normally do it. And it was like 80 photographs from a year later.
Ms. Splitting.
A lot of this has already been fully briefed and decided by the commission on the motion for spoliation, which was denied by the commission.
Okay, we're gonna move on now. Any other questions, commissioners?
I'm done. Doing that.
Okay. I don't see Commissioner Reader's hand up, so I think we are done with commissioner questions. I think at this point, we are now ready to close the record. So I will start with entertain a motion to close the record.
Moved.
Okay, it's a motion from Commissioner Slutsky, a second from Commissioner Milford. The record is closed. At this point, I'm going to thank all the parties and witnesses who have been here today for all the work. And again, working through a difficult presentation, a very tight timeline, and being very respectful of all that. So thank y'all very much. Do we have a vote to close the record? Make sure we're good. Yes. Okay.
Yes.
Seeing all eyes. Okay. In that case, this concludes the hearing portion of the proceeding, and the record is now closed. It is 4:22 on October 16, 2025. So we're at 4:20. We've got about 40 minutes. We choose to endeavor. I know that at this point, we typically consider an executive session to kind of clean up any remaining questions we might have prior to deliberations. I don't anticipate us being able to get through a thorough executive session and deliberations before 5 o'clock today. I wanted to see if anybody had any opinions on doing an executive session this evening in the next 40 minutes, or saving that for tomorrow morning and continuing deliberations kind of in all one fell swoop tomorrow morning. Commissioner Miller.
So I would like to request that we make a session to get some advice on procedural matters.
Okay. We ready to do that now? Okay. Well, I think we can take the session. We have a motion to enter into executive session. Got a second from Commissioner Slutsky. All those in favor?
Aye.
Okay, excellent.
Just for the record, clarifying that it's a motion to enter executive session to confer with counsel under Colorado statute.
Can you turn on your mic, man?
Oh. That was a motion to enter. Council under Colorado revised statute section 24-6-402 sub 3 sub A sub 2 for the purpose of addressing legal questions and options, receiving legal advice on specific legal questions and issues relating to the consolidated hearing matter as environmental excellence.
We can't hear you. I'm sorry.
Would you like to hear the entire motion?
It needs to be recorded, I would think.
Oh, is this for recording and amplification? Okay.
How's this?
Yeah.
Okay.
Much better.
Clarifying for the record that there was a motion to move into executive session to confer with counsel under Colorado revised statute section 24-6-402 sub 3 sub A sub 2 for the purpose of addressing legal questions and options, receiving legal advice on specific legal questions and issues related to the consolidated hearing matter, Edge Environmental LLC versus Air Pollution Control Division. And there was a motion second and all in favor unanimously.
Correct. Motion by Commissioner Milford, second by Commissioner Slutsky, unanimous vote. And so we are ready to do that. And to be clear, for the parties, you are excused. Of course, you're welcome to stick around, and I imagine you will. But we are going to enter into an executive session. That now.
We're gonna do about Curtis.
We'll need a room for.
We need lunch.
Sounds
I
good.
have a special link. I'm good. I've been
Sorry,
told.
just to clarify, we all are going to open space.